December 4th, 2024. Brian Thompson, the CEO of United Healthcare, is shot dead from behind on a Manhattan sidewalk. 5 days later, a man at a McDonald's in Altuna, Pennsylvania, is spotted by an employee and arrested. His name is Luigi Magione. The man, prosecutors say, pulled the trigger. In his backpack, a 9mm pistol, a silencer, and a red notebook. Today, we aren't arguing whether or not he did it. We are reading the order that decides what a jury will ever see at trial. On May 18th, Justice Gregory Carro had some answers. Some of that evidence stays in, some of it is gone. This is Defense Diaries. Let's dig in. Welcome, beautiful humans. Happy Tuesday. I am Bob Murdaugh. This is Defense Diaries, and as always, I am joined by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all.
So what's up, girl?
I mean, we got Luigi. I can't say it like you know, but we're going to start with the Luigi Mangione suppression decision out of Manhattan.
Oh, you mean Luigi Magione?
Yeah, yes, I do. The judge is ruling on what evidence and what statements can come into this case. So we're going to read every page of it together. We're going to stop at breaks and break it down along the way. And we've got a very short little piece of the body cam footage. It doesn't really tell us much, but we'll watch it.
Yeah, for sure. And before we get started, I've got to get better at this. Just do me a favor. Just drop the chat down, hit the subscribe button, hit that bell for notifications, and make sure you subscribe. And if you really love us, become a member. All right. So let's begin.
Before a New York judge could decide whether the evidence against Luigi Magione comes in, he had to decide the question of what, most people never really think about. The arrest happened in Pennsylvania. The trial is in New York. Whose rules apply? The answer decides everything that comes after. So before we open that door, let's set up what Mangione's team actually asked for. Bob and I read the defense filings, and it's some details you guys need. So this was a motion to suppress. It had two halves. One, the physical evidence from the backpack. Two, everything pulled out of the backpack and off his person. So not two. So it's not only the backpack, it's also everything off that came off of his person. And then two, the statements. Everything he had to say to law enforcement from the McDonald's through Pennsylvania jail.
Yeah, and typically the way that you're going to handle that in New York, the test is a hearing. So two of them there. And there's a map hearing, which is the search and the seizure piece of it. And that's named after Map v. Ohio, a watershed Supreme Court case, and a Huntley hearing. And that relates to the statements piece, whether what he said was voluntary and whether Miranda had been honored. So, Carro, should we give a spoiler here or should we wait?
I don't know, but Judge Carro made decisions.
The Carro held both hearings. 17 witnesses testified back in December. So this order took a hot minute, right? We're in May. Both sides briefed it, and this order gives us our answers as to what the court held. So,
and there's one fight buried in here that sounds like a technicality. And as my husband always says, he hates when people think of it as a technicality, but it's actually the foundation of the whole ruling. So both sides fought over which state's law applies and the judge and which the judge should use. So Pennsylvania is where it happened. New York is where the case is being tried.
Yeah. And hold that thought, because the judge frankly answers it early and the answers change everything after it. So let's jump into the doc, and then we'll stop along the way. We'll talk about things as they come, and we'll kind of roll from there. Yeah.
Yep.
All right. So, and we originally were going to look at the body cam. I think we ruled against. It's only a couple of minutes long, but it doesn't
No,
even
I
go
I
further enough.
decided we'd play just the one part. It's very short. It doesn't
Oh,
really have it doesn't have anything to do with weren't able to get the part that's actually referenced in this ruling, but it's something for the people to see.
all right. Tracy is backstage, which
Tells you we might
means
have an
maybe we're
issue.
screwing something up.
Right. I looked, we are live. It
All right,
is.
we're live. That's good. We don't have any frantic text messages from her.
So maybe she's just
So,
back there to help out in case
all
we need
right.
it.
God bless.
Thanks, Trace.
We love you, Tracy. I always get when mom comes backstage, it usually means we're in trouble for something. So, all right, let's get rolling with it. I'll read first. Yes.
Sounds good.
Okay. So this is the decision in order. Okay, and it's from the Supreme Court of the State of New York. New York County, Part 32, People of the State of New York versus Luigi Mangione. So, and Justice Gregory Carro has written the opinion. So on December 4th of 2024, Brian Thompson, the CEO of United Healthcare, was shot to death outside the Hilton Hotel in Midtown Manhattan. On December 9th of 2024, the defendant was arrested at a McDonald's in Altuna, Pennsylvania, after he was recognized by employees who had seen media coverage. A 9mm gun was recovered from the defendant's backpack, as well as among other items, a loaded magazine, a silencer, cash, a passport, and a notebook. Defendant has moved to suppress the evidence recovered, as well as statements made to law enforcement officers during and after his arrest. On September 16th of 2025, this court ordered Mapp and Huntley hearings, and those hearings were held in December of 2025, during which the court heard testimony from 17 witnesses. Both parties filed written submissions for the reasons stated below. The motion is granted in part and denied in part. All right, so the findings of fact. Take it away, babe.
Okay. The arrest at McDonald's. The facts relevant to the hearing are largely undisputed. Several officers from Altoona Police Department testified, and their body-worn camera footage was introduced into evidence. On December 9th, 2024, the defendant bought food at the Altoona McDonald's and sat in a back area to eat. A McDonald's employee called 911 to report that the defendant resembled the suspect in the Thompson killing. Footnote 1 says photographs of the suspect had circulated in the media. Altoona police officers Joseph Detweiler and Tyler Fry responded to the scene at about 9:30. Detweiler was a 14-year veteran of the police department who was familiar with the videos and the news related to the Thompson killing, while Fry was a rookie officer who knew very little about the shooting.
Ooh, green machine. Little green. Green under the gills, that one.
Yep. Detweiler and Fry saw the defendant sitting at the back table near the bathrooms with a backpack sitting on the floor near his feet and a laptop in front of him. When the defendant pulled down his face mask upon Detweiler's request, Detweiler immediately recognized the defendant as the New York City shooter. When asked for his name, the defendant responded that it was Mark Rosario. And when asked for identification, the defendant produced a New Jersey driver's license in that name. While Fry went to verify the license in the NCIC database, Detweiler asked the defendant questions about where he was from and whether he had been to New York recently. Detweiler then had the defendant stand up and frisked him, but did not find any weapons or contraband. I'm just going to pause there real quick because, those kind of searches you can get away with that if you're, looking for weapons or contraband. So he did that initially and there was nothing. And I'm sure that comes into play as we continue on. So Fry then stood next to the defendant while Detweiler went outside to call Lieutenant Tom Hanley at the station, telling him that he was about 100% sure
Hundo.
that the defendant was the New York City shooter and asking him to come to McDonald's. Again, I'm just going to pause there to say these kind of facts that the judge is including, don't scroll up yet, babe. These kind of facts that the judge is including, for example, that the officer stayed next to stayed next to the defendant all deals with whether he was seized, whether he was free to leave. So those facts are all important, and are likely going to come back here. So moving on, Lieutenant Hanley then headed for the McDonald's along with Sergeant John Burns, Corporal Garrett Trent, and Officer Samuel McCoy. Detweiler returned to the table, again asking the defendant if he was from New Jersey, what he was doing in Altoona, and whether he had been to New York recently. Defendant said he had not. He also stated that he was homeless. Detweiler told the defendant that they were, quote, just trying to confirm his identity and that he would be able to leave, although Detweiler conceded that he had no intention of letting the defendant leave. In response to further questions, the defendant said that he was from the DMV area. And footnote 2 reads
that is the District of Columbia, Maryland, Virginia area.
Okay. While Lieutenant Hanley was on his way to McDonald's, he attempted to reach New York City Police Department by calling 911 and alerting the operator that the Altuna police may have located the New York City shooter. Hanley was still on the phone with 911 as he reached the McDonald's, took the Rosario license from Detweiler, and relayed information from it to the 911 operator. Meanwhile, Detweiler...
Meanwhile, what you did there.
Yes.
Yeah.
Meanwhile, I did it again. Wow.
Love it.
Meanwhile, Detweiler moved the backpack that had been near the defendant's feet out of the way and out of defendant's reach.
Pause briefly. So I just want to go back up to the paragraph before and point out that when the judge is writing little things of great import that he's kind of plugging in, it kind of gives you a vibe of where he's going on the front end. When he talks about, because when the judge is writing the opinion, they're gonna put in what they think is relevant. So when he puts in a little fact like he says, and that he would then be able to leave, although Detweiler conceded that he had no intention of letting the defendant leave. That obviously is going to become a very major part of the analysis as we move forward. So while we're reading through the factual scenario, kind of look for little terms of art like that are relevant to the issue at hand as we move forward.
And I'll just let people know why it's relevant, babe.
Oh, you're going to jump ahead?
No, but just to let them know why you focused on that specifically, because what his intentions are not relevant, but it's what the defendant understood. So they always do that. Just, you're free to leave, and you're about to be free to leave after we confirm your identity here. So that's all I'll say, and we'll wait for the analysis. So moving back to the body, and that's equally, sorry, that point that Bob made goes equal to, I kind of changed my voice when I read how he moved the backpack out of his reach. So we'll see that come up as well. As Sergeant Burns and Corporal Trent arrived, Burns asked Detweiler if the defendant had been frisked, and Detweiler responded that he had. Okay. About a minute later, officers McCoy and Luke Yeager also arrived at the McDonald's and went toward the back where the defendant was seating. Another officer, Corporal Brian Miller, also arrived at about the same time and went towards the back of McDonald's. Also, the judge is listing all of these officers for a reason we'll see as it develops as well. But the more officers, the less likely you are to be able to leave. Detweiler asked McCoy to stand next to the defendant at about 9:42 a.m. while Detweiler and Hanley spoke outside. Fry, McCoy, and Yeager continued to stand next to the defendant. Hanley testified that he considered the defendant detained at this point. While speaking outside, Detweiler repeated to Hanley that the defendant was 100% the person wanted in New York City. Burns and Trent joined them outside, where they pulled up photos of the suspect on their phones. Inside, McCoy asked the defendant if the backpack and laptop belonged to him, and he responded that they did. So while he's detained, they asked him some questions. Hint, hint. McCoy moved them to a table about 9 feet away from the defendant. Moved away. He can reach it. It's not a danger. 2 more officers, Christy Wasser and Stephen Fox, entered the back of McDonald's at about this time. Hanley called the turnkey officer at headquarters and asked him to run the Mark Rosario license through the NCIC system. No record was found. Hanley told Detweiler to give the defendant
You okay there, Bubs?
I remember somebody complaining that I make those sounds in the phone. I'm trying to keep it clean for the next, whatever we're going to do next with this, but sorry. Okay. So to give the defendant false ID warnings required by Pennsylvania law. Detweiler then told the defendant he would be arrested for, quote, false ID if he gave the police a false name. And he asked the defendant if his name was actually Mark Rosario, to which the defendant responded, no, sir. Detweiler then asked for his actual name and date of birth, which the defendant provided. Defendant also acknowledged having a fake ID. And footnote 3 reads, asked by Fox why he had lied, the defendant replied, clearly I shouldn't have. Asked again by Fry why he had done so. The defendant replied, that was the ID I had in my wallet. I had a fake ID. Returning to the body. At about 9:48 a.m., Corporal Trent directed Fox to read defendant Miranda warnings, and Fox did so. And you'll see the judge isn't just putting this time in for fun. This all has legal significance. When Fox asked the defendant if he wished to speak to them, he shook his head, also stating, no, I don't think.
I'm good.
And he gets cut off there. And Fox told the defendant that he was not in custody at this point. Fox continued to ask the defendant why he had a fake ID, and the defendant responded he was going to, quote, remain silent. Fox ordered the defendant to stand and frisked him again. The defendant volunteered that he was carrying a jar of peanut butter. When Fox asked if he had any weapons, the defendant first said no, but then he stated he had a pocket knife. Sergeant Burns then relayed an instruction to Fox to handcuff the defendant, and he did so. After Fox retrieved the knife, he added it to the table where the backpack and laptop had been placed. Hanley reached out to the Blair County District Attorney's Office to determine what charges to file, ultimately settling on forgery and tampering. Footnote 4 reads, while Hanley was speaking with the DA's office, the defendant asked McCoy why there were so many officers there, and McCoy replied that they were, quote, just trying to figure it out.
Oh, yeah. So, listen, I got to tell you, I do have a bottle of peanut butter jammed in my back pocket. I just need you to know that. When I read that, I was like, wait, where's the peanut butter? Is it in the backpack? Or is he carrying a bottle of peanut butter on his person? Inquiring minds want to know.
Right? Yeah. Returning to the body. At about 9:58 a.m., Hanley instructed the officers to place the defendant under arrest. And as Detweiler and Fry each took defendant by an arm, Wasser began to put on a pair of blue rubber gloves. McCoy confirmed that they were arresting the defendant for tampering and announced on the radio that the defendant could be marked as, quote, in custody. Officers Detweiler, Fry, and McCoy searched the defendant's pockets and clothing, recovering the jar of peanut butter, a pouch with money, some coins, gloves, papers, a hat, and some string. As Fox approached the table where the backpack was, he asked the defendant if there was anything in the bag they needed to know about. The defendant responded that he was, quote, just going to remain silent. Wasser and Fox then proceeded to search the defendant's backpack. As they did so, employees and customers continued to walk through the back area to access a closet or a bathroom. Wasser unzipped the backpack's main compartment and removed a sandwich as well as a loaf of bread. They continued to look through the backpack. Corporal Trent approached and suggested that they, quote, go through that back at the station. Wasser responded, I don't know, just wanted to make sure there's nothing in there that's gonna. Fox joked that he would rather have a bomb here than down at the station. Wasser responded laughing that she did not want to, quote, pull a Moser, a reference to an officer who had once transported a pipe bomb back to the station house.
This is a very important paragraph in terms of what was said, the rationale as to why the search was conducted there. Well, I mean, they get into it pretty heavy in terms of the analysis, but it's a critical paragraph there.
Okay, returning to the body.
I think I should start reading. I feel like you've really been running.
We're almost done this section, and you
Oh,
have to move it up for me, though.
Oh, yeah.
Fox removed a red journal from the pouch and placed it on the table. Wasser recovered a waterproof bag, referred to as a Faraday bag, and removed a cell phone, a passport, and a wallet from inside the bag. Fox retrieved a small cardboard sleeve from the backpack and spent some time trying to open it with a knife. He eventually got it open, removed a computer data chip that was inside the cardboard. Wasser handed the passport to Sergeant Miller and placed the other items back in the bag. Trent and Burns then inspected the passport. Wasser also examined the wallet and took out and looked at 2 credit cards before returning them to the wallet. Wasser removed a pair of underwear from the backpack and unrolled it,
Mantis.
revealing a loaded magazine for a handgun. That's where they found that. Loaded magazine for a handgun. After announcing
in the backpack,
rolled into the underwear. After announcing her discovery to the other officers, Trent stated, now that you've cleared it all, let's just go back to the station. Wasser responded that they were just making sure it's not a bomb or anything. Fox told Wasser, now that we have found it, the magazine, let's just take it back. Hanley testified that he told Wasser and Fox that they should wait until they got back to the station before finishing the search of the backpack because he was concerned about cross-contamination of DNA evidence and also because he did not want the search to occur in public. Wasser and Fox then placed everything back into the backpack except for a few items, which were placed in a separate McDonald's bag. Hey. Shop and
save.
Now we got McDonald's bags.
McDonald's bags.
If you know, you know.
Is it one of the plastic ones or one of the smaller paper ones?
I'm betting the paper one.
I'm guessing the bigger big breakfast plastic bag with 2 handles is what I'm guessing. But what do I know?
Could be.
Maybe.
Which were placed in a separate McDonald's bag to be taken back to the station. When asked if they had retrieved a particular item, Wasser stated that they had not completely searched the backpack because they just wanted to, quote, make sure there's no bombs. Trent then stated that, quote, at this point, you're probably going to need to do a search warrant for it. Corporal Miller agreed. Sergeant Burns and Fox disagreed, stating that they were permitted to do a search incident to an arrest. Wasser carried the backpack to her patrol car to transport it to the station, while Fox carried the McDonald's bag of items to his car. So now, babe, can you just play that? We only have a small piece of it, but
you mean the one that Tracy sent?
Yes.
I didn't have it chalked up.
Okay, I've got it.
Oh, good girl. Good girl. Thank you. I told you I didn't think we were playing it, so
I know, but I said it, so we're gonna do it.
I'm glad that you did it.
Okay.
Just a couple of guys in Altuna heading to a McDonald's to get a little coffee, make a
I'm
huge
still not
arrest.
hearing any sound.
I don't hear any sound. There we go.
Yes, sir. There you go. Can you put your mask down real quick for me? Yes, sir. Appreciate it.
I do.
Okay. What's your name?
Mark.
What is it?
Mark.
Mark?
Yes, sir.
Mark what?
Rosario.
Rosario? Someone called. They thought you were suspicious.
Oh, I'm sorry.
Do you have your ID on you?
Yes, sir.
Thanks.
Notice he has his eyebrows covered with that hat. He's super incognito.
Guy's just trying to eat a fucking hash brown, man.
I thought she looked like someone guilty to. 26, 27, 29 out of New Jersey. Rodeo
Guy's
60
recording.
07 521 00 07982. Should come back to a mark. Rosiano.
And that was basically it.
That's it. Like, why don't we have the rest of it? Like, is that
Not
all?
out there. I look.
Why? I wonder. I wonder why. Inquiring minds want to know. Well, so I mean, look, that doesn't give us that much, right? But because everything that the judge just described, the recognition, the questions, the moment that this goes from a conversation to an arrest, all of it is basically on the body cam, right?
Right. We just can't see all of it. But what was able to be seen on it, and as the order sort of describes, it starts with 2 or 3 that become 8. You can see the room physically change around him. The judge could, and the judge could see his demeanor. That Mangione remained calm the entire time, cooperative.
Mangione.
And that word
Mangione, not Mangione. Come on, you got an Italian surname.
Mangione.
There you go.
And that word cooperative, it's going to matter enormously as we progress in here. So we'll put a pin in it.
And we didn't see it on the video, but we heard about it in the judge's order that the escalation starts right after that cop goes in, asks for his ID. You know, at that point, 2 officers becomes 8. And it's not legal commentary. It's a legal fact. And it cuts 2 different ways in this order. For the search question, more officers means the bag is more controlled by police and less reachable by him. That's why Allie pointed out when she was going through the body of the order, the thing was 9 feet away, right? Because officer safety is something that the high courts are always like, look, we want our cops to be safe. Let's make sure that things are out of the reach of the criminals so they can't reach them and do harm to the cops. The fact that this bag is 9 feet away is indicative of the fact the officer was safe at that point in time. So more officers also means that the bag is more controlled and less reachable by him. But for the statement questions, more officers means a reasonable person. Imagine yourself sitting in McDonald's eating an Egg McMuffin and a Hashi, and you're surrounded by cops. Are you going to feel like you're free to leave? And that is the test for custody. So, you know, we have the same footage. There's 2 different doctrines, and we're going to keep a watch out for both of them.
Yeah. And one more thing that, like, the judge flagged in what we just read, the 2 responding officers were not equals. And she points out that one was a senior officer who knew the case, the other was brand new.
Green.
What?
Green. Wow.
And now I lost my train of thought, but and
I'm so sorry.
the other was brand new, green, right? And he knew very little about what was going on, and that's going to show up later too. So we'll just keep reading. But the rest of the findings of fact is the judge laying out the Altuna inventory policy, the searches back at the station, the warrant application, and the statements. So we'll read straight through that part, and you go, babe.
Oh, yeah. Let me pull it back up. Boop. There we go. All right. So the next thing we have is the Altuna Police Department inventory policies. All right. Now, these are a thing that after you're arrested, okay, and they're going to get into it in great detail. They can go through your shit, and they will go through your shit, and they will literally write down an inventory list. Reason being that if you're arrested and you have personal property, cash, the hope is that after you get arrested, they give you all your shit back, including your cash. So that's why they take the inventory. And we're going to go through Altuna's policies in terms of how they are supposed to conduct that particular inventory policy search. All right. So several officers, including the evidence custodian, one George Featherstone, testified about the policies and guidelines concerning inventory searches, and the relevant APD general orders were introduced into evidence. So APD General Order 3.1.9A1 requires an inventory search of a detainee upon arrival at APD headquarters and before being placed in a cell. So General Order 3.1.10A instructs how to properly document and store a detainee's property and requires officers to generate an itemized inventory of all items taken from the detainee. So any contraband evidence or weapons will not be returned to the detainee, but would be noted on the property form and documented in the official incident report. So detainees should be escorted to the APD station house intake area in order for the arrest to be processed. When possible, the detainee's property would be inventoried in his or her presence. There you go. That's it. That thing. You wanted, like, oh yeah, I had $1,200 cash there, sucker. Better all be there when I walk, so as to minimize claims of theft or damage.
AKA Afro Man.
Exactly. Perfect example. They went into his closet. They pimped his cash out of his suit coat. He's like, I had more. They're like, no, you didn't. If they would have done it at the spot and written it down, it wouldn't have been an issue. So, however, if the search revealed a weapon, the inventory search would be moved outside of the intake area and away from the detainee. Every piece of clothing would be searched, as would every bag, jewelry, extra clothing, and other personal items would be removed and stored. So during the intake process, the officers would determine which items were personal property to be returned and which items constituted contraband or evidence. Personal property would be listed on a receipt and inventory form and then stored in a locker. Contraband or evidence would be documented, photographed, and placed in labeled envelopes. Overhead cameras, as well as the officers' body-worn cams, would record the searches of the detainee's person and property. So APD officers were not required to write inventory lists simultaneously with the inventory search. That's the nice thing about body-worn cams, right? It takes away the necessity of writing that contemporaneous to the search, because you're always worried about them adding shit or subtracting shit. Now that we have a video on it, we're not as concerned about when that inventory list is written. So APD officers were not required to write that inventory list simultaneously with the inventory search, but could document the items at a later time. So then we go to the searches at the police station.
They're short, so keep going. The next two.
Okay. So once the defendant was brought to the station, officers Fry and Austin Homan completed an intake which involved obtaining the defendant's pedigree information, as well as searching the defendant's clothing. Fry collected defendant's layers of clothing, his jewelry, which included a USB drive hanging on a necklace. Ooh, you like my shit? You like my shit? And some personal items such as bus tickets, The USB drive was set aside as evidence, while the personal items were collected in a Lowe's bag. So meanwhile, Wasser arrived at the station carrying the backpack as well as the McDonald's bag, which had been handed to her by Fox. Wasser placed the backpack on a chair in the intake area where the defendant was being processed and placed the McDonald's bag on the floor. She then began looking through the backpack, opening a compartment that she had not searched at the Mickey D's, and quickly found a handgun wrapped in some manties. So after telling Deputy Chief Derek Swope about the gun, he had her move the backpack to another room to continue the search. So out of sight, Luigi can no longer see it. So Wasser took the backpack and the bag to an adjoining hallway as she, quote, cleared the gun. She discovered it was loaded, and she and Swope then placed it in an evidence box. Wasser continued to search the backpack, placing items in separate bags, including items that had been found at the McDonald's, such as the microchip, the cell phone, and the Faraday bag, the knife, and the loaded magazine, as well as items that had just been found at the station, including a silencer and the USB drive. At one point, she took the red notebook out of the backpack, examined it, and stated, "It's like a journal." When Swope asked if she should bag it, apparently suggesting it be treated as evidence rather than personal property, Wasser replied, "I mean, I would." Swope also stated at one point that Wasser should, quote, make sure there's no explosives in there, which she had already done at McDonald's purportedly. After removing the items and then placing them in the bags, Wasser asked if she should, quote, put this all back in, referring to personal items such as a bag of toiletries, batteries, clothing, and masks. An officer agreed that she should, and Wasser then placed the items back in the backpack. And we've got footnote 5. All of the bagged evidence in envelopes, as well as the personal property in the backpack, was later transferred to one George Featherstone, the evidence custodian. Back to the body. So meanwhile, Lieutenant Hanley spoke with NYPD Detective Leonardi of the Manhattan South Homicide Squad, who stated, "I'm on my way to Altuna. Don't do shit until I get there. You fools over there in Pennsylvania." That's what I'm imagining. Asked that nobody speak with the defendant and requested that all of his property be held. Wasser returned to the intake area with the backpack, where it was then moved to Featherstone's office so there would be more room to conduct an inventory search. Sergeant Eric Houston began photographing items recovered from the defendant, including a Maryland license, the fake New Jersey license, the wallet, the passport, the gun, and the silencer. He also began photographing loose pieces of paper, as well as some of the writings in the notebook. Houston and Hanley sent some of the photos of the evidence to the Dicks in New York. At some point, because George Featherstone's office had become too crowded with all of this evidence, the officers decided to move everything to the roll call room, where they would have more room. In the roll call room, Burns photographed every item recovered from the defendant, including every loose piece of paper, as well as every page in the notebook. Burns was particularly careful to photograph where pages appeared to have been torn out of the notebook in order to protect against claims of tampering or damage. Featherstone packaged and labeled every item and kept a written record of each item recovered and photographed. So the application for the search warrant. Later that day, Houston prepared an application for a search warrant for all the items recovered, listing the items that had been recovered from the backpack and describing some of the information that had been found in the red notebook. Houston also informed or added information about the shooting that had been obtained from Detective Oscar Diaz of the NYPD. Houston described the purpose of the warrant as, quote, to seize the items located during the search incident to arrest and inventory of the property, and to quote, to continue the search of the items, end quote, and to quote, maintain the property. This is all important language for law enforcement. This is all CYA language that you want to see cops writing down in order to cover their ass for when a suppression motion is going to be filed on a later date. So to maintain the property to be later transferred to the NYPD. The Blair County District Attorney's Office approved the warrant, and it was signed by a Pennsylvania judge. Defendant statements. That evening, defendant was arraigned at the Blair County Courthouse on the Pennsylvania charges. Do we remember that? I remember that. You remember that little lawyer? Do you guys remember that little lawyer? We covered that back when that happened. Little guy. He was feisty, that little guy. I can't remember what his name was. I wanted to get him on the show. I thought he was a feisty little guy. I'm like, feisty little guy. No way in hell that guy's representing him in any of these cases, though. So
I honestly have no recognition. I was just pretending.
Oh, yeah.
But I have perimenopause brain. So.
Oh, yeah. I remember, babe. So on December 10th of 2024, while the defendant was housed at Pennsylvania's Huntington Correctional Institution, he was monitored by correction officers Matthew Henry. Defendant told Henry that he was a software engineer and that he had been arrested at McDonald's and that he had been carrying a backpack. And that backpack contained a 3D printed pistol and a magazine, as well as a small amount of foreign cash. And the people were accusing him of being a foreign agent. Henry testified that the defendant blurted out these comments without any questioning from him, John Wayne Gacy style. It's exactly what the Gacers did. So on December 16th of 2024, defendant was being monitored by corrections officers Tomas Rivers. Defendant talked about his travels and places that he had seen in Vietnam and Thailand. So he also talked about people appearing to be happier in third world countries. I mean, I don't know why. They're all smiling. It's unbelievable, despite living in poverty. And they also discussed the healthcare system. Rivers could not recall who initiated the conversation, but Rivers did give his opinion about private versus public healthcare systems. Defendant also asked Rivers how the media was portraying him. And he stated that he had heard that he was being compared to Ted Kaczynski. Wow, the Unabomber, babe. So defendant also said that he, quote, wanted to make a statement to the public. Listen, I got shit to say. I need to make a statement to the people. That's what's really going on here. So the next day, the defendant spoke with Rivers about books, including discussing his favorite authors and recommending a book by Aldous Huxley. So they also discussed the standard of health among Americans compared to Europeans.
So I just wanted to say that, and you'll see it later. He says he just blurted it out. That makes a difference when whether or not when you're in custody, the officers ask you questions or you just blurt things out. And, so what we've heard so far is like, that's the complete account of the facts from the judge. Now comes the law, the conclusions of law. And this is where the judge actually decides it. He goes in order, which state law applies, then the McDonald's search, then the inventory search, then the warrant, then the statements. So I'll start here with and
we're going to read it, and then we're going to stop after each one, talk about it a little bit.
Right.
And so first up is obviously going to be the choice of law, which you were talking about. You got Pennsylvania and New York fighting.
And you'll see why it makes why it makes such a huge difference which law applies.
Yep.
So conclusions of law. Initially, this court must decide which state law, New York's or Pennsylvania's, applies when determining whether evidence or statements should be suppressed. Defendant is being tried in New York for a crime that occurred in New York. Under these circumstances, it is clear that New York is the forum state and that New York has a, quote, paramount interest in the application of its laws. And it's citing a New York case from 2018 for the concept that suppression issues are governed by the law of the forum. Cites a 2009 case for the concept that procedural and evidentiary issues are governed by the law of the forum state. While the people argue that Pennsylvania law should apply, as the Altoona Police Department followed Pennsylvania law in good faith, that is not the test under New York law. And in any event, New York law does not have a good faith exception to the exclusionary rule. So that is huge. The state is arguing, well, these officers were following their law, and it's their law that should apply because they did it in good faith. And usually when you do something in good faith, then they'll be like, all right, you were wrong, but we're not going to exclude the evidence because,
They were acting in good faith.
Right.
Right.
So
But like, before you jump on the significance, you can see why the prosecutors wanted that Pennsylvania law to apply as opposed to the New York law, because New York says, hey, you know what you could do with your good faith exception? You can shove it right up your ass. We don't play that game.
Right.
So that's why the defense would obviously want the New York law to apply because of that fact.
Right.
So that's where we've got the battle brewing here.
Right. And just so you know, like, New York is one of those states, along with California and Louisiana, where it's a whole different common law, a whole different rule of law that applies. Like, a lawyer can't be like, I've been practicing 20 years in New Jersey, I'm ready to come into New York. No. You got to take a whole New York bar exam. You've got to prove that you understand New York law, where for states that all follow the same common law, you can just kind of hop in.
And Louisiana law, just as a very short aside, is like Martian law. It's like alien law. Like, when I was sitting there interviewing Lance's father, who is a old-time Southern lawyer, that there is going to, in some short order, there's going to be a podcast that we do, because I interviewed him for 10 hours. The guy was unbelievable, legendary lawyer. But the things that he was talking about in terms of the process procedurally, I had no idea. I had never heard turns of phrases. It was kind of like when we went out to Pennsylvania and the prothonotary. I'm like, what is that? Or like the clerk. I'm like, well, why don't you just call it the clerk? Not the pro. I'm like, the protho notary. So, all right, back to the body, babe.
Okay. The people, did I read that part? The people also argue that the cases cited by the defense apply only where the defendant claimed violation of another state's search and seizure laws, because New York courts will not, quote, trouble themselves with asserted violation of other states' search and seizure law. People's Memorandum of Law, and they cite to the People's Memorandum of Law. This court does not believe, however, that those cases can be so limited. The courts clearly state that New York has a, quote, paramount interest in the application of its laws, and that suppression issues, procedural issues, and evidentiary issues are governed by the law of the forum state. The courts do not limit this clear pronouncement, and therefore this court will follow New York law in deciding the issues.
All right. I mean, that was a big win for the defense there. Yes?
Yes.
So, all right. Carro picks New York law, and his reasoning is pretty clear, right? New York is the forum state, meaning that's where the shit happened, the place of the trial, and the forum has what he calls a paramount interest in applying its own law to the suppression questions. Suppression, procedure, evidence, all governed by the forum.
And you've already said this, but it's like Bob said, this is the whole ball game. New York search and seizure protections are broader than the federal floor, and that is unusual. Most states are, they follow the federal law in what is called lockstep. But critically, New York has no good faith exception to the exclusionary rule, as we discussed, and he cited that case for that. So, I mean, there are a lot of jurisdictions, including the federal system and Pennsylvania, again, where if police get it wrong and they're acting in good faith, the evidence still comes in. So years ago, New York said, nah. And that's exactly why, as Bob said, the people wanted Pennsylvania law, with the argument that the Altuna officers followed Pennsylvania law in good faith.
Yeah. I mean, if the search is bad, the evidence is out in New York. They don't give a shit how sincere the cop was. There's a bad search. The evidence, it's gone. Boop. That's it. Right?
Yeah. And they also ran a more clever argument. They said the defense cases only protect defendants complaining about violations of another state law, and that New York court laws will not trouble themselves with another state's search rules. So Pennsylvania law should govern by default. And obviously we heard the judge rejected that too, saying that they can't be so read so narrowly. You know, I mean, there's like a little push and pull there, because why would they say we don't trouble ourselves with search and seizure laws, but that's what suppression issues come from, when you violate someone's, right to reasonable searches and seizure, or right against unreasonable search and seizure. So
yeah, and like I always find these choice of law things fascinating. And Allie, in the Garcia case, we had a choice of law issue because Garcia had been arrested in Illinois. Obviously, the crimes took place in Nebraska. So she got into the weeds in that fight. And, I mean, and again, the law was more beneficial in one state than it was in the other. So Allie obviously fought for us to and I can't remember which was which. I can't remember if it was Illinois or Nebraska that was more favorable.
I think we would have been arguing, it must have been we wanted Illinois law.
Yeah, I would think so.
But we might have wanted Nebraska law and thought Illinois would apply because it happened in Illinois. So I don't know. Sorry.
Who knows? Who knows? But yeah, it's always an interesting scenario. You see it a lot. You saw it with Koberger. Again, you had Pennsylvania law where he gets arrested, and then obviously you had Washington or Idaho rather, where it went, or Washington State, depending on, his you had 3 states involved there. You had Washington State, you had Idaho, and then you had Pennsylvania. So those are always really kind of interesting scenarios, and they're kind of interesting to figure out which state's law is going to apply. And, it's a bit of forum shopping by the lawyers. I mean, obviously each side's going to want to pick the state that has the law that's more favorable to their side. So ultimately it's going to be up to the judge to figure it out.
Right. And then you've got this next section, which is the search incident to arrest. And it's a doctrine everyone has heard of, and almost everyone gets slightly wrong. So when police make a lawful arrest, they can search the person and search the area within his immediate control without a warrant. The people here, they call it the grabbable area.
Grabbable. Hold on. That's grabbable. Like, meaning I could reach it and grab it. That's a grabbable area. You've got some grabbable areas, don't you, babe?
Oh, come on.
Oh,
come on. All right.
And the reason for the doctrine defines its limits, right? So there are exactly 2 justifications, officer and public safety. We were talking about it when Allie pointed out the fact that they moved the bag 9 feet away, right?
And
so
that they already did that first search of his person.
Right. And, he's like, so they patted him down. So that's straight up officer safety. And then when they move it 9 feet, unless dude's Stretch Armstrong, he's not going to be able to reach the bag in order to pull any kind of potential weapon that's in that bag. So the suspect, obviously, if the bag's too far, can't grab the weapon, and preserving the evidence so the suspect can't destroy it. That's the other part of this, right? It's kind of like, when they're knocking on your door and you're trying to flush all the cocaine down the toilet before they get in. Oh, I'm coming. Flush, same shit.
So that is one of the exceptions to the knock and announce, is the destruction of evidence. And that is used a lot in drug cases for exactly what Bob's saying, that once you knock, then they start running to the toilet and trying to flush everything.
Exactly. And if neither one of those situations is in play, the justification is gone.
Right. And New York tightens this further for closed containers. So even a bag that was near the suspect when he was arrested, cannot be searched without a warrant unless the circumstances support a reasonable belief that he could actually get into it for a weapon or to destroy evidence. And the prosecution here had a fallback. They didn't really argue Mangione could lunge for the bag.
Almost.
Mangione.
Hey, my name is Luigi Magione.
So they weren't arguing like he's going to lunge for the bag and get to it. They argued the officers were doing a safety sweep looking for a bomb before transporting it. So something that could go off without him even touching it.
Yeah. And when you kind of remember that whole thing, like that search when the manhunt was going on for days, and they kept finding like little things that were like pipe bombs and shit. Like that whole manhunt was kind of insane. Like I forget about it. I almost want to go back and kind of revisit it. I just like that entire event was so crazy. So, but at any rate, as we read this section, okay, there's two questions. Number one, was the bag in his control? And even if it was not, was there true exigency, meaning an emergency, that justified going into that bag anyway? So let's read it. Do you want me to read?
I think did I just read or did you just read?
You just read. All right. So the search incident to the arrest. The Fourth Amendment to the United States Constitution protects individuals from unreasonable searches and seizures. You guys know how much we love the Fourth Amendment over here. We love the Fourth Amendment. It really protects our asses. The New York Court of Appeals has interpreted our state constitution as providing even broader protections. We've taught you this over the years. States, they can offer more protections than the federal constitution. They can never offer less, right? So New York offers more. We know that because they said, you know what, that whole good faith thing, nah, we're good. So this provision serves to shield, quote, shield citizens from warrantless intrusions, end quote, including of their personal effects. And that comes from People v. Jimenez, 2014 case. So to justify a warrantless search, the people must meet two separate requirements. The first, quote, imposes spatial and temporal limitations, end quote, to ensure that the search is not divorced in time or place from the arrest. So that's an important factoid. Remember that. In the context of searching closed containers incident to an arrest, the second requirement is that the people bear the burden of, quote, demonstrating the presence of exigent circumstances, end quote, in order to invoke the exception to the warrant requirement. Okay. So those are two things we want you to keep in mind because that really goes to the heart of the issue here. So in order to invoke the exigency exception, the property must be within the suspect's immediate control or grabbable area. Grabbable area. And that comes from Goki at 312. Under those circumstances, there are two interests that justify a warrantless search. Quote, the safety of the public and the arresting officer, and the protection of evidence from destruction or concealment. Also see Jimenez. So even a bag within the immediate control or grabbable area of the suspect at the time of his arrest may not be subject to a warrantless search incident to an arrest unless the circumstances, quote, support a reasonable belief that the suspect may somehow gain possession of a weapon or be able to destroy evidence located in said bag. Again, citing Jimenez and Goki.
And I just wanted to mention here, this is how you can see how like the law evolves as circumstances come up, because you could argue here, well, the judge wasn't faced with the fact that what about some sort of remote detonation, or what about something that if it gets shaken, someone tell me,
Shooken
it could,
or shaken. They're both fine. They're
okay.
both real words.
I just didn't know which one was right
shooken.
there.
Maybe it's shooketh.
That something could go off without him gaining access. So like, and I'm sure it gets into it a little more here, but you can see that's one of the ways like the law would evolve. They'd say, well, under the reasoning here, when we're talking about the possibility where X could happen, this logic applies. But I actually haven't read this whole motion. I know you did. But
yeah, back to the body. Here, the backpack was not within the defendant's immediate control or grabbable area. You like that? You like that? I know you love that. I mean, how can you not love it? At the time of the arrest or search, Hanley moved the backpack away from the defendant out of his reach shortly after he arrived, while a number of officers stood around the defendant. Show of force. Hanley considered him detained. A short while later, McCoy moved the backpack to a table about 9 feet away from the defendant. 9 times. Name the movie. So once defendant was arrested for the false identification, he was handcuffed and remained surrounded by several officers. Hanley was not concerned the defendant could reach the bag while recuffed. Right? Rear cuffed, meaning behind his back. So McCoy was also unconcerned, testifying the defendant was surrounded by officers who had, quote, good body positioning. The defendant was also cooperative, described by several officers as compliant and non-combative, and offered no resistance to the frisk or the placing of the handcuffs. See Jimenez and also People v. Evans. So under these circumstances, the backpack was not in the defendant's control or grabbable area. Indeed, the backpack was within the exclusive control of the popo. See Evans. So the backpack under complete control of the officer when it was searched, People v. Diaz, and the search of the defendant's backpack unlawful because the defendant, handcuffed at the time, was and it was no longer in his control, People v. Medina. So, and then the backpack removed from the handcuffed defendant. Oh, wait, hold on. I got my blown up screen from my blind ass. Hold on. All right, there we go. Backpack removed from the handcuffed defendant and within the officer's dominion and control. So even if the backpack could be seen as within the defendant's control or grabbable area, the people did not meet their burden of demonstrating exigency. So the people assert that the police were merely searching for explosives. There's a bomb, maybe, in an effort to protect themselves and the public before removing the backpack to the station. However, this justification for searching the backpack does not hold up to scrutiny. We ain't buying what you're selling, girl. We ain't buying what you're selling. You know, I don't want, what was that cop's name? We don't want a Moser situation. Whatever she called it. Oh, we like, what are the various situations where somebody's done some like total kerfuckle and it's termed a that person situation? You know what I'm talking about? Do you know what I'm speaking of? You're sitting there quietly.
Yeah, I don't know which situation you mean, but that's the thing that happens. Yeah.
Like when somebody shits the bed, it then
right, and then it becomes their name. Yeah.
Yeah, exactly. So, however, wait, where was I? I got lost. I got lost, babe.
You're at a kerfuckle.
Oh, does not hold up to scrutiny. The officer's actions were inconsistent with merely performing a safety search. The area where the police searched the backpack was open to the public and to the McDonald's employees, both whom passed by the area on their way to the bathroom. And in the case of the employees, to gain access to the storage closets. Yeah, they got their phone out, every employee. I got to go to the bathroom. I'm just going to the bathroom over here. Where, you know, everybody's filming Luigi Magione. Oh, yeah, I'm just trying to go to the closet to get a mop. Filming everything. So the area where the police searched the backpack was open to the public and to the employees, both who passed by on their way to the bathrooms, and in case of the employees to gain access to the storage closets. A safety search for a possible bomb is inconsistent with this unsafe protocol. Maybe they had to have cleared the scene if that's what you're worried about legitimately, right? So
I want to chime in here because
I think you should.
A lot of times the law does not consider what they actually thought. Now, I can't remember if it was a case that we were discussing on YouTube, and I think it was just my everyday real legal life that researching officers who are like claiming community caretaking, and they're like, oh, well, we broke in the house because we thought they might be hurt. And the even the Supreme Court is like, well, it doesn't matter whether he really thought the person was hurt inside, because the defense is like, all of these actions he took, like he didn't check the guy's, whatever, X, Y, and Z, prove this guy did not even contemplate that somebody was hurt. And they said, I don't care what he thought. All I care about is whether the facts an officer could reasonably believe someone inside might be hurt. Whether or not he actually believed it, he went in, all of his actions show he didn't do a damn thing to check on a person or whatever, didn't matter. So this is interesting. And I don't know if that's just a change in the application of New York law, that this is, they consider facts like that, or if it's just this judge, but you see it a lot in circumstances that deal with illegal search and seizures, and whether the officers had some sort of either probable cause or reasonable grounds to enter somewhere, and they won't consider their subjective belief or their subjective actions, whether that is consistent with the asserted objective belief. So that's very interesting to me there, that the court looked to what they did and said, if you really thought there was a bomb in there, you would have cleared out the McDonald's. I think it's the right way to do it.
Me too. I
obviously
appreciate that they did that. Like that's like looking outside of the box a little bit and like really trying to get into the heads of the cops, because I mean, that's frankly the only way that you're going to be able to sniff out if they're full of shit.
Right.
If
And
you're just going to look at it on the face of it without doing any kind of analysis like that, then, you're just taking the cops' word for it all the time.
And I think it could be, still come into play with a subjective versus objective belief, because, all right, there were grounds for an objective belief that someone's, for example, that there was, something that could be triggered remotely in there. Now let's see if your actions were consistent with that objective belief, even if in your mind you actually didn't believe it. Like I think that goes along with it. And it's something that we should see more often. I find it absurd. It's like one of those things where the law just says words and then is like, I don't really mean them if you say the right thing.
Hey, can I tell you something?
What?
You look very beautiful today. Back to the body. So I'm going to start with the last sentence just to get you guys back to where we were. So a safety search for possible bomb is inconsistent with this unsafe protocol. Moreover, the police stopped searching the backpack once they found the loaded magazine. So Officer Fox even stated that now that they had found the magazine, quote, let's just take it back. Similarly, if it was a search for a bomb, it was an incomplete one, as they left compartments unopened and untouched. Good point, Judge. Good point. Moreover, a search for explosives would be inconsistent with the examination of small items where a bomb would be unlikely to be found, such as the defendant's wallet. Hey, check if that guy's got a wallet bomb.
Right. And now that is consistent with like search and seizure law, because if you have a search warrant for a computer, for example, and you start going through someone's pants pockets, I'm using like a really obvious example here, the court will say you can't find a computer in a pants pocket, so, but it still is looking beyond what I've seen other courts look at, as I described before, about, well, yeah, that's an reasonably objective belief that there could have been some bomb in there or something that was triggered.
Say, is that a computer in your pocket, or are you just happy to see me?
What a dork. What a dork I am.
You're so adorable.
All right. So moreover, a search for explosives would be inconsistent with the examination of small items where a bomb would be unlikely to be found, such as the defendant's wallet and the close examination of an opening of the cardboard sleeve. This court is unpersuaded that the people have met their burden of showing exigent circumstances. So the police also argue that the search of the backpack was justified because the officers had a reasonable belief that the bag contained an operable gun. However, while the body-worn camera footage showed that officers did express concern at the scene that the backpack might contain a bomb, there was no evidence that a gun was a concern or that it was the basis for the search. But even if it were a legitimate concern, there was no possibility at the time of the search, temporal, that the defendant might retrieve a gun from the backpack, and thus no exigency. Again, he's handcuffed behind his back. The bag's 9 feet away. It's a no-go.
Right.
So, and then they quote, citing Goki there must be a reasonable belief that a suspect may gain possession of a weapon. Medina, backpacks in the officer's control, no longer any safety concern that justified the search, nor can it be that whenever a gun is alleged to have been used, that the police may conduct a warrantless search of a closed container without a reasonable belief that the safety of the officers is threatened, as that would, quote, run afoul of the Court of Appeals jurisprudence and would eviscerate the grabbable area doctrine, People v. Morales.
You're going to do that every time they say grabbable.
I mean, look.
And I know what your sound is there. It's crazy.
Oh, yeah. You know.
I
That's
know.
an inside joke.
Yeah.
That's an inside joke. That's inside poker right there.
Yeah, but you
Kids
kind
don't
of,
need to know. The kids
they
don't
know.
need to know.
They can figure it out. You
Oh,
make
yeah. You
comments.
think?
I do.
They're pretty smart. All right. So therefore, the evidence found during the search of the backpack at the McDonald's must be suppressed, including the magazine, the cell phone, the passport, the wallet, and the computer chip. 6 footnote.
What about, oh, we're not at the red notebook yet.
So ask and ye shall receive. The red notebook will not be suppressed as the officers did not open or search it at the McDonald's. See People v. Lewis. Search of an envelope occurred when the police opened it and boop, peeked inside. Wow. All right. So there you go.
Is there more to that footnote, or that was it?
That was 6. There's a 7.
Oh,
which we have
okay.
not gotten to yet.
All right. So, look, here, the judge didn't just take the officer's word for like what kind of search this was and their reasons for it. He watched the body cam footage, which we don't have all of that, but he did watch it. And in the search of the backpack, again, it was at McDonald's. It was carried away from him. It was set down 9 feet away. It took place in public with customers there and employees passing, and the officers opening small items like the wallet, and the officer saying words to the effect of, let's just take it back after the loaded magazine is found. Again, that was all what the judge said. Like, that's not you looking for a bomb, because you were satisfied once you found the loaded magazine, but didn't continue to search the entire bag.
Yeah, I mean, the bottom line is Judge Carro decided the math wasn't mathing and answers the question with a flat nope. The backpack was not in Mangione's grabbable area, and the timeline is brutal for the prosecution. One cop moves the bag away early, then the other moves it again. Magione is handcuffed. He's surrounded. He is, by every cop's description, cooperative. So it just doesn't work. It doesn't work for their narrative.
No, and the judge's phrase is that the backpack was in the exclusive control of the police. And he stacks up New York appellate cases, all the same fact pattern. Bag taken off a handcuffed defendant, no longer his to grab. The search is unlawful. Once the bag is 9 feet away and he's in cuffs, bring by cops, the safety rationale and the evidence rationale are both gone.
Yeah, and look, so that handles question 1. All right. So question 1, that's a no-go. So then they're going to look at question 2, which is the exigency. And kind of the way from law school that I always found that exigency was the easiest way to think about it. Think about, like, if you're a cop, you see a guy like literally shoot somebody on the street. He's off like a prom dress. He's running, runs up into somebody's like front porch, busts through their door, running through the house. Obviously, that cop is going to be able to enter that house while he's chasing the person, because he's clearly afraid that that person's going to commit another felony in there and or get rid of the evidence. There's a lot of reasons why that cop would be able to get in there without a warrant, even though that house has nothing to do with it. Exigency means that, like, you got to act right now or shit's going to happen bad. Either they're going to hurt somebody else and or they're going to get rid of the evidence. So those are the kind of situations they're looking for when they're trying to reach a determination of exigency. And this is where the brief footage that we saw, which again, I really wish we could see all of it, because I would have loved to have seen like the search of the bag, but you looked, right? We just couldn't find it anywhere. I don't know.
No, I looked every place that I looked had the same thing, but the judge saw the whole footage.
Right, exactly. And so, you know, and again, the cops are saying that they were searching for bombs, a genuine bomb sweep. And Carro did a beautiful job of, as Ali said, going a little bit beyond and dismantles it using the officer's own conduct and their words, or lack of conduct, meaning let's clear the restaurant. I'm worried that there could be a boom boom up in this bag. So that didn't happen. Judge did a great job of looking past just the words on the paper and the video, and, you know, kind of really trying to get into the cop's brain, and did a nice job of it.
And we basically covered, you know, all of the things with that it happened in public and they didn't make the people leave. And the judge focusing on all the parts that were inconsistent with this claim fear, you know, and that they stopped searching the moment they found the magazine, and they left the compartments incomplete. So
yeah, I mean, that's basically it. So Carro's conclusion writes itself. Basically, the conduct does not match the claim purpose. So the bomb sweep was an evidence search wearing a costume, right? So wolf in sheep's clothing, or a sheep in wolf's clothing, I think is more the appropriate phrase. So he also rejects the separate theory that the officers reasonably believed that there was an operable gun in the bag, because again, why, class? He couldn't reach it. He was cuffed. Those two reasons. It's a no-go. No evidence that the gun was the actual concern, and there was zero chance that Mangione was going to be able to get into that bag. And he adds an important line. He says that you cannot have a rule where any time a gun is alleged, police automatically get to search any closed container. We don't want to live in that world. We don't want to live in that world. So that would eviscerate the grabbable area doctrine. The exception would then eat the rule.
right. So the judge says that everything found in the backpack at McDonald's is out. And again, that one carve out that Bob read the footnote, and we get more into it in the next section. The red notebook, they took that out of the bag. They took it out of the bag and set it on the table, but they did not open it. So the notebook is not suppressed in that section.
Yeah,
But let's
I mean, we're going to keep rolling right here.
right, let's get to the next section.
So if Ali and I are reading this, we're like, oh, big win, big win. But hold on, there's more.
All right.
Because unfortunately for Mr. Luigi Magione, there's more evidence. And it's pretty damning shit. So I'm anxious to see what happens with this evidence.
All right. So inventory searches at the station house. That's the next section. An inventory search is a search designed to properly catalog the contents of an item searched, and it must be, quote, conducted according to a familiar routine procedure, citing numerous cases in New York. It must not be a ruse for general.
Love that word.
Yes, quote, for, quote, general rummaging in order to discover incriminating evidence, citing it both a Supreme Court case and a New York case. While the discovery of incriminating evidence may be a consequence of an inventory search, it should not be its purpose. And you know how many times we saw that, like in the law with automobile search, like, oh, I'm taking the driver into custody. I had to search the whole damn car, including the trunk and everything. And then lawyers like, wait a minute. There was a second
in the backpack, in the trunk.
There was a second driver that could have taken that car and driven it away. You didn't give him the opportunity to. He had a driver's license, and there was no reason for you to keep the car, and then just make up a reason to search it. So, you know, the policy that every specific police department's policy on inventory searching, like of vehicles in those kind of situations, always, you know, became an issue. But all right, back to the body. An inventory search procedure must be designed to protect the property of the defendant, protect the police against any claim against lost property, and protect police and others from dangerous instruments, citing a New York case. Reasonable police regulations relating to inventory procedures administered in good faith, satisfy the Fourth Amendment, and minor deviations from procedure will not invalidate an inventory search. Again, citing 2 New York cases. Here, it is clear that the Altoona Police Department had an established inventory search protocol that was set out in its written rules and regulations that met the 3 objectives and sufficiently limited the discretion of the searching officers. The people also demonstrated that the Altoona officers, quote, conducted the search properly and in compliance with established procedures. The defendant was first brought into the intake area to be searched and processed according to APD protocol. After Wasser arrived at the station, she placed the backpack on the chair in the intake area. Also, according to APD protocol, the detainees searched property. Oh, sorry. There was a footnote right at the end of the paragraph where they
You're
said,
right there. You're right there, baby. No worries.
all right. So after the court notes that the property, the compliance and established search procedures, they cited another case, and it's C. United States versus Mangione.
Hey.
The search of the backpack was, quote, consistent with the written regulations and standard practices for an inventory search. And that was in the federal court of the Mangione case. So the court just sort of adopted what the federal court ruled. You know, again, there's a federal case and a state case going on at the same time, which is highly unusual. And I think the law needs to be revisited on this issue. But for now, it is what it is. So in any event, they said that after they arrived to the station, they followed the rules that the detainee property should be. Go down, babe.
Oh, wait. Sorry, baby.
Should
I was
be
panicking. There was some kind of talk of a game being canceled. I'm like, wait, was there a game today? I really shit the bed. Sorry.
He's worried about our daughter's softball. That
But
would
I
have been horrible.
digress. I digress.
So searched in the detainee's presence where possible. Once she quickly found the gun, she moved the backpack to a separate area as required by APD protocol that the search be moved out of the detainee's presence if a weapon is recovered. Once Wasser moved the backpack into the hallway, she continued to sift through it, placing personal items back in the backpack and putting other evidentiary items in manila envelopes, including items found at the Mcdonalds, such as the gun magazine, the cell phone, and the knife, as well as items found at the station, including a silencer, the USB drive, and the red notebook. This was also consistent with APD protocol that personal items be separated from evidence or contraband. All items were then moved to Featherstone's. Can't do it like you, babe.
George Featherstone.
Office, so there would be more room to complete the inventory. This initial inventory sufficiently complied with Altuna's procedures to be a valid inventory search, citing a 2025 case, nor does the effort to separate evidence from personal property render the search unlawful, citing a 2021 New York case for the proposition, quote, that one of the requirements of an inventory search was to, quote, remove any contraband did not render the inventory search invalid. While Wasser did not prepare a written list of items, APD policies did not require documentation be simultaneous with the search, and the items were documented once they were moved to Featherstone's office and the larger area of the roll call room. Minor deviations from procedure will not invalidate an inventory search, reciting that earlier case of Chieta that the court cited earlier. And courts have upheld inventory searches where there was a delay in documentation, citing New York law. There was an 11-hour delay there. So she's saying, look, even under New York law, a slight deviation of not writing down, delay in documentation is not going to invalidate everything. So once the items were moved to Featherstone's office and then
George Featherstone's office
and then the roll call room, all items were meticulously documented. Featherstone, Houston, and eventually Burns placed each item in an envelope, labeled each envelope, and kept written lists of the items. Houston and Featherstone also photographed each item, including each loose piece of paper and each page of the notebook. Thus, it is clear that the Altoona Police Department had established inventory search protocol, that the protocol was followed, and that the search produced the, quote, hallmark of an inventory search, a meaningful inventory list, quoting another New York case. As noted above,
Oh,
any minor deviations from protocol do not invalidate the search. Footnote 8 is a
oh. Can you read that?
says, nor is this court persuaded by the defendant's argument that the protocol only permits inventory searches of the defendant's person rather than his property. This claim is not supported by the language of the general orders, and they quote to it, moreover, or cite to it, moreover, it defies common sense and would defeat the purpose of any inventory search to catalog and preserve the defendant's property, which the judge is saying would include all of his personal property, not just the stuff on his person. Returning
To the
to the
body.
body. Therefore, the people met their burden of establishing that this was a valid inventory search. Defendant also argues that Wasser's brief examination of the notebook to determine whether it should be treated as evidence and Houston and Burns' photographing of its pages were an unlawful extension of an inventory search. I kind of thought that too, but let's see what the judge said. This court disagrees, finding that the cataloging and photograph of the notebook was a valid part of the inventory search, nor does the evidence suggest that the purpose of examining the notebook was, quote, investigative, rather than conducting an inventory. The officers,
I don't know.
yeah, me neither.
I don't know. It's like you're talking about a notebook. Why you got to be such a curious George? Just wait till you get the warrant.
Right.
You know, like you want to dig in. I want to see what's written in there. Can't help myself. You know, wait till the warrant. You're getting the warrant. You're applying for the warrant. You know you're going to be able to get into it. I don't know. That I think that's a stretch. You know,
Yeah.
and I think that kind of goes to. I think the judge may have known how important
it
that
was.
particular red notebook is in terms of what's contained therein. And he found a way to kind of work around, you know, like we'll talk about it when we get through it a bit. But yeah, I thought it was spurious. This particular piece of evidence, I thought was like, I don't know.
Yeah. So the judge goes on to say that the officers photographed every single page demonstrates that the purpose was to catalog rather than investigate. And Burns was careful to document every page of the notebook to protect against claims of damage or tampering. This is ridiculous. Why did they don't need to catalog the pages of the notebook? They need to catalog the existence of a notebook. And
Yeah.
the court cites this is a CF, which means, all right, here's a case that held something the other way. Compare this to People v. Somerville, a 1996 case where the court said may not look through book during an inventory search for, quote, sole purpose of investigation, and then cited some other cases as well. So the court's trying to say here, this isn't.
It's a distinction because
Yeah.
they weren't looking at the notebook to see what was written. They wanted to make sure they were protecting against any claims of damage or tampering, meaning, you might remember when you used to have your school notebooks, you tear out the page and it would leave that, that trail of the paper, where the holes stuck in there and you could pull them out and have confetti, basically like that type of shit. Basically, like I don't see the argument that could be made as to how in any way, shape, or form that proves a damn thing. Like they could tear a page out and then take a picture and say, "Oh, well, like I took a picture. Like it was gone already." Okay, I just don't. The argument's not making sense to me, just logically, as to how a photograph being taken of each individual page protects anything in terms of claims of damage or tampering. It just that math ain't math, and for me, it's a real stretch in my estimation.
Yes. And just so you know, things changed because, school's out and we've got a almost 14-year-old. So you're going to have to continue without me at 5:05 just to go pick her up.
What?
Yep.
That's outrageous.
The other kid has a soccer.
Oh, I
game
wish
or
we'd have
something.
known that on the front end.
Yeah, obviously.
You know what I mean? You know what I mean?
Yes.
Like how deep into the burn is it?
It's right downtown Auburn.
Oh my God.
Yeah.
I'll
right
carry
off
it.
47 by where Brian used to live.
I'll carry it for the team. You know what I mean?
Yeah.
All right. So now we're switching to the Pennsylvania search warrant. So the people argue that the search warrant for the backpack obtained at the end of the day after the search at McDonald's and the inventory searches at the station provided an independent source for the evidence, citing People v. Arnow. So, and that's a 1982 case. However, the presence of an independent source does not, quote, automatically immunize an initial warrantless search. And that's People v. Burr, a 1987 case. In Arnow, the search warrant was obtained based, quote, solely on information obtained prior to and independent of the illegal entry. And that's People v. Vasquez, a 2018 case.
New York case. You got to make sure.
Where you see that?
Well,
Oh, yeah.
they're all New York cases unless it's,
Wait, did I say otherwise?
No, I'm just saying it's important because it's different than federal law. So.
Oh, yeah. Oh, yeah. These are, I mean, you could tell at this point in time, you should be able to tell by the way the site looks, whether it's federal.
They're not able to do that.
I mean,
Come
it
on.
has US in there. All right, never mind. Okay, so phone initially searched without a warrant, but police already had probable cause based on a victim's statement to the police, and they were the basis for the warrant.
So that was how they distinguished that case. That what Bob just read was this 2018 New York case.
Yes. Here, the Altuna police relied partly on the evidence itself recovered from the backpack and information given to them by the NYPD after the searches had occurred. Therefore, the independent source doctrine does not apply. And to apply it under these circumstances would improperly vitiate the warrant requirement. Okay, so that was short and sweet, that little section there, huh? Do you want to take this next section or?
Well, yeah, let's just discuss, because what are we at
That was the
statements? Yeah.
that was the Pennsylvania search warrant.
Oh, right.
That was
So
shorty.
So with the Pennsylvania search warrant, it's the there was like headlines out there, Mangione wins suppression. And while it's true, some people think that means the gun got thrown out, and it didn't. And, that's why we needed to understand this whole inventory search. It's a completely different doctrine. And the whole police cataloging information to protect police belongings, to protect themselves from a later claim of things stolen. So they cite the rules, the cases in New York, that an inventory search is valid if they follow department rules. So and that's what they did here. So now you've got the judge upholds the station house inventory search. He finds Altuna did have the written policy and that they followed it, and everything was, had the hallmarks of an inventory search, even though Bob and I aren't seeing it with that red, with the red notebook. But he said that the police don't have to simultaneous document things. I think that was supported. But, there's the part that Bob had flagged, or that I just discussed about the gun, that you have to kind of track each item. So the McDonald's was a bad search. They found that the magazine, the cell phone, the passport, the wallet, those are suppressed, but the handgun itself, that's not there. The gun was first discovered at the station when Officer Wasser opened the compartment. So,
I mean, I don't love the concept that the courts are relying or giving so much weight to an independent police department's policies. I mean, the policies can't override the law. You know what I'm saying? It's like, what happens if they have some crazy shit in their policies? They're like, well, they followed the policy.
No, I think that I'm sure in that situation, they would say their policy is too.
Maybe.
I mean, I would hope so.
Maybe.
But, like the gun itself, was not fruit of the bad search. It was completely different. They hadn't even opened up that compartment. So it's a non-issue if people, believe that was something that might have come out of this by reading the headlines. And then we saw that the notebook, which is the motive evidence, that got its own its own analysis, and the defense argued that examining the notebook and photographing every page was investigation dressed up as inventory. And as we just heard, the judge disagreed, and the notebook, comes in.
Yeah, it's just like if I would have liked to have seen it, like if Carro would have like finished the job. You can't do the kind of analysis that he did with respect to what was in that cop's mind in terms of what they did or didn't do in the Mcdonalds to kind of disprove the fact that they were actually concerned that there was a bomb in there, and then abandon that application of common sense when thinking about the notebook, because it's the same shit. Like the judge knows that they are applying for the warrant. The judge said, well, here's the problem. Okay. You already had a cop running to get in front of a judge who's applying for the warrant. Once that a warrant, and you're clearly getting it. There's no, I wonder if we're going to get the warrant. You're getting the warrant. So as soon as you get the call from the cop, from the courthouse, warrants in hand, then you can read it. You didn't wait. I call bullshit. It's out. You know what I mean? Like that's the reality of the situation, because that's how that thing plays out. For them to say that, taking the photographs was to preserve any kind of issue down the road of tampering with it or any kind of, police malfeasance. I'm not buying it, and this is like, I considered this particular motion and the order to be like what they call a Pyrrhic victory. It's like you may have won the battle, but you lost the war, because the shit that comes in is the shit that's going to put them down anyway. It's like that thing where, the judge throws you some breadcrumbs. If you're the defense, we're going to keep a bunch of shit out that doesn't really matter because they still have plenty of evidence to nail you against the wall. And that's what happens here.
Right. And then, like this last section, which is the statements, right? That's what we're at next.
Yep.
Yep. This is the Huntley. That's the New York case, part of the hearings that Bob described earlier. It's the Miranda framework with the New York kind of gloss to it. Has two questions: was the person in custody, which is normal, and was what the police did interrogation, which is also normal. But both have real definitions. So custody is not just being detained. It's a seizure that curtails your freedom to the degree of a formal arrest, judged by whether a reasonable innocent person would feel free to leave. Now, remember that escalation that the judge described that he saw on the body cam. The judge is a man, right?
I'm assuming so.
Yeah.
I think his first name's Gregory.
Right. There were, the whole 2 officers becoming 8. And
I did know a girl named Gregory once, but it was very rare. It was unusual.
Right. And interrogation, it's not
I didn't
just
know any chick named Gregory, dude. Come on.
Oh, well.
What? Did you actually think that was real?
I don't know. I'm trying to get through this before I leave. Interrogation is not
sounds like a you problem, girl.
All right. So interrogation is not just questions. So it's questions or its functional equivalent, reasonably likely to elicit an incriminating response. And they're going to cite the case in this next section. We heard about them saying, oh, he just blurted stuff out, but then the officer said some words. We also heard some words being asked and questions being asked at McDonald's. So we're going to get into all that. And the one thing that protects the prosecution no matter what is volunteered statements. Those are, oh, he just blurted them out. Miranda doesn't come to that. And because they're not compelled and there's no compulsion. So you'll see the judge, drawing the line at custody and by minute here. So
listen, kids, if you're taken into custody, just don't puke shit out. It's coming in. If you just offer it up, it's coming in. All right. You want me to read since you might have to dip? It's only 2 pages, but
yeah, because I got to dip in 2 minutes. So I don't know. You'll just discuss it. Yeah. All right.
Okay. So defendant's statement to law enforcement, a defendant's statement obtained through custodial interrogation and without Miranda warnings must be suppressed. However, quote, any statement given freely and voluntarily without any compelling influences is, of course, admissible in evidence. Miranda v. Arizona, 1966. See how they have that U.S. thing there? That's how you know it's federal.
Right. And I just
Okay.
want to say in typically like they call it like a spontaneous statement or a spontaneous utterance. I think they have like a different word for it here in New York.
Yeah. So volunteered statements of
Volunteered
any kind
statements.
are not barred by the Fifth Amendment. The Miranda safeguards do not come into play unless a person is in custody or unless a person in custody, quote, is subjected to either express questioning or its functional equivalent. And that's Rhode Island v. Innis. And that is another federal case, 1980. Also see People v. Farrow, and that's a New York case from 1984. So to determine the admissibility of a statement given without Miranda warnings, a court must determine, one, whether the person was in custody, and two, whether the police questioning constituted interrogation. See People v. Cabrera, a New York case out of 2023. So to determine custody, a court must find that, one, a reasonable person innocent of any wrongdoing would not have believed that he or she was free to leave. And two, there has been, quote, a forcible seizure, which curtails a person's freedom of action to the degree associated with a formal arrest. Interrogation is defined as any questioning that is reasonably likely to elicit an incriminating response. People v. Paulman, 1980 or 2005. That is another New York case. Like if they ask you your name, that's not going to be theoretically, depending on the crime, I suppose, eliciting an incriminating response. If they ask you where you were at, where you were coming from, then it shifts. Then those are things that could incriminate you, you know? So it's like, look, in my estimation, just read Miranda immediately. There's never a circumstance under which a cop shouldn't just read it, because if the person is going to be the type of person that's going to talk, they're going to do it whether you read Miranda or not. Meaning that I think most people understand at a base level that you have a right to remain silent. But when you get into the throes of an arrest and you're brought into a cop shop, everything changes. Everything is heightened in terms of the human response. It's a very anxiety-inducing situation. People are going to feel a certain type of way. And, you know, to me, if you're a cop, like, because the argument from the cop side is like, well, look, you know, like, I want to just like kind of get into some, like, you know, real casual shit, not even talking about anything relating to the crime at all, in order to get this person just talking. And if they're just talking just based on this bullshit that we're shooting back and forth to one another, and they happen to puke something out, good on me. You know, that's on them. It's going to be fine. So, you know, it's a tough situation with these types of, you know, these are always such a difficult legal analysis, you know, and it really goes judge by judge. That's why I'd like to see a more even split in terms of defense attorneys and prosecutors on the bench rather. But, you know, I mean, it is what it is. So during the initial interaction at McDonald's from about 9:29 a.m. until 9:47 a.m., I find the defendant was not in custody. Only 2 or 3 officers approached or spoke with the defendant. Only 2 or 3. If you've ever been in a situation where you've been pulled over and the first cop comes to your window, knocks, say, I need your license and registration or proof of insurance. You're like, oh, okay. You know, you're going over there in your glove box to get it. And then all of a sudden, another cop shows up on the other side of the window. It changes the vibe completely. And then if a third one shows up, I mean, do you really think that you can leave? do you really, is a reasonable person going to think that they can leave that situation? I don't think so. So only 2 or 3 officers approached or spoke with the defendant. The interaction occurred in a public setting where the defendant was eating brekkie, and there was no indicia of custody. The officers did not display their weapons, employ physical restraints, or engage in any conduct that would lead a reasonable person, innocent of any wrongdoing, to conclude that he was not free to leave or under arrest. I call bullshit on that. I don't think that any one of you in chat, if you had 2 or 3 cops walk up to you, no matter where you're at, especially in a public place, and they basically surround you and they start asking you questions, you are not going to believe that you are free to leave. Now, if you have the wherewithal to ask, hey, am I free to leave? That changes the analysis. But in this situation, that didn't happen. So you're left with what's reasonable. What is a reasonable person going to think in that circumstance? I just disagree with the judge here. I think that it's a show of force. 3 cops is a lot of cops. And for the average person who very rarely, if ever, has had interactions with police, it's a very threatening, intimidating situation. And you're not going to feel that you have the ability to be able to leave. That's just the way I feel about it. No one's ever changing my mind. So therefore, any of the statements made during that period will not be suppressed. We've got a footnote. To the extent that some of the questions concern the defendant's name, address, and date of birth, statements in response would be admissible in any event as pedigree information. See People v. Wortham, a New York case, 2021. So the analysis is different, however, once more than 8 officers. So there's the line. So once there's 8 cops there, well, then you're not going anywhere. It's clear, right? So once more than 8 officers arrive at the scene and surrounded the defendant, such that a reasonable person would not believe that they were free to leave, the officers positioned themselves in a manner that effectively encircled the defendant and controlled the immediate area, creating a police-dominated atmosphere. Their presence and positioning significantly restricted the defendant's freedom of movement and foreclosed any avenue of departure. See Cabrera, New York case, and Boyle, another New York case. So under the totality of the circumstances, the court finds, as established by the video evidence, that at this point, at about 9:47 a.m., the defendant was in fact in custody. Therefore, the responses given to the officers' questions that were interrogation or the functional equivalent, including Fox asking why the defendant had lied about his name, Fry also asking why he had lied, and Fox asking if he had a fake ID, will be suppressed. However, the responses to Detweiler and Fry's questions about the defendant's real name, his date of birth, and his middle initial will not be suppressed, and as they are admissible as pedigree information. So after the defendant was given them, oh wait, there's a footy there. So additionally, defendant's questions and statements to the officers, quote, calling a couple more cars, and this is a puffy jacket. I'm not very big. And can I ask why there's so many cops here? Will not be suppressed, as they were spontaneous and not in response to police questioning. Yeah, I mean, doesn't that there's a lot of cops here. Is that what time's that? Is that like the 3 cop situation? Obviously, if he's asking if more cops are coming, and we know it caps at 8. So, I mean, he didn't feel like he could leave. So, but they consider that shit to be pedigree anyway. So that was their workaround. So after the defendant was given the Miranda warnings at 9:48:32, he shook his head when asked if he wanted to speak to the officers, and asked again why he had fake ID. The defendant responded that he was going to remain silent. Those responses are of course not admissible. So 11, footy. Similarly, the defendant's response to the question about whether there was something in the bag, quote, just going to remain silent, is not admissible. There you go. There you go. That's how you do it. I'm just going to go ahead and assert my 5th here and shut it down. So, however, his responses to being asked to stand up for a frisk, if he had any weapons on him, and responses to follow-up questions about the pocket knife are all admissible as responses to safety concerns and related questions. See People v. Johnson, New York case on 2007, and People v. Hartley, another New York case, 2002. So further responses to questions from Fox about his name, to McCoy about where he was from and to Burns about his age are all admissible as pedigree information. Defendant also made statements to 2 Pennsylvania correctional officers, Matthew Henry and Tomas Rivers, who are monitoring him while he was being held at the correctional facility. Both Henry and Rivers testified at the hearing, and I find them to be credible witnesses. So did I do 11? Oh, no, I did 11. So Henry's testimony was uncontroverted, that he did not ask the defendant any questions or attempt to elicit any information from him. And I find those statements to be spontaneous and therefore admissible. Officers Rivers and defendant engaged in casual convo on various subjects. That's exactly what I'm talking about. Just shooting the shit. And again, the defendant's statements were not made in response to questioning or interrogation. And I find those statements to be admissible as well. So this constitutes the decision and order of the court dated May 18th and signed by one Gregory Carro, judge of the Court of Claims. So there you go. There's that guy. And, like I said, kind of midway, I put the cart before the horse a little bit. I consider it to be a Pyrrhic victory, meaning, they were given some breadcrumbs. They won and had some stuff that's, going to be suppressed that is in no way damaging to the government's case. I mean, they have plenty of information. I mean, the notebook with, his incredible statement in there, that's really all you need, but they got more on top of that. It's like, I tweeted about it yesterday. I'm like, the poison pills, the poison daggers, the government still got them. What was suppressed is not going to damage their case in the least. They have more than enough to be able to get a conviction on this, in my estimation. So, it's one of those situations where, because obviously the trial court doesn't want this thing to get reversed on appeal. And to me, I think there's going to be, if he is convicted, there's going to be a legitimate argument as to that red notebook. I don't know, especially in light of the way that the judge did that thing that I was talking about just a little bit earlier, wherein he's like, okay, well, I hear what you're saying in terms of looking for the bomb, but all your other inactions belie what you're saying to me, or belie what you're saying why you conducted the search. It's just, it's not making sense, because it's the same thing when it comes to that notebook, and especially in light of the fact that they're searching for the warrant, or they're going to get that search warrant. So, I don't know, man. It's interesting. It was, and I find New York to be a real bastion for the Constitution, typically with the court system out there. And with juries, you saw it with the Weinstein thing. It's like, everybody knows that guy's a creep. The dude's like an uber creep. He was like the casting couch nightmare. And they're bringing cases. They continue to bring cases against him. And, they're getting mistrials. They're getting NGs on some of his cases. Like in New York, typically I find that they follow the law for the most part, but they'll make concessions. You can have a piecemeal decision like this where it's granted in part and denied in part, and they're, carving out the shit that's not going to be a death knell to the state's case. And they're going to deny, they'll grant rather, and they'll deny the stuff that they know is going to allow the state to get into court and meet their burden, or at least give them a fighting shot at doing it. They're not killing the case. So, which is exactly what happened here. Just absolutely exactly what happened here. So, as far as kind of landing the whole thing, the scorecard heading into the trial in September, and it's coming. It's coming. Just the bottom line, they suppressed the Mcdonalds search, the physical evidence. So that's the magazine, the phone, the passport, the wallet, the chip that was found, and the thing that they opened with the knife, and the unmirandized custodial statements about the fake ID. And then surviving and going in front of the jury, the gun, the silencer, the notebook. pedigree statements. This is who I am. The safety statements and the spontaneous remarks. And of course, anything that he said in the jail. So, so at the end of the day, look, it's a partial win for the defense that trims some edges, but it leaves the heart of the case right there for the government. The single most important thing to understand about this is the McDonald's search got tossed, but the gun was found at the station inventory search, and the inventory search is upheld. That's it. Bottom line. So the firearm and the notebook, those come in, and those are going to be probably the two pieces, if you're thinking about it just on its face, are going to be the two most powerful pieces of evidence in the case anyway. Even if you brought in the rest of the stuff, the magazine, the phone, the passport, the wallet, the chip, depending on what's on the chip. But the gun and the notebook, incredibly damning stuff. So, I think that wraps that. And if you have any comments, leave them in the chat and make sure that you like, share, and subscribe. All right. So if you're wondering why I did that, if that seemed a little bit weird, it's because what we're doing is we're actually going to take this live. We're going to carve it into two separate videos that because we're trying to up the amount of content we have. So basically I'm taking this as a break in between Mangione and Murdaugh, where I'm going to talk a little bit to you guys, tell you I love you, see if we got any comments here. We got a few. We got Luigi Pepperoni. We got Grooves in the Heart, D-Nice, gifting 5 DD podcast memberships. Thank you a million times. And then D-Nice to me comes back with 5. If this first search was considered not a good search, then how can they try them? Well, I hope you understand, because you asked that pretty early. I hope it's making more sense now, right? So the first search really doesn't have the stuff that is the damning stuff. So meaning the notebook, the silencer, and the gun. That was found in the inventory search, which, agree or disagree, the court found that that was a valid inventory search, including the fact that, this one cop's in there taking pictures of every page of the notebook, probably reading it. Oh, shit. Oh, my God. This guy's Ted Kaczynski. They found what they found. At this point, it's going into evidence at trial. It's coming in. If he's convicted, they take it up after the fact. And we all know how that is. Trying to undo a conviction, it's hard. It's very, very hard. So I hope you're clearer on that, Denise. I hope that we explained it enough. True Crime Pulley, member for 20 months. OG, glad to catch you all on live. Hey, we're glad that you caught us as well. Yeah, we're so sporadic with when we start these times. It's just, there's no rhyme or reason. You know what I mean? I know it's crazy, but that's how we roll. That's how we roll. Yeah, I'm definitely a weird one. Ooh-wee. Never going to change. If I'm as old as I is be, it's never going away. Can't teach an old dog new tricks. And weird Bob, it's good Bob. So, all right. So a couple of announcements. I'm going to try to kill as much time because I want my partner in crime to make it back before I start Murdaugh. If it gets a little long on the tooth, then I'll do what I got to do. So I want to remind everybody that on Saturday, we are having our Aaron Spencer live. I expect to see a hell of a lot more than 252 people. No offense to you beautiful people that are in here. We love you, but we want to get a big crowd in there because we're going to go 12 hours starting at 10 a.m. Saturday. Got some great guests lined up. I've got David Yanetti's coming. I've got Mel and Rebecca, who I love. They are coming. Who else did I get? I got a bunch of folks. I tried to get Peter. He's going on a cruise, lawyer, he'll usually come and hang, but he's doing something way more fun than hanging on live with us. So he is gone. Who else do I have? I'll give you guys a little preview. Ian's going to bump in. We're still waiting to hear from Mel. I'm sure if she's not traveling, which It's a distinct possibility. Melanie loves to travel. She will come in, and because like I was trying to focus on creators that have given some time to the Spencer case, and everybody that I'm bringing on, as far as I know, and I did a check through YouTube to see who was going to be doing it. Of course, Runkle. Runkle's my boy. So Runkle will pop in. I didn't nail him down on a time, but he's definitely going to pop in because he's available. But still wait on Mel, Tony Bruschi, and Robin Dreek. I'm with them every Tuesday. They are big supporters of Aaron Spencer. So I'm excited to have them on. The one and only Nick Starro, he will be on with us. And then I try, like brother counsel, I reached out to him. It's a Saturday. Doesn't work with his religion. They are, I think he's Orthodox Jew. So Saturdays are verboten. It's Shomer Shabbos. I don't roll on Shomer Shabbos. Oh, by the way, anybody get the 9 times quote? I wasn't looking at the chat. I was busy. Did somebody get it? Did anybody get it? 9 times. 9 times. Tell me in chat so I don't have to scroll through, and let me know if somebody got it. Yeah, I'm reaching out to Broken too. So Broken will be here. And I'm putting some other folks together. And Heather Spencer, Aaron's wife, is going to join us. As to the time, I'm not sure when, but she's committed to coming on, and you guys can meet her. She's a lovely, lovely gal. And I'm excited about seeing her on the live. So that's great. I haven't seen her since the last time we were in Arkansas. So everybody mark your calendars, 10 a.m. to 10 p.m. Open your pocketbooks, open your hearts. They really need the help. It's expensive. A murder trial is expensive. It just is. That's facts. Hiring experts. And we know with the recent rulings, experts are coming in. The old judge, she was denying a lot of stuff. And then we've got, the new judge, who's obviously far more reasonable and not biased. So that is excellent. So keep your eye out. I'm going to keep posting, and I'm going to keep reminding people that this thing is going on. Tell your friends, tell your neighbors, because we want to have a big crowd in there. Let's raise some money for these folks, and it's going to be going directly to them. They have a what is it called? Go, Send, Go, Fund, Send, Go, something like that. But what we're going to do is we're going to have their QR code. So I'm not going to be touching any of the money. It's going to go straight to them. I think I was talking to Heather today about additionally also making just their Venmo, Cash App available, because they do take a fee through those crowdfunding apps. Give, Send, Go. Thank you very much, Classic. Appreciate that. So yeah, again, mark your calendars. You can pop in and pop out. This is a pop in, pop out situation. If any of you people are psychotic enough to sit with us for 12 hours, I'm going to be on this ball for 12 hours, maybe. I might have to switch to a chair. I mean, the ball is very good for the core, though. Oh, yeah. Once you get used to the ball, the ball chair becomes like the only way to go. It's the only way to go. So, yeah, I'm excited about that. And it'll be a great day. It'll be a great day. I had no idea that it was Memorial Day weekend. I'm like, isn't that always at the end of the month? Because I was texting Michael and Linda. I'm hoping to get them on. I didn't know when I said it. I was wondering why we didn't have any games. It didn't dawn on me for the softball thing, because we usually have shit on the weekends. And I'm like, wow, there's no games. I'm like, it's perfect. Saturday, we're a month out from trial. We're a month out from trial in that case. So they need us. They need our help, y'all. They need our help. And they deserve our help. And it's one of those cases, It's like there's all types of cases that I think exemplify the importance of defense attorneys. And this is like a whole different set of facts, right? Completely different set of facts than, say, Karen Reed's case. Completely different set of facts. There's a lot of times when, the attorneys for the defense come in and it shows you all the different ways on how important defense attorneys are. All the different situations wherein you can get caught up in the system and you need somebody that's going to go in there and fight like hell for you. And that's what Aaron and Michael are doing for Aaron Spencer. You know, Aaron Casanelli. I love her. I've been trying to get her on. She's hard to pin down because she's busy. She's busy, but she's a great lawyer. They both are. You know, he's in very, very good hands. You know, notwithstanding that, it's still somewhat terrifying because you never know what a jury's going to do. You know, it's like we can all sit here on this side of it saying, well, common sense, there's no way a jury will convict. You never know what a jury's going to do. It's a very, very scary situation. And that family has been going through it for a long time, starting before Aaron was arrested, starting with the assault on their daughter. You know, it has been going on a nightmare scenario for a long time for them. So, you know, and there's been high moments. Aaron runs for sheriff, wins the primary. Feel pretty confident he's going to win come November in the general election. You know, that's a high moment in a dark time. But, you know, the waiting, the impending trial. I was talking about it. I don't know who I was with yesterday. Oh, I think when I was on Aiden shit, you know, people underestimate the process as part of the punishment, meaning the period of time from arrest, waiting until trial, where you got to go into the courts every 30 days, every 45 days, step in front of the judge for a status. You know, walking into that building as a defendant makes your heart start pumping. You know, every day that you're in the shower, you're thinking about, oh my God, you know, am I going to lose my freedom in like 6 months? It never is not there in your brain percolating. You know what I mean? So it's heavy shit. It's heavy shit. So just think about that. Are you guys even listening? All my mods are chirping back and forth. Tell you. So it's 10 p.m. Central Time. Okay. I would think that you guys would know at this point. We are Central. I am a Chicago Bears fan. Always know that. Chicago is Central Time, which means it's an hour later for you guys on the East Coast. I mean, my wife, who you guys know I love to death, who grew up on the East Coast, who has lived in Illinois for the better part of 25 years, still cannot remember if the East Coast is ahead of us or behind us. It's amazing to me. It's amazing. It's like she's got a literal block in that big giant brain of hers as to time zones. I think it's a thing, though. I think it's like a real thing. I think that there's people out there that just don't like the time zones. Yeah, look, my admonishment here does not apply to people overseas. You guys all get a pass. Like, that's a whole different thing. That's a whole different thing when you're converting. I mean, all I know is England is about 6.5, 7 hours ahead of us. That's it. But if you're in the US, I'm sorry, I put you on notice. Y'all need to learn your time zones. It's not that complicated. If you're on the other side of the pond or down there, you're good. You're good. Like, you know, it's I'm curious, when you guys on the other side of the pond, when you go into the tubes, when you see it, it gives you the countdown, right? Like, once we set the live, it'll be like, oh, you know, 3 days, 24 hours, or 3 days, 23 hours. So you could see that, right? But I know that not everybody gets their notifications. Like, you got to make sure that you're hitting, like, on the page, you go to that bell and you click the menu so that it pops up and it says, you know, it gives you options of what kind of notifications you want. So in the other way, which is frankly the better way to always get notifications when we're going live, is you simply go to the Seeking Justice Discord page and sign, like, if you become a member over there, like, you'll always get notified. It's like clockwork. It never misses. There's never, oh, I didn't get a notification. And it happens immediately. Like I get them all the time on my Discord, like a bloop. Like anybody that on any channel that I'm following in terms of me being a member over at Seeking Justice, anybody that goes live that I'm following that Seeking Justice has, and they've got a laundry list of different channels. Anytime they go live, I get immediately I get a notification that they've gone live. Pops right up on my phone. So if I'm sitting there like a mutant, just looking at my phone, like we all are, I know it. So that's exactly where you need to go. Exactly where you need to go. So, I have to remind you guys. This is very, very important. It's very, very important. We have created a buy me a pizza, also known as a buy me a coffee, for our mods that you guys love so very much, who make this community what it is, who are here day in, day out, who make the chat safe for everybody to come in, who are wise enough to allow what we want to happen in here, which is civil debate. That all goes to the mods. So you can give them a little love by just shooting them a dono. Say, hey, you know what? Thank you. Thank you for making this an awesome place for us to hang out for 2, 3, 4, 12 hours. That's all them. I'm not looking at shit. I need you to understand that. Oh, my guy. I have a great grin for me story, but I'm not going to tell you all. It's a secret. But at any rate, I'm like so indebted. Allie and I are so indebted to the mods. I really appreciate if you guys give them some love. No matter how much it is. They split it up. Whatever they get, the end of the month, Tracy handles her business. All of our beautiful mods get a little something, something. And, it's nice. It's a nice thing to do, because this, when we're huge, when we're where we should be, which is 500,000, and I'm not kidding, I watch a lot of content. I watch a lot of channels. I really do. And, I think Allie and I are pretty good. I think we're a pretty good channel. So, I think we're going to get there. I don't know how long it's going to take, but, when we get there, obviously I'll be throwing money at the mods, but we're not there yet. So I have to grift for my mods because they deserve it and because they're beautiful humans. So, all right. So yeah, I'm sure Trace has been throwing it up there in the chat. Give till it hurts. You know what I mean? Give till it hurts, because it really, really means a lot to me, and it means a lot to the mods as well. So yeah, Grin. Who the fuck wants a pizza? You do. You want pizza. You love pizza. Welcome back, Grin. Glad to see you in here, man. Ash and Sugar, 55, member for 3 months. Better late than never. Guess I'm on the replay crew. You know what to do on replay crew, right? You know what to do. Got to leave a comment. You have to leave a comment. Get that thing in the algo. It helps. It really does. Really does. Green comes back with a $2 holla. Tell all my secrets. I don't care. Can I tell that story? Can I tell the story? I don't know, man. I think we need to think about it. I think we need to, I'm not trying to compromise my boy. Makes me nervous. Just I don't know if y'all know Grin's Army Ranger, like active Army Ranger, out there kicking ass, taking names, and protecting us. Literally. Last time I heard from Grin, he was literally sitting on the Strait of Hormuz, protecting us, protecting our interest over there. Dude's real McCoy. If you didn't know that about him. So, and as you all know, I have mad love and respect for our soldiers, past, present, future, all of them. I have huge respect for men and women that enlist and put their life on the line, literally. So that's a big thing. Oh, yes. And as Allie says, hype on replay. Her shit is like real. So Grin comes in, he says, if he's saying it, he's saying it. So Bob and I have smexy texts back and forth because I had a buddy in text sniff out all his active phone numbers. I was active in sending vids to Bob of where I was. True story. It was crazy. It's crazy. It was crazy. He was sending me his like location. Like, you know, like this is where I'm at. I seen it. It was crazy. It's crazy. And you know, that's a hot zone. Some shit going on over there. He's in the shit. Army Rangers are in the shit. You know, I mean, as Grin told me, he's like, look, it's like, my job is I got to be anywhere on the planet within 16 hours ready to roll. Think about that shit. That's like some intense shit. Yeah, Lucy's coming. I've got to. I saw Lucy posted like a love note, some kind of love note, like telling me to stand down, saying I'm not lying about shit. I'm not lying about a damn thing. Not a thing. And I'm going to tell the other side of the story. I'm going to tell the other side of the story about how, because that's where it got interesting, you know, and like, I really just want to help the woman, you know, but she gets things in her mind and just will not let it budge. And, you know, the Smith family are just really nice people. And Sean Smith wants to help her and isn't asking for jack shit. Like everything that she has always said about him and wanting money and blah, 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 or me wanting this or what. I didn't want shit. I went 3 years without even talking about the woman or mentioning it other than the TikToks, which were approved by her. So, Grin says, show him the vid, Bob. You can't dox me by showing it. I'm not worried and can't get in trouble. I'm a volunteer. I got no way to get it up here. Well, let me see. Are you talking about the thing with your location? Because this is a good way I can kill some time so Allie can get home from Murdaugh. Let me see. Let me see what's what here. Let me try to find it. Grin, you're buried. You're buried. I remember the area code though. So when I see it, I'll see it. There it is. Oh, my girl's back. All right. Let me see her. I'm going to send it and then I'm going to throw it up. Show you what our boy Grin for me does for all of us. See what you guys think about this. So this is, so we're literally driving to Iowa for the softball tournament 2 weekends ago. And I get this strange text. And I'm like, who the fuck? I'm like, who this? You know, and it's got the Bob, the BAHB. And only our community calls me BAHB. That's it. No one else. So I knew that it had to be somebody from the community. So I'm like, who this? He's like, it's Grin. And he tells me the whole story about one of his fellow Rangers, like big tech guy who can pull up anybody's phone number, no matter when in time they had it. Like there was a whole thing. Like he's like, is this really you or am I talking to some douchebag? And I'm like, it's me, bro. It's like, it's me. I'm like, my kid's name is Scout. He's like, all right, it's you. You know, but then like, I think like the next day, like one of your buddies hits me up. He's like, hey, yeah. But Grin's like, I've been playing your channel to all my, with all my boys and we love you guys. And, it meant a lot to me. It was we had a really nice chat. It meant a lot to me. So, especially coming from somebody who's out there in the shit doing what they do. All right, all right, I'm going to send this. I'll pull this real quick. We'll put it up. It's short. It's a shorty. I heard my baby's back home, so I'll let her take care of what she needs to. She'll get planted, and we'll start with part 2, Murdaugh. All right, let's see. Let me get into the old. All right, there it is. It's loading. It's still loading. Shit's coming from Iran. It's going to take a minute. Just kidding. It's just on the phone. All right, let's see here. Okay. All right, so the question is, how the fuck do I get it out of my mail thing?
Okay. Save the downloads folder. There we go.
All right. I think I'm making magic happen, y'all. It's exciting. It's exciting. Watching the magic happen on Defendants Diaries. Okay, hold on. Oh, yeah. Oh, look, she's snarfing something. What are you snarfing? Daddy's hungry. Got a little snarfing? What's going on? I need a water, by the way. I'm parched. Got 2 dead soldiers here. Dying of thirst. All right, hold on. Please hold. Please hold. Okay. Okay. Oh, yeah. Oh, yeah. Oh, yeah. Okay. Cool. Cool. All right, this puppy should pop up. Woo-wee! All right, I'm making it happen. I feel like so accomplished right now with all this tech I'm doing. It's so awesome. All right. Share screen. Okay. Boopy doop. Boopy doopy doopers. Window. All right. This should work. Share sound. All right. Let me know if you can hear this sound because you don't want to miss Grin. If you guys remember back when we were doing the voicemails, you guys know the quality content that Grin shares with us. All right. Share that guy. All right. So after I figure out it's Grin and he tells me how he got to me, I'm like, all right, cool. So he tells me where he is. And then to prove it up, Allie and I are lawyers. We like proof. He fires this thing over to me. So this is it. Tell me if you can hear it.
Bob, I want to record this. I don't know how else we do this. This is my phone.
You guys, can you hear it? I thought he was wrestling with a lion right there. So he's going through. Gives you location. Hot as balls, 97.
In the microwave. You didn't do that for you?
Oh, yeah. No, I'm good.
But I was wondering how you were handling this.
You guys see this? Is that you making that? It literally sounds like like you're hanging around like a lion. You guys hear that shit, right? That's not me or my stomach. All right, so here's where he is. You can see his location right there. Wow. See? There it is. There's the straight right in there. I think Grin just does an incredible lion imitation. I think that's what's going on. What is he saying? Has he given me an answer? Are those like actual animals? Babe, you hear that shit? I didn't hear this in the car. He's like, where's this piece of shit at? Also, my guy just learned to drag and drop. Do you hear that screeching bird? Wow. Maybe that's just Grin's voice and super slow. Right. I just figured that out. Wait, hold on. Did I mess with the, like, how do I change the speed?
You don't tell Delta what to do. They tell us what to do.
Oh, it was him.
Here we are.
Boom. So,
Wow. I think you had that messed up when we watched it. I don't remember the sound.
no, like I didn't do anything when it went back to normal. It was Grin.
Oh,
That was Grin's tech wizardry. I didn't touch shit when he went back to normal. So pretty amazing shit. Pretty amazing shit. And then like all of a sudden, we're in the, like he sends me this Eurythmics I ask him a question. He like in response, he sends me a yeah,
Bob,
you literally sound like a lion.
Bob and I were trying to find the code. We put the song on. We're like, he's speaking in code.
He sent a
Yeah.
we're sending it to friends. We're like, what's the code of this? Like, what does he mean by this? Yeah, oh yeah, we definitely did.
Doesn't sound right at all.
I was trying to figure some shit out. You know what I mean? Yeah. So that was amazing. But at any rate, like 3 minutes after this, he's like, "Yo," he's like, "Shit's popping. I gotta go. I'll talk to you in 2 weeks." I'm like, "Hello, Grin."
We were listening to the news, like, what's happening?
He's like, we're either gonna be on the news or we're already on the news because shit's popping. I'm like, wow. So that was amazing. It was amazing. So there's a little intel on our boy, in case you didn't know.
Yep.
Badass extraordinaire. Grin for me. All right. I killed time till you got back, babe.
I know. I heard. I was like, how's he gonna do this? And then 47 like backed up big time. I'm like, what's going on?
No,
I live in the middle of nowhere.
You know, I can like, dude, I'm gonna do 12 hours on my head. It's just gonna be easy, sis. The question is, I'm starving. Have I eaten today?
No, I just said like when I ran in and you called me out, I threw one of those horrible pieces of pizza in the actual microwave because I didn't have time for it to heat up in the,
You know what would be
oven.
awesome? Like if you could kill time and I could go, oh, hi, buddy.
What am I killing time about?
So I could go like cram something in my pie hole.
All right, I'll kill some time. Give me something to talk about.
I'm picking out a thermos for you. Do you have any final thoughts on the I explained to the kids that we're making like two separate.
I heard. Go ahead, go get something to eat and I'll look at people's chats and I'll come up with some stuff to talk about. Wow.
Okay.
All right.
I'll be back.
Yeah, Tiff, it was Bob's stomach. Yeah, I got this. Yeah, I was so very unclear. I mean, is that like a true thing here about wait, why won't it let me click on this? That if I play it backwards, it's Purple Rain, or that's just a joke because it's the upside down smiley face, so that sounds like it's just a joke. But I don't know. Do I have any final thoughts on Mangione? I mean, I was listening. It seemed like Bob covered them all the possible thoughts that I could have had. You know, he's pretty smart like that. But one thing I was thinking is how crazy it was that Bob didn't realize he picked Memorial Day weekend and everybody's, going to be away. I just heard from Andrea Burkhart, who's like, she's hoping that she will be out of range on her adventures. So far that she won't even have a signal is what she's hoping for, and we hope that for her. So I heard him tell you that Peter he's traveling. So everybody's got stuff going on. It's, one of those weekends where, especially people with kids, they go away with their kids, but we'll make it work. We'll figure it out, and we'll just, push you guys to actually donate extra since so many people are not available. I don't know. That's my thought on it. I was actually texting Bob, like from the car. Are you sure you want to start Murdaugh now? Kind of hinting towards like, let's just save Murdaugh for another day. But then I heard him talk about it, so I was like, okay, I guess we're doing it. One thing I didn't hear is Bob had asked about if anybody had gotten anything with that 9 times, and I was watching the chat at the time he said it the first time, and nobody guessed the movie. But I don't know if you guys since have, because I was driving, but as I was listening, I didn't hear Bob say anything out loud. Yeah, Amanda says that it was their holiday yesterday in Canada. Well, there you go. There you go. And, like school ends a lot sooner out here in the Midwest and starts sooner as well than it did on the East Coast. Then, like, we were still in school at this time. Grin for Me says, haha. So I had like 8 guys over my shoulder watching me, and they asked what my icon was. So I sent that. Then somebody took some pop shots at the U.S. vessel in the strait, and we all ran outside, and I forgot about Bob. Hashtag feed Bob. Yeah, we were pretty worried about you. We're like, oh my God, he really did just drop off, and like something, is he okay? You also, I don't know if Bob said it, but you sent your text at the time, go back and look at it, was like, it's this whole, like, you might not hear from me, and if something happens to me kind of text. And we were like, what's he saying? And it like ended with, remember, I love, and then it just dropped. Or I did, I don't know. It was like, is he worried that like he's not going to be coming back here? Like, that's the last thing he ever said. Who we have to share this with? But you're here. It's okay. You survived. And as Bob said, very brave. So yeah. Yeah, it was crazy. I mean, we really were listening to the song lyrics. We're like, he's speaking in code, giving us state secrets. I'll watch for your chats in the regular chat, Grin. You have to keep spending all this money, sending us money left and right. So Patty asks, are you and Bob still planning to meet Runkle in Chicago? So I think Runkle's staying with us. Bob is planning on doing the meetup with Runkle. I think, I'm not privy to these conversations, but I am not going to actually be able to be there because the next day is our granddaughter's birthday, and I had plans with my son and daughter-in-law to help set up various things and do this or that. And so you'll have Bob, but not me. Oh, is that what he said? He said, remember, I love bad. I don't know if that last part came through. It was like, I think Bob was reading it to me as remember, I loved, like with a D at the end. So I don't know. Maybe he was misreading it to me. Oh, it was voice to text. Yes, we do have a granddaughter who is about to turn 2. Yeah, I'll miss you guys too. So that's pretty exciting. Kind of, like even when you have kids, you wish you could do like this whole like, yeah, I just want to press that rewind button for a minute and kind of do a little bit of this again. Like 2 she's already grown up. I keep trying to get her to say, Mommy, I want a baby sister or brother. I'm like, oh, you know what? Tell Mommy what a good big sister you'll be. My daughter-in-law is not ready to have a second yet. And my daughter is fighting me on, she wants more time before she's got to give me grandkids. But I got one to spoil. So, but when my daughter has one, I'm just going to keep it for a while. Keep him or her for a while. Like, okay, you go rest now. I've got it. You're much it's much easier to monopolize when you're the mother of the mother than when you're the mother of the son. It just kind of works out that way. I could just force my daughter to do whatever I say. Not really, if you're listening, love. See, this is what Sharon says. I'm not going to give grandkids. Oh, you're not going to have grandkids, or if you have them, you're not going to. Maybe you're saying you're not going to have kids to give to your parents. Oh, I thought you were saying like when I'm not going to let my parents like have the grandkids um, for extended periods of time. Ain't so plain. Jane says she's going to be in Chicago this weekend. I can't justify going down 2 weekends in a row with these gas prices. No, that's for damn sure. That's for damn sure. Yes, classic overthinker. I absolutely agree. I mean, it's not all about the parents. Think about the grandparents. Maybe Megan, maybe not, says, okay, nobody told me because why does my son not give me the baby? I mean, that's what happens. Like, it's more with the mama's mom. Just kind of works out that way. I know, you're right. The pressure isn't fair, but my daughter says she's going to have kids, so I'm just trying to push it forward. If she had said like I don't want to have kids, then I absolutely would not pressure her. I'd just keep it in my head like, oh no. But I got two other daughters, but I don't know how old I'm going to be by the time the other two are going to have kids. I mean, Scarlett's 14. I'm going to be old, like so old and decrepit. I won't even be able to do anything. Mm, hmm, yeah. Well, Ashton is lucky enough to be helping raise two of her six grandkids. They're with her every day. I would so do that if the kids let me, but they kind of have it worked out, where mom's home with the baby, who's not a baby anymore, toddler. And then when my son's off because, he's like, I don't know, if it's like 4 days on, 4 days off at the firehouse, um, then he's with her and I'm like, "Wait a minute, wait a minute. You guys are, still somewhat newly married. You can't split your time like that. When do you see each other? When do you see each other? It's very important not to just be like, all right, I'll be home when you're working and you'll be home when I'm working. You're skipping a step there, a very important step there. Time for mom and dad together, you know. Yeah, Sharon's like, I just don't like babies. And that's some people's jam and it's nothing wrong with that, you know. But I love babies. Um so uh but my daughter actually did, my oldest, for a period be like, I don't know if I want to have babies. And now I kind of take it back. I did sort of pressure her, even though she said that in retrospect. But I don't think it's her present position. Maybe I'll have to talk to her and say, although I give you a lot of shit, I'm not really pressuring you. All right, I'll take your comment to heart there. I'll have to have a little discussion with my daughter that I'll forgive her and still love her, even if she doesn't give me grandkids. But I won't say it that way because that basically says, like, dude, you got to give me grandkids. Um, you know, Ain't So Plain Jane says, I thought about it a lot, and one child would be nice. I heard you have to find someone to be the father, though. No, you don't. There's banks for that these days. You got to find one that you trust because then you'll end up like that documentary where there's like, I don't know, 700 siblings because they keep giving the same one guy's gene out or sperm out, or like the doctor's like, I'm going to give everybody my sperm and I'm going to populate the world. That happens. Shit like that happens. I don't know. You know, it's a thing. But I mean, this is I wasn't signed up for this. Like I thought Bob was gonna be gone like a, a minute, you know, not like 20 minutes. I don't know what I did. So like I was running and trying to like rush around, and then like the dog needed something, and I like somehow dug my nail or scratched my finger, uh, and now it hurts. It's like feels like a paper cut because that's what it's like, even though it wasn't on paper. But yeah, he went for a snack. Oh, but then MBW is like, you know, he had to poop. Yeah, I mean, everybody poops. It's possible. But I think he had difficulty finding a healthy snack, which is what I did. Why I just grabbed pizza my father-in-law ordered last night. But, you know, I don't know, Bob. I don't I don't know if he really actually has ADHD, you know. What? You see the guy Eaton interviewed. Oh, I thought you were saying like this happened to Eaton. Somebody Eaton interviewed, took his twins to gymnastics and hasn't seen them since. Been over a year. See, how do some kids just like disappear, and with all the possible avenues to hear about this information, we don't hear about it. But, you know, Gun 3 was the whole world was looking. Twins just disappear from gymnastics? No, that's not right. That's all right. Give us some more. Give us some more Trial World TV. What the hell is going on? And why are we just hearing about it now? That's what's weird. I think people are saying saw that last night, meaning this. Wow, Bob, we can hear you.
Huh?
Yeah.
What?
Whatever, you know.
You can hear me snarfing?
Yeah.
Oh my God. The whole time?
No, just that second that I said it.
Oh yeah.
Yeah,
Sorry.
put your muted. He's been muted. But let's see. Could live off quesadillas. I mean, quesadillas are good. Absolutely. I could probably live off them too, especially if there's some guacamole in there. I need guacamole on everything. All Mexican food. So Grin for Me comes back again. Thanks for your continued generosity. Babies are mentioned. She reads nothing else in one track, like she's having a one-on-one conversation at the knitting club on the weekend, but you put her on trial live. She is reading every message, agreeing with her shitting on Lally. Wait, what? What I miss here, babe? Help me. Now Bob's staying muted. He's like, no, I'm staying muted. Are we talking about me agreeing? She's reading every message, agreeing with her shitting on Lally. Hey, I'll go to the knitting circle if it's about babies. He's still eating. What is it he's eating? Now I want it. But you guys, I was like literally ran in the house like, oh my God, I have to get something. And I said to my father-in-law, I don't understand how Bob's doing this. He hasn't eaten anything all day.
Yeah, I was starving. That's facts.
Did you find a healthy snack?
And then yeah, I was not pooping. That did not happen. No, I ended up making like an unwich. I
Wow.
used those giant romaine leaves and
Wow, so you really did get a healthy snack.
yeah, I made a delicious thing. But Scout, like, you know, she subverted me.
Oh.
I had to get the extension cord so she could plug in her dead scooter, whatever, you know, all that shit. All right. So how'd you do, bae? Just crush it?
I mean, see what you can
I don't
read.
know what the fuck he's talking about. Grin.
I
Make
was
yourself clear.
talking about babies, so that was
I was not listening to anything you were saying. I was busy doing things.
all right. Well, we got no
I don't
baby
know.
talk.
Yeah. Oh, you were talking about babies.
Yeah.
So he says, Allie was like, I'll read what you say without you paying. Then babies were
Oh,
mentioned. Go on.
he's right. I did. That is true.
Okay,
I
so
was like,
now
oh, you keep paying. You don't have to do that. I'll watch. And then I didn't notice anything else after that. We're just looking for
I
baby
just
talk.
proved the point. I just proved it. I mean, we fail at grifting. Like true grifters never read comments from people that don't pay for it. We just can't do it.
No, I specifically told him, like, you spent a
I'm
lot of
saying
money
in
here.
general, we like
Yeah.
we won't do that. Allie was like, when we first started the tube, she's like, no, like we gotta stick to it. Like people only get their shit read. I mean, that's what YouTube says to do. Only allow people who pay to have their comments read. It's like, I don't want to punish people that don't have money and that
I don't see where I even
deserve
missed
to be
any grin
heard.
for me.
So.
I'm going back looking for grin for me to see all the
Time I really want, like when we turn off the ads during lives, is when I
No.
expect you all to pay.
We're gonna have to stop doing that. I told you this. The algorithm, like YouTube is not putting our lives in the algorithm because we don't have monetization turned on.
Yeah, I mean that was a theory.
No, that's facts.
How do you know it's facts?
Because I mean it's facts from like the research that I did. I don't know for real, but
All right, are you ready to start the next one?
yeah.
All right, so remember y'all, this live will still exist if you want to watch it in its entirety. But what we're going to do is we're going to carve it up to 2 separate videos so that we're like Tony Bruschi does it. Like I go on his show every Tuesday. We'll cover 3 or 4 different sections of a case or a couple of different cases. He'll carve it up and then he'll put videos out. It's brilliant. Tony's on top of his shit. He's on top of his shit. For a year plus, we did not have ads during the lives. We, of course, put them on during replay, and people are still bitching. Or like, there's a million ads. I'm like, tough shit. Can't do anything about it. I'm not doing this for free. You know, this is my job. I have to make money somehow, you know, and it's like, there's nothing I could do about it. Like, there's 3 levels of ads you could put. You could put, you know, and they're always like, well, you could do like low, medium, high. High is super intrusive. It's constantly blasting. And I always do kind of like the mid, and people are still complaining. I'm like, I don't know what you want me to do. I don't know what you want me to do, but like I'm making right. I mean, I wish I could gift out YouTube premiums every once in a while. And the other thing we found out is that the wheel is like verboten. Like you can't do it. Like we're not allowed. Like I can't give shit away. I can't make you all pay for an entry fee to get on the wheel and then give something away. It's like you can't do it. Yeah, I like if you're on YouTube more than you're watching any other streaming, it's worth paying $9 a month to not have to deal with ads. It just is. It just is. Oh, well, that's good to know. That's good to know. Your live popped up on my screen, so the algo worked today. We still got a small crowd. I mean, I don't, whatever. This is a great live. People don't want to watch great shit. Go watch stupid shit. I can't control that. You know what I mean? It's like we've got almost 70,000 subs, and we only I think we had a high of like 300 people today. I can't figure it out. Can't figure it out. I mean, the Mangione shit's interesting. The Murdaugh shit, guy's a fucking creep douchebag, but it's interesting. You know what I mean? Like, it's worth covering. Now, we're not getting into the Becky Hill. I saw Emily D. Baker was doing the suit. We're not handling that today. We'll do that on a different day. But there's some interesting interplay between the 1983 claim by Murdaugh against Becky Hill that was made possible by what well, made much easier, I should say, by what we're going to be going through today, which is the Supreme Court of South Carolina's order here granting Murdaugh a new trial. And it makes that 1983 claim way easier because there's some powerful language in here about how much she fucked up. So all right, so the way that we're going to do it, it's going to be another cold open. It's going to be like we just started it. Remember, we're turning these into videos, so you guys are going to have to work with us. Tony does it on all his lives. So if you watch me on Tony or you watch Tony's shit, you should be used to it, because when he goes live, that's why he'll always say, oh, just like, share, subscribe, like at any time we end any kind of section. So that's why I did that thing at the end of the other one. All right. You guys ready for the live open, the cold open? The sea was angry that day, my friends. The sea was angry that day. All right. You ready, babe? I'm going to go. Are you going to do the intro again?
Can I?
No, I don't see why not. You're just playing it.
Oh, okay.
I mean,
no, I will. It's short. People can deal.
Yeah. I mean, if they don't like it, tough shit, Let
me get to the right screen. Okay.
Okay. Yeah. Okay. Oh, yeah. All right. Ready? 5, 4. Hold up. My nose is running because of the jar.
Well, mute it.
I didn't know
yourself.
It was the jar.
You're muted, dude. I muted you. Unmute you?
Unmute me.
I mean, you can unmute yourself. I just keep I unmuted you already, though.
Oh, you did? Okay. All right. Ready? 5, 4.
I don't know why you're counting down.
So you know. So you
but you're starting. When you finish your cold open, that's when I hit
5,
intro.
4, 3, 2, 1. For 6 weeks in 2023, the country watches the murder trial of Alex Murdaugh. A jury convicts him of murdering his wife and his son. 3 years later, the South Carolina Supreme Court says that the jury, they were never fair. Wow. And the reason? It's not a witness. And you know what? It's not a juror. It's the elected clerk of court, a unanimous court. The murder convictions reversed. The verdict gone. A new trial ordered. Welcome to Defense Diaries. Let's get into it. Welcome to Defense Diaries. I'm your host, Bob Murdaugh, and I'm joined, as always, by my beautiful and brilliant co-host, Allie. What's up, girl?
Hey, babe. Hey, all. I don't know why we're getting the super podcast voice.
Oh, yeah.
But I like it.
it. I mean, I could bust out the podcast voice anytime I want. All right. So we are here for a very foreseen set of circumstances, in that the Supreme Court of South Carolina up and reversed and remanded. So they got rid of the conviction and they said, you know what, Alex Murdaugh, you get a new trial. I mean, go ahead. So we're going to go through the entire opinion. It's interesting. I know you went through it. Did you cut any of it, or are we doing the whole damn thing?
I didn't know that I was authorized to do that.
Oh, yeah.
So I didn't cut anything. I just inputted places to stop and talk without.
Well, we better get cracking. It's 27.
Well, let's just taste. Oh, Lord. The procedural posture first, because you need the map, right? So March 2023, Murdaugh is convicted of the murders of Maggie and Paul Murdaugh, plus weapons counts. Judge Newman. I'm pausing for you to play a sound, babe.
Oh, wait, hold on.
So Judge Newman.
Hold on.
I'll say it. Tell me when to say it.
Hold on. I'll give you the high sign.
But I'm not looking at you. Hold on.
I'll say what?
What?
Okay, wait, hold on.
now I am.
Hold on. I'm still looking for it. Hold on.
What the dog doing? What the
Oh,
Don't,
no, wrong one.
don't just press random. Don't press it
What?
until you.
Oh, that was the wrong one.
Well, don't press anything.
Okay, hold on. I'm still looking for it. It's buried in here.
Oh boy,
Oh my god.
we killed the mood. We killed the time.
Totally killed it. You should have given me a heads up. I didn't know. Not a
I mean,
mind
sometimes
reader.
you can read my mind, though.
It's true. All right, I'm ready.
All right. So Judge Newman
will bring the jury. He will bring.
sentences him to life. The direct appeal gets paused so the defense can chase something new. And what do they chase, babe?
Well, what they chase is one Becky Hill, the Colleton County Clerk of Court. Back in October of 2023, the defense moved for a new trial with juror affidavits alleging that Hill tampered with the jury. Judge Newman recuses himself. Former Chief Justice Jean Toll is brought in to hear the new trial motion. She holds a hearing back in January of 2024. We covered it right here and denied. That denial is what got appealed, and the Supreme Court of South Carolina certified it and consolidated it with the direct appeal. So the document we're about to read is the Supreme Court reviewing Justice Toll's denial.
So, I mean, the allegation was that Hill did basically three things: told the jury not to believe Murdaugh's testimony, pressured them toward a quick guilty verdict, and misrepresented things to the trial judge to get a juror removed. Now, I'm just going to say, Bob and I, like, that was it. Like, we heard this and like, it's like case over, case done. He's getting a new trial. There's no ifs, ands, or buts about it. Boom, period. It's just, you don't mess with the jury. It's one of those things that, is now my perimenopause brain's kicking in. Structural error.
Oh yeah.
They don't balance it. There's no, there's so much other evidence that it doesn't matter. There's nothing. That's it. You did it. It's done. So it was shocking that Judge Toll denied it in the first place.
Yeah, she was a hard woman. I'll tell you that. And here's the doctrine the entire opinion turns on, and it's called the Remmer Presumption. And it comes from Remmer v. U.S., a 1954 case. And that's when a third party has an improper private contact with a juror about the case. The law presumes prejudice. That means that's the starting point. The law says we're starting from the fact that because you talk to a juror in private, it's been prejudiced. So it's what they call a rebuttable presumption.
So it is rebuttable, then I guess it's not like a hardcore structural error. It's like must be just below that, since there's some sort of balancing.
Yeah, but I mean, it is a very heavy burden, and it sits on the prosecution, and the state has to prove the contact was harmless. So that's where we're landing.
So there is a harmless error. It's just a stronger harmless error.
Oh yeah.
All right.
Oh yeah.
And so what's with this presumption?
Well, I mean, the presumption is essentially the reason it exists. It's practical. Okay. You usually cannot prove what actually moved a juror's mind. Like we talked about that a lot in terms of this concept that Toll had this weird expectation that they were somehow, because you're like, at what point in time of the trial are you trying to delve into a juror's mind? It's a fluid situation. So essentially, instead of making the defendant prove the unprovable, the law flips it, and improper contact equals presumed prejudice, and the state has to dig out of it. Watch for the South Carolina court formally adopting a 3-step test for this. Let's get into it.
All right. And I don't think that I was on the live when you covered that.
You know?
I mean, unless my perimenopause brain is like on overtime, I don't even have the slightest recognition of it. I'm sure I was working on something and couldn't be there that day.
That
But
tracks. That tracks. All right, so here we go. Here we've got it. So this is the state of South Carolina in the Supreme Court, the state respondent versus Dickie Alexander Murdaugh. Appellant. All right, so reverse and remanded. This thing was heard February 11th, 2026, filed May 13th, 2026. Lists all the attorneys. You know them all. You know the cast of characters. And this is the pure curiam. And it's basically the synopsis. We could really just read the pure curiam and call it a day. But
maybe we can.
yeah, for 6 weeks in early 2023, the eyes of the nation focused on Alexander Murdaugh for the murders of his wife.
Wait, no, you skipped a line.
Eh? Eh?
Focused
Oh.
on
Where the state prosecuted notorious former attorney Richard Alexander Murdaugh for the murders of his wife, Maggie, and son, Paul. Both the state and Murdaugh's defense skillfully presented their cases to the jury as the trial court deftly presided over this complicated and high-profile matter. However, their efforts were in vain because Colleton County Court Clerk Rebecca Hill placed her fingers on the scales of justice, thereby denying Murdaugh his right to a fair trial by an impartial jury. Our justice system provides, indeed demands, that every person is entitled to a fair trial, which includes an impartial jury untainted by external forces bent on influencing the jury towards a biased verdict. Although we're aware of the time, money, and effort expended for this lengthy trial, we have no choice but to reverse the denial of Murdaugh's motion for a new trial due to Hill's improper external influences on the jury and remand for a new trial. Because we order a new trial on this basis, it is not necessary that we review every evidentiary issue Murdaugh raises on appeal from his conviction. However, we address the admissibility of Murdaugh's financial crimes to offer guidance on this thorny issue to the trial court on remand.
So, and I just want to note, as much as you know that the Supreme Court wanted to basically bitch slap the trial court for allowing all this evidence in. They say they praise the judge, talk about how great he was on, overseeing the trial. So when we read, cases where we're like, you hear what the, appellate or Supreme Court just kind of cast some serious shade or talk some serious shit on the judge, like they don't do that. And you can see that here with this, how they're trying to word it very favorably.
Indeed. You want to start with the factual and procedural background?
Sure. On March 2nd, 2023, Murdaugh was convicted of the murder of his wife, Margaret Murdaugh, and his son, Paul Murdaugh, as well as 2 counts of possession of a weapon during the commission of a violent crime. The trial court, Judge Newman, sentenced him to life in prison. While his direct appeal of these convictions was pending at the Court of Appeals, Murdaugh filed a motion to hold the appeal in abeyance to allow him to file a motion for a new trial. The Court of Appeals granted this motion. And when they ask to hold something in abeyance, it's just basically like, just keep it right there a minute. Don't do anything with it, but like it still counts, and let me do something else. So that's what happened there. So on October 27, 2023, Murdaugh moved for a new trial, asserting Hill tampered with the jury by 1, advising it not to believe Murdaugh's testimony and other defense evidence, 2, pressuring it to reach a quick guilty verdict, and 3, misrepresenting information to the trial court in an attempt to have the court remove a juror she believed to favor the defense. He attached affidavits from several jurors to support his motion. Chief Justice Beatty appointed former Chief Judge Toll, post-trial court, to preside over this motion, as the trial court judge had recused himself. And just to talk about why, and I don't know, maybe you know specifically, I'm assuming this recusal is based on the fact like that's his clerk, like that's a clerk that's probably worked with him for years. So he's like, you know what, I can't, this isn't me. Let's let this sit on somebody else's, or maybe let the clerk's an extension of the court. So I'm gonna
Yeah,
let
I think
another
there
clerk.
was definitely conflict aspects to it, but additionally, I think there's a forced retirement statute
somebody
for
did mention that.
judges. And Newman knew even if this thing went to a new trial, he wasn't going to be sitting on it anyway. But I think that the conflict thing, the potential conflict, was the bigger issue because I mean, theoretically, he could have been called as a witness.
Right.
He was obviously presiding over the case. So,
And whatever she told him.
right. Right.
The post-trial court conducted the hearing of this motion on January 26th and 29th of 2024. During the hearing, the post-trial court asked each juror, 1, if the guilty verdict was an accurate statement about their verdict at the time. 2, whether their verdict was, quote, based entirely on testimony, evidence, and law presented in the case. 3, whether they heard Hill make any comment about the case before the verdict, and 4, whether their verdict was influenced in any way by any communication by Hill. Juror X, who testified on the first day of the hearing, acknowledged hearing Hill say before Murdaugh's testimony, looks like the defendant's going to testify. This is an important day, or this is an epic day, and that it was rare for a defendant to testify. Juror X said these statements did not impact the verdict. Well, I guess as we'll see, it's like you don't know how comments like that affected your subconscious, how it influenced you. Like that might not have been what you were focused on, but you had a clerk making comments like that, and that's they
Not
don't
just
mess.
a clerk, the elected clerk of the county.
Right. Juror Z, who submitted one of the affidavits Murdaugh attached to his motion for a new trial, was the first juror to testify on the second hearing date. When asked whether she heard Hill make any comments about the case, Juror Z responded that Hill said, quote, to watch his actions, and quote, to watch him closely. Juror Z added that Hill said more, but she could not remember anything else. Juror Z explained Hill's statements influenced her finding Murdaugh guilty because, quote, to me, it felt like she made it seem like he was already guilty. At the state's request, the post-trial court questioned Juror Z about her affidavit, addressing each paragraph in turn. Juror Z's affidavit gave a more detailed recitation of Hill's comments. Toward the end, and this is the court quoting those portions about the comments. Toward the end of trial, after the President's Day break, but before Mr. Murdaugh testified, the clerk of court, Rebecca Hill, told the jury, quote, not to be fooled by the evidence presented by Murdaugh's attorneys, which I understood to mean that Murdaugh would lie when he testifies. Next, it says, she also instructed the jury, quote, to watch him closely immediately before he testified, including to, quote, look at his actions and, quote, look at his movements, which I understood to mean he was guilty. Next, it says that's my cue that you've covered it up for me.
Wait, where? Oh, I thought you were reading on your own shit.
No.
Oh, okay. I'm sorry.
She also instructed the jury, quote, to watch him closely immediately before he testified, including to, wait, did it say that twice?
She also instructed the jury to watch him closely immediately before he testified, including to look at his actions.
Oh, I guess you didn't cover anything. I'm sorry.
Yeah. Okay.
Okay.
I accept your like heartfelt apology.
I don't know how I got confused. So I'll read it again for a third time. Just
okay.
For fluidity.
Oh, yeah.
For fluidity here.
Oh,
she also instructed the jury, quote.
Oh, sorry.
Babe,
It was the goat. It wasn't me.
it
was
wasn't
just
you.
this guy.
To watch him closely immediately before he testified, including to, quote, look at his actions and, quote, look at his movements, which I understood to mean he was guilty.
Mm.
Juror Z testified that when the jury deliberations began deliberations, I don't know what I need right now.
Wow.
Okay, starting over. Juror Z testified that when the jury began deliberations, Hill told the jury, quote, this shouldn't take us long. Okay. In addition to referencing Hill's statements, Juror Z averred in her affidavit, quote, I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors.
Mm.
After reviewing the affidavit, the post-trial court questioned Juror Z. I asked you previously, was your verdict on March 2nd, 2023 influenced in any way by communications from Becky Hill, the clerk of court? You answered that question, yes. In light of what you have said in the affidavit, which is, I had questions about Mr. Murdaugh's guilt, but voted guilty because I felt pressured by the other jurors. Is that answer that I just read more accurate statement of how you felt? A more accurate statement of how you felt. Juror Z answered affirmatively. The post-trial court then asked if she stood by the affidavit, and she answered yes. Juror Z subsequently submitted an affidavit to clarify her testimony, in which she explained that she felt influenced to find Murdaugh guilty by Hill's remarks before she entered the jury room. And once deliberations began, she felt additional pressure from the other jurors to reach a guilty verdict. Although the post-trial court did not admit this affidavit, it accepted it as a proffer. Thus, the affidavit is part of the record before this court. Juror P testified that on the day Murdaugh was to take the stand, Hill made a comment to, quote, watch his body language. He denied Hill's comments influenced him in any way. And we have a footnote 1, which reads,
You want me to read it?
no,
Oh,
I
footy.
want you to scroll
Footy.
so I can see it.
Sorry.
Following Juror Z's testimony, the post-trial court informed the parties that the other jurors who were waiting for their turn to testify had tuned in to the proceeding on court TV. The jurors either denied viewing the proceeding or, if they saw it, asserted it would not influence their testimony. Returning to the body of the ruling, scroll down.
Oh, yeah.
The remaining jurors testified that they did not hear Hill make any comments about the case, and they were not influenced by any comments Hill made. Following the jurors' testimony, the state called Hill as a witness. Although Hill denied making most of the comments the jurors related, she admitted that on the day Murdaugh testified, and within earshot of some jurors, she spoke to the bailiff about Murdaugh's decision to testify. So you got to picture this the way she's explaining it.
She a damn lie.
Here, the jury's here, and I'm saying to Bob, hey, Bob, this should be pretty quick out here because, they can see his body language.
Yeah, he's full of shit.
I mean, even by her own shit, she's like intentionally speaking in front of the jury, just turning her face to pretend she's talking to somebody else. So,
Yeah.
Yeah.
She a damn lie. She a damn lie.
Yeah. Although, I said that part. She also stated that she gave the jurors a, quote, little talk, instructing them to pay attention and that the day was a, quote, big day. She denied attempting to influence the jury. In discussing her book, Behind the Doors of Justice, The Murdaugh Murders, and footnote 2 reads, as her book's title suggests.
Like the book title says it all.
As her book's title suggests, it turns out Hill was quite busy behind the door of justice, thwarting the integrity of the justice system she was sworn to protect and uphold. The book was pulled from publication because Hill plagiarized portions of it. Double whammy.
Whammy. Bammy, thank you, mammy.
Okay, returning to the body. Hill claimed, so again, it was in discussing her book, Hill claimed literary license to explain some of the more dramatic passages. She denied wanting a guilty verdict because it would sell more books, claiming the outcome of the trial didn't matter to her. But she acknowledged as true a passage in which she stated she believed Murdaugh was guilty, but was concerned he would be acquitted because of his family's goodwill in the community. The post-trial court also questioned Hill about the favors she granted the media. Hill denied allowing the press to view exhibits, including the sealed exhibits. However, she subsequently pled guilty to perjury stemming from this denial. Although the post-trial court limited discussions of juror 785, we've got a footnote 3 as to who juror 785 is, which reads, when the trial court dismissed juror 785, she said her belongings left in the jury room included a dozen eggs, which another juror had brought her. She then became known as the egg juror or the egg lady.
Boom, boom, boom. I seen his bald head. The Eggman. I was gonna start seeing some beasties, but I
Yeah.
All right.
Okay, so returning to the body. So
yeah.
it says, although the post-trial court limited discussion of the egg lady, whom the trial court dismissed on the day deliberations began for allegedly discussing the case with third parties, it allowed Murdaugh to question Hill about bringing to the trial court's attention social media posts that Hill mistakenly believed was from the egg lady. Oh, the egg lady's ex-husband.
Mhm.
It's not even her, it's her ex-husband.
Oh yeah.
Hill claimed that the juror was very talkative while Hill walked her to the trial court's chambers and volunteered that there were restraining orders on her ex-husband when they divorced. In response to the post-trial court's questioning, Hill continued to deny initiating or engaging the juror in discussion of these matters.
Sure.
In contrast to Hill's testimony,
Sure she did.
right, juror 785 averred at the hearing before the trial court and in an affidavit Murdaugh attached to his motion for a new trial, and we'll go down to footnote 4 here. Although the post-trial court did not allow juror 785 to testify, her affidavit is in the record for our consideration. So returning to the body, it says, she also attached the affidavit for a new trial, that Hill interrogated her about the social media posts and whether she had been in contact with her ex-husband. In the affidavit, juror 785 related that Hill, knowing the juror's fears about her ex-husband, informed her that law enforcement officers questioned the ex-husband about the posts, offered to reinstate restraining orders juror 785 had against him, and speculated that the, quote, the Murdaughs probably got to, end quote, the ex-husband when he called juror 785 on the morning of the verdict. What? How could he be calling on the morning of the verdict when this was before deliberations started?
On her cell, maybe?
Yeah, but I don't know. They're talking about speculate. Oh, Will maybe speculated that the Murdaughs probably, got to the ex-husband when he called juror 785 on the morning of the verdict. All right, we'll see if it gets fleshed out later because I'm a little lost. Juror 785 asserted Hill asked her whether she and the other jurors were inclined to vote guilty or not, and told her that everything Murdaugh said had been lies. She also stated that before Murdaugh testified, Hill told the jury not to be, quote, fooled by, close quote, the evidence Murdaugh's attorneys presented. Rhonda McElveen, the Barnwell County Clerk of Court who assisted Hill with the trial, testified that Hill repeatedly told her she wanted to write a book so she could buy a lake house and a guilty verdict would be the best way to sell books. Wow.
Wow.
McElveen testified that after hearing Hill had given a juror a ride home. Are you shitting me?
She was fucking on one, man.
She's giving jurors a ride home.
Oh man.
This is outrageous.
Papa
All
was rolling over in his grave.
So what did McElveen do after that? McElveen counseled her that it was inappropriate, and while Hill admitted she gave a juror a ride, she claimed the bailiff was with them and that they did not discuss the case. Now we've got a footnote 5. At the hearing, Hill denied giving the juror a ride home.
Lies.
Wow. But
She a damn lie.
But in the time that you didn't give her a ride home, was the bailiff with you? That's all I'm wondering.
Mm-hmm.
Was the bailiff there for that thing that didn't happen?
Mm-hmm.
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 Although McElveen did not hear Hill say anything inappropriate to the jurors, she stated that Hill made comments to her, staff, and media members strikingly similar to those Juror Z reported, such as advising them not to be fooled by Murdaugh's attorneys and to look at Murdaugh's actions and movements while he testified. Finally, McElveen testified that Hill seated a writer with court personnel. This writer wrote the foreword for Hill's book. Wow.
Oh, hey, it's behind the curtain of the Murdaugh murder trial.
While I'm reading this, just glance at the text that Tracy just sent. Be back to, Next, Murdaugh called the alternate juror to testify. She described the incident in which Hill made her comments before Murdaugh put up his case, stating that while the jurors were assembled in one of the 2 jury rooms and were standing in the hall, Hill stood at the doorway and told them, they're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off. The alternate juror also testified that Hill told the jurors not to be nervous and, quote, don't be afraid to show your emotions because that's what they want to see. Oh, that makes a great book. That makes that's very compelling for the book. I need the jurors to start to cry so I can put that in my book. Okay. The alternate juror related she heard a court staff member say deliberations should not take long, but she could not remember who said it. In its order, the post-trial court declared the burden was on Murdaugh to show both an external influence on the jury and prejudice from that influence. It then found Hill made improper comments to the jurors on the day Murdaugh testified, e.g., this is an important day or this is an epic day, and that they should watch Murdaugh's body language. The post-trial court determined Hill's denial of making these statements was not credible, finding Hill wanted to write a book, which she believed a guilty verdict would help sell. She was, quote, attracted by the siren call of celebrity, end quote. That's not what it sounds like.
Oh, okay.
No.
That was just a bird.
Oh, that was some calling, all right. And, quote, she allowed her desire for the public attention of the moment to overcome her duty to her oath of office and her oath as a witness. Next, the post-trial court found that these comments did not affect the juror's verdict. It explained Juror Z's assertion that Hill's comments affected her verdict were ambivalent, self-contradictory, and not credible, emphasizing Juror Z had acknowledged her statement in the affidavit that she had voted guilty due to pressure from other jurors was the, quote, more accurate statement. The post-trial court further found that Hill's comments were limited in the subject, quote, were limited in subject and not overt as to opinion, were only heard by, at most, 3 jurors. Oh,
That's fine.
We still got the other 9.
Big deal.
So the other states, they don't even make you be unanimous.
Oh, God damn it.
That doesn't matter. Oh, it's fine. The post-trial court Further found that Hill's comments were limited and only heard by 3 jurors and were made in a case with overwhelming and compelling evidence. All right, that's that thing I said shouldn't count. We'll see what the court says. Maybe I'm wrong. And that the trial court's extensive instructions cured any
Yes.
effect from these comments. The post-trial court concluded that while it found Murdaugh had failed to meet his burden to prove prejudice, any presumption of Murdaugh's timely appeal to the Court of Appeals, it therefore denied Murdaugh's motion for a new trial. Murdaugh timely appealed to the Court of Appeals. This court certified the appeal of the denial of the motion for a new trial and subsequently consolidated it with the direct appeal. Now, I know stop and discuss. I don't know. Do we need to discuss more? What are your thoughts?
I mean, look, like just a kind of like a hot moment. Just notice that the court gave us the why behind Hill's conduct, right? And why it matters. And the court basically found Hill wanted to write a book, believed a guilty verdict, would sell those copies of the book, and was, in the post-trial court's own phrase, attracted by the sirens of celebrity. The best part is that the book got pulled later for plagiarism. She's such a douche. And since then, Hill has pled guilty, even though she got a real hand slap, to perjury connected to this very matter.
I mean, it's just like which all means by the time the Supreme Court is weighing her credibility, she has none left to weigh.
Got no credibility, lady.
Nothing. You got nothing.
You're not a credible person.
So keep that in mind when we read this next part, because the court's about to find that all of the reported comments were made, and not just a couple of them. So let's get to the heart of it and do the Remmer analysis.
Oh yeah, the Remmer analysis. So this is the long analysis, and I apologize for my brief blasphemy where I said GD. I know there's some folks out there that are very God-fearing and they get upset when I
know I don't like to do it
GD.
either.
I know. I always feel bad after I do it. But it was really Judge Toll saying it, not me. I was just repeating what I guessed that she said. All right. So A.
Guilty.
Oh, guilty.
Blasphemy.
Guilty. All right. So
is this my I just read. Oh, it's your turn.
Yeah.
Yay. Phew.
Like you put in some heavy lifting there. Okay, so the Remmer presumption of prejudice. Murdaugh argues he was denied his constitutional right to a fair trial by an impartial jury free from outside influences. He asserts that following Remmer v. U.S., which is a 1954 U.S. Supreme Court case, also known as Remmer 1, prejudice should be presumed from Hill's comments to the jury, and that the presumption is irrebuttable. In the alternative, he contends that the state failed to rebut the presumption of prejudice. The state argued that the jury convicted Murdaugh, quote, because he was obviously guilty, not because 3 jurors heard Hill's foolish and fleeting comments about his upcoming testimony. It contends that the post-trial court correctly declined to presume prejudice, and any presumption of prejudice was, in fact, rebuttable. We agree with Murdaugh. Prejudice is presumed from Hill's comments, and while this presumption is rebuttable, the state failed to overcome this presumption. Our federal and state constitution guarantees a criminal defendant the right to a fair trial by an impartial jury, citing the U.S. Constitution, Article 1, Section 14. No right touches more the heart of fairness in a trial than the right to an impartial jury. It's deep. This right can be infringed when a third party makes improper contact with the jury. For the right is meaningful only if the jury remains free from outside influence, including exposure to evidence or information that has not been introduced during the trial, citing State v. Green, and then Green 2. So to protect the right to impartial jury in such cases, the Supreme Court of the United States created a rebuttable presumption of prejudice, the Remmer presumption, elucidating, quote, any private communications, contact, or tampering, any private communications, contact, or tampering directly or indirectly with a juror during a trial about the matter pending before the jury is, for obvious reasons, deemed presumptively prejudicial, if not made in the pursuance of known rules of the court and the instructions and directions of the court made during the trial with full knowledge of the parties. The presumption is not conclusive, but the burden rests heavily upon the government to establish, after notice to and hearing of the defendant, that such contact with the juror was harmless to the defendant. So that's citing Remmer 1, page 229. So the United States Court of Appeals for the Fourth Circuit noted that in addition to the presumption of prejudice, quote, Remmer established a separate but related requirement that a defendant be entitled to a hearing when the defendant presents a credible allegation of communications or contact between a third party and a juror concerning the matter pending before the jury. Citing Barnes, the Fourth Circuit established a 3-step test as promised. Here it is. For considering extrajudicial contacts with said jury. The party who is attacking the verdict bears the initial burden of introducing competent evidence that extrajudicial communications or contacts were more than innocuous interventions. Hence the affidavits from the jurors. So if this minimal standard is satisfied, the Remmer 1 presumption is triggered automatically. The burden then shifts to the prevailing party to prove that there exists no reasonable possibility that the jury's verdict was influenced by an improper communication. And that comes from U.S. v. Cheek,
You can
1996.
and you can just tell from that we're not dealing even with like just some random guy on the street, someone in the courthouse. You're dealing with the clerk of courts. So overcoming a presumption like that under that standard seems next to impossible.
I can't think of a person other than the judge or the lawyers that should not be anywhere near the jurors other than the clerk of court, the elected clerk of court. We're not just talking about a court clerk. Like all courtrooms have a court clerk. Every judge has a clerk. This was the elected clerk of court who was in there walking around. Like we have bailiffs that handle all jury communication from the jurors in the form of a note to the judge, handle lunch, dinner, those kind of things. That's all bailiffs by us. Clerks aren't messing with that at all. So back to the body, the Fourth Circuit further provided that in determining whether the extrajudicial contact was innocuous or whether it triggered the presumption, the court considers whether there was, quote, 1, any private communication, 2, any private contact, 3, any tampering, 4, directly or indirectly with a juror during trial, and then 5, about the matter before the jury, citing Remmer. Quote, an unauthorized contact between a third party and a juror concerns the matter pending before the jury when it is of such character as to reasonably draw into question the integrity of the verdict, citing Barnes, quoting Stockton. So once the Remmer presumption is triggered, the state bears the heavy burden of proving, quote, there is no reasonable possibility that the verdict was affected by the contact, Cheek. So the court must examine the entire picture, including the factual circumstances and impact on the juror, quoting again Remmer and Remmer 2. In determining whether the state met its burden of rebutting the Remmer presumption, courts consider a variety of factors, such as the extent of the improper communications, the extent to which the communication was discussed and considered by the jury, and the type of information communicated, the timing of the exposure, and the strength of the state's case. And that comes from U.S. v. Basham, which is a Fourth Circuit 2009 case, and also State v. Kelly, state case, South Carolina case 1998. Relevant factors to be considered in determining whether outside influences have affected the jury are the number of jurors exposed, the weight of the evidence properly before the jury, and the likelihood that curative measures were effective in reducing the prejudice. Problem here, it was after the verdict, before any of this came out. There was no ability to be able to cure it in any way, shape, or form by Judge Newman. The extent of the communication is the more important factor. And that's Basham again. So in Parker v. Gladden, the Supreme Court recognized the extreme prejudice inherent in statements concerning the matter at trial when made by an officer of the court. That's Footy 6. The Supreme Court did not apply the Remmer analysis. There, a bailiff, see, who oversaw a sequestered jury during an 8-day trial, stated to a juror in the presence of other jurors, "Oh, that wicked fellow." Petitioner, "He is guilty." At 63. The bailiff also told another juror, "If there's anything wrong in finding the petitioner guilty, the Supreme Court will correct it." See, the bailiff was popping off there. So at least one juror or alternate overheard the statements. At 364. In rejecting the state's argument that no prejudice was shown, the Supreme Court explained, quote, "This argument overlooks the fact that the official character of the bailiff as an officer of the court, as well as the state, beyond question carries great weight with the jury, which he has been shepherding for 8 days and nights. Dinners, lunches, notes back and forth. I have to go to the bathroom. Can I go out to smoke? All those things. That's the bailiff. That's the shepherd. He is the Sherpa. Sherpa-ing." So although the Supreme Court noted the 26-hour jury deliberations and one juror's testimony that she was prejudiced also supported the trial court's finding of prejudice, it held that, quote, "that the unauthorized conduct of the bailiff involves such a probability that prejudice will result that it is deemed inherently lacking in due process." We love due process. We love it. Quoting Estes v. Texas, U.S., 1965. It further recognized that it, quote, "it would be blinking reality not to recognize the extreme prejudice inherent in such statements that reached at least 3 members of the jury and 1 alternate member." Quoting Turner v. Louisiana, 1965. However, not all comments by officers of the court are prejudicial. In Green, a juror asked a bailiff, "What would happen in the event of a deadlock?" And he responded, "The judge would likely give them an Allen charge." We're about to find out what an Allen charge is. Allen v. U.S., 1896. You guys know. You guys know, right? We've watched enough trials with Allen charges over here. You know what it is. The dynamite charge. That's where the judge says, "Hey, go back there. Figure some shit out. Work it out.
Deliberating. You're
Keep
not
doing it.
done yet.
You can do it." The Allen charge, and ask if they could stay later. And that comes from Green at 713. So while the Court of Appeals held that the state overcame the Remmer presumption, this court held the bailiff's comments did not trigger the presumption. In Green 2, that was cited. We explained that, quote, "our unwillingness to categorically apply the Remmer presumption of prejudice stems from our view that not every inappropriate comment by a bailiff to a juror rises to the level of constitutional error." At page 441. So as the Fourth Circuit recognized, quote, "there is a split among the circuits regarding the issue whether the Remmer presumption had survived intact following," quote, "the Supreme Court's decision in Smith v. Phillips." That's a 1982 case, and the U.S. v. Olano, 1993, which we've got a footy. So in both Phillips and Olano, the Supreme Court noted the case's procedural postures inform the outcomes. See Phillips. Of equal importance, this case is a federal habeas action in which the trial court's findings are presumptively correct under 28 U.S.C. 2254D. So Olano. And then applying plain error standard, because Olano did not object to the alternate juror's presence in the jury room, citing Olano again. So the Court of Appeals should correct a plain forfeited error affecting substantial rights if the error seriously affects the fairness, integrity, or public reputation of judicial proceedings. Again, quoting United, that wasn't an id, but it's quoting United States v. Atkinson, a 1936 case. All right, so where was that footy? It was deep. Oh, it was buried. So U.S. v. Lawson was cited, collecting cases and recognized the split in the circuit. So in Phillips, the Supreme Court declined to impute bias to a juror who applied for a job in the prosecutor's office during Phillips' trial. Okay, in reversing the grant of federal habeas relief, the Supreme Court declared, quote, that the remedy for allegations of juror partiality is a hearing in which the defendant has the opportunity to prove actual bias, at 215. So the court explained that the due process does not require a new trial every time a juror has been placed in a potentially compromising situation. So instead, due process necessitates, quote, a jury capable and willing to decide the case solely on the evidence before it, and a trial court judge ever watchful to prevent prejudicial occurrences and to determine the effect of such occurrences when they happen. Id. In Alano, the Supreme Court considered whether the presence of alternate jurors during jury deliberations was a plain error, and the Court of Appeals was authorized to correct under Federal Rule of Criminal Procedure 52B. So noting the alternate juror's presence was not the type of error that affected, quote, substantial rights independent of its prejudicial impact, end quote, the court found, quote, no reason to presume prejudice. It at 737. It explained there may be cases where an intrusion should be presumed prejudicial, but a presumption of prejudice as opposed to a specific analysis does not change the ultimate inquiry. Did the intrusion affect the jury's deliberations and thereby its verdict? It at 739. So neither.
Need your id. Nope.
I like the id.
The id.
Id. What do you guys think? Id? Id?
No
No
id.
id.
No
To
id.
id or not to id?
I mean, you could just say in the court
That
back
is
to
the
the
question. Id. Okay. Neither Phillips nor Olano overruled the Remmer presumption. Indeed, in Olano, the court specifically recognized that prejudice should be presumed from certain intrusions, just not from alternate jurors who've been properly instructed not to deliberate, sitting in on the deliberations of a jury. The
right.
fourth,
I mean, in that situation, there's nothing's been said to a juror, nothing's affecting the juror. They don't even say that the alternate juror said or did anything.
yeah,
So, that one's like a no. What do you call that? A nothing burger.
nothing burger. The Fourth Circuit rejected the argument that the Supreme Court overturned the Remmer presumption of prejudice attached to an extrajudicial communications with the jury, declaring the presumption remained, quote, alive and well in the Fourth Circuit, and that's Lawson, noting that the Remmer presumption is clearly established federal law, even after the Supreme Court's decisions in Phillips and Olano. Again, Barnes, concluding that North Carolina state court's adjudication of Barnes' juror misconduct claim without allowing a hearing on the claim or following the Remmer presumption amounted to an unreasonable application of clearly established federal law. Jenkins v. State. So while Phillips and Olano may somewhat limit the scope of presumptive prejudice, they do not preclude such a presumption in all situations where excessive or egregious jury misconduct or improper contact by a third party occurs. The Fourth Circuit explained the Remmer presumption applies in cases where, quote, the danger is not one of juror impairment or predisposition, but rather the effect of an extraneous communication upon the deliberative process of the jury. That's Barnes. So thus, quote, the distinction between internal and external jury influence is critical because unlike external influences, which, quote, necessitate a thorough judicial inquiry, no such obligation is imposed with regard to an internal jury influence. And that's citing Johnson. So external influence on a jury involves situations where jurors receive information during deliberations from some outside source, while, quote, internal influences involve information coming from the jurors themselves. There's your distinction. So remanding for a hearing And that comes from Remmer. So remanding for a hearing when a juror was offered a bribe during trial and was later investigated by an FBI agent, and that's Turner. So finding a defendant was denied a right to a fair trial or a right to a trial by an impartial jury when two deputy sheriffs who were key prosecution witnesses were responsible for the sequestration of the jury during the time, during which time they, quote, ate with the jury, conversed with them, and did errands for them. Can you pick up my dry cleaning? Can you pick up the shit in my backyard for my dog? Thank you, sir. Even when there was no evidence that the deputies discussed the case with the jurors. And that's Fullwood v. Lee.
No, you're ignoring the semicolon. So
Ah!
then we have Fullwood v. Lee, where the Fourth Circuit held holding defendant should not have been afforded a hearing to determine whether a juror's husband repeatedly instructed her to vote for a death sentence would entitle defendant to relief was proven. Then they also cited the Cheek. So this
Are you taking over reading?
No, I'm just gonna
Here for it. I've read a lot. I'm
Okay,
like, we're
so-
page 12, so it's your
So
turn.
when we hear them say, when we hear the court write an opinion collecting cases, this is a precise example of that. The court's just citing case after case and then giving a little description of how the holding applies. So they next cite to this Cheek case, which is a federal case, holding a defendant was entitled to a presumption of prejudice from his co-defendant's attempt to bribe a juror, and the state failed to rebut the presumption. Then they cite Stockton, also the federal case, holding the presumption of prejudice attached when a local restaurant owner suggested to jurors in a capital case that, quote, they ought to fry the son of a bitch.
Fry him!
Then we have State v. Cameron, which was ultimately heard by the Supreme Court in 1993, holding a bailiff's response to a foreperson that the jury should not worry if they were deadlocked over the issue of mercy, quote, because the judge was fair, was prejudicial because it was misleading, and, quote, tends to lessen the jury's sense of responsibility by implying that if they rendered a verdict of guilty without mercy, the judge has some discretion in sentencing. And then footnote 9 reads, the post-trial court erred as a matter of law in relying on State v. Aldrich, which is a 1999 South Carolina case, in holding that the defendant must demonstrate prejudice from juror misconduct in order to be entitled to a new trial. And it notes that Aldrich addressed the issue of premature deliberations, a form of internal jury influence. So what you see there is the court explains the difference between the internal, when a juror is saying something, and an external influence when a third party, aka the clerk of courts, is saying something. So apparently the burden is different as to who has the burden once there's been who has to demonstrate prejudice once a showing's been made that there was improper conduct or contact or conduct. So returning to the body, our decision in Green 2 did not deviate from Remmer or its Fourth Circuit progeny. Adhering to Remmer, we held only that the facts of the case did not warrant applying the presumption while leaving in place the Court of Appeals holding that the trial court must follow the Remmer procedure when it learns of an allegedly improper contact with a juror. Then they cite to Green 1 for which says holding that, quote, in the event the trial court learns of an allegedly improper contact with a juror, the procedure of Remmer v. United States must be followed. The Fourth Circuit has long recognized, quote, that certain kinds of extrajudicial state contacts may amount to nothing more than innocuous interventions that simply could not justify a presumption of prejudicial effect. We acknowledge that this court has not always employed the Remmer presumption when considering external influences on the jury. In Kelly, an appellant asserted the trial court erred in denying his motion for a mistrial when in a capital case, juror shared a pro-death penalty pamphlet in the jury room during the penalty phase of trial because the appellant framed the issue on appeal as the denial of a mistrial. The court noted that, quote, in order to receive a mistrial, the defendant must show error and resulting prejudice, and held the appellant failed to show prejudice. We did not discuss Remmer. I'm just going to pause there.
Oh, yeah.
And I just want everyone to take note of what this court acknowledged it did. And it's one of the worst things about the law. It is form over substance. Did you say the magic word? Did you say it in the right order? So they're saying here, because the appeal there, they appealed the denial of the mistrial instead of raising the claim that there was improper jury influence, that they used the burden and the law around when a mistrial is supposed to be granted and said, well, you appealed the denial of a mistrial. You had to show prejudice to do that. And they didn't even discuss Remmer, didn't even discuss it, probably because the defendant there didn't even bring it up. So, that's the kind of thing that happens in the law that is just complete and total bullshit, and it shouldn't happen. And, so, very rarely you'll hear a court be like, well, although this says it's an appeal from the denial of the mistrial, we're going to take this as an appeal based on juror misconduct because that's what the mistrial request was based on. And because we want to grant this specific defendant's motion, some relief here, we're going to say that. And, in such a situation, the state has to prove the burden and they didn't, but that's, very rare. But it's one of those situations where we say sometimes a court can just do what they want. Like, oh, there's a little, they didn't say this the right magic word or in the right order. So we're going to ignore Remmer and we're going to focus on the mistrial issue. So it's very frustrating. And hopefully that point was, you guys followed me on that and see our pain.
I did, honey.
Feel our pain as
I was
defense
putting on
attorneys.
some socks. My tootsies were cold.
Oh,
Oh yeah, my feet. They need
Okay.
to put socks on. Oh, all right.
all
sorry.
right.
Okay.
In State v. Bryant, a South Carolina case from 2003, a death penalty appellant moved for a new trial after discovering detectives from the same police department as the victim contacted jurors' families after the jurors were death penalty qualified, but before the jury was selected. Citing Remmer and Phillips, this court held, quote, in cases where a juror's partiality is questioned after trial, it is appropriate to conduct a hearing in which the defendant has an opportunity to prove actual juror bias. We noted the detective's actions, quote, could have been perceived as an attempt to intimidate jurors, and concluded that, quote, given the nature of the case, the timing of the inquiries, and the questions which were asked, the jury could not have been fair and impartial. Thus, while we did not discuss Remmer's rebuttable presumption, we essentially followed the procedure, recognizing that Remmer and Phillips entitled the appellant to a hearing in which he had the initial burden of proving the detective's actions were more than innocuous interventions, and then rejecting the state's argument that the appellant was not prejudiced. And they cite back to this Cheek case discussing the three-step analysis when analyzing alleged improper third-party conduct with a juror. We clarify today. Now, let's just talk about why they have to do this, because they
Let's
went
talk about
off.
why they went to single spacing on these lines, bro. This shit's super dense.
Yeah, it's crazy.
What are they
So it's-
trying to prove?
It says 27 pages, but it's really like 50.
Feels like 500.
60, actually.
At 5:14, Allison texted me. He's like, "Do we really want to do Murdaugh today?" I'm sorry, I didn't see that, babe. I probably didn't like. Hey, you know what? You're right. That first one went a couple hours.
Yeah.
Oh,
I
yeah.
told them about it while you were getting your snack. And then I
Oh,
was
yeah.
like, well, then I heard him say it, so I wasn't going to bring it up again. I was like, okay, we're doing it.
Oh, I just didn't see it. I would have given it a
Um,
long thought. know?
I texted to your computer too.
Oh, I wasn't sitting at my computer. I was down there making a unwitch.
No, when I was in the car.
Oh,
These were sent from the car
Oh yeah, I didn't see that shit. I was working.
long before it ended.
oh
'Cause
boy.
while we're just taking a little pause here, you should have your messages open so
Mm.
that you see a text.
I got a lot of shit going on my screen, girl.
I know.
Rejected. Heard. Rejected.
But no one else is going to text you to that. I'm the only one that knows how to get
That's
you
the
on your
secret
computer.
squirrel shit right there, girl.
Yeah.
Yeah. Oh.
We clarify today. Oh, okay, so this is what I was going to say. And here's the reason why they have to clarify. They're supposed to apply the same law in the same factual scenarios. So now they went off half-cocked on that one that we talked about where they were like, well, you really appealed a mistrial, so we're not even going to discuss Remmer. And then they did this other one where although the right essentially it rose to the level of saying like there was a Remmer rebuttable presumption. They never actually said those words. So when they do things like that and go off sideways and don't follow their line of cases and the law is set out, they have to do shit like this. We clarify today that when faced with a third party's improper contact with a juror, our courts should follow the Fourth Circuit's three-step analysis as set forth in Cheek. And 1, require the defendant to meet the initial burden by presenting evidence that the contacts were, quote, more than innocuous interventions. 2, if the minimum standard is satisfied, recognize the Remmer presumption is triggered automatically. And 3, shift the burden to the prevailing party to prove that there exists no reasonable probability that the jury's verdict was influenced by improper communication.
Jury. That one
That's,
gets stuck on your tongue, girl.
That's
Oh,
why
yeah.
it's been a
Oh
long,
yeah.
a long day, and
It's been a long day.
we're just halfway through this single space
And they
document.
really single spaced it on us. They were nice,
Really
double
single-spaced
spaced, like all in the first like 8 pages, and then turn around and really stuck it up the gigi.
Right. But, since we're doing a lot of discussing during it, I think we can ignore my stop and discuss comments.
Stop and discuss. Let's stop and discuss it.
Because we're doing a lot of stopping and
A
discussing.
lot of stopping, a lot of discussing.
Okay, returning to the body.
Let's get back to the body.
Under this framework, return to the facts at hand. First, we must determine which comments Hill made to the jurors. The post-trial court referenced only a few of the comments the jurors testified she made, e.g., this is an important day, or, quote, this is an epic day, and to watch Murdaugh's body language. The state argues the post-trial court implicitly rejected the other alleged comments as not being credible. We find this argument is without merit. And I kind of wish, and don't know, maybe they do later, that they say, and even if he did, or she did, I can't remember what tool or toll is.
Toll. For whom the bells toll.
So is toll a male or a female? Well,
Janet Studdard thinks that's a pirate. That is not a pirate. Pirates are like, arg, how you doing, matey?
It gets pirate. It could be pirate.
It's not pirate. That's like old English guy.
Oh yeah, it's
Don't
old
make me
English
go get
guy.
the big hat.
That's old English guy.
I'll go get the big fucking
No,
hat.
no.
Yeah, everyone loves the hat.
See, the people that are just watching this live, like when we separate it out, are not going to understand why we're so like punch. What do they call that? Punch drunk. Like just popping off and messing around, because really we're creeping
4
up.
hours in.
4 hours.
We're a third of what our marathon's going to be on Saturday. So, there you go. Only 8 more hours. You can imagine how punchy I'll be at like hour 9.
How do people eat on those? They just don't eat?
Oh, I'm going to be eating all up in the live.
Well, you've got
slurping,
me. Like we
crunching.
could take turns. Like
Oh
I
no,
turn off
I'm
my
just gonna eat
camera.
right in the mic. All kinds of mouth noises, like making your head explode on a live in real time. Ooh, girl.
Okay, so I'm just saying, I hope that the court also says Judge Toll was just wrong. Either I'm not buying it, or if Judge, that's what Judge Toll was trying to do. Judge Toll was wrong.
Oh yeah, Toll is definitely a woman.
Okay.
Yeah.
Thank you, Janet. We find this argument is without merit. The post-trial court gave no indication it found the other comments not credible, nor would the record support such a finding. Thank you, Supreme Court.
Yep.
Indeed, the post-trial court found Hill's denial of making any inappropriate comments lacked credibility. Footnote 10, Hill's lack of credibility during the hearing on Murdaugh's motion for a new trial is further evidenced by her recent guilty plea to perjury stemming from the hearing for her denial of allowing members of the press to view sealed exhibits.
This bitch, man.
Just like, have at it. Shh, I'm going to sneak you in.
Don't worry about it.
Take a peek. I'll keep an eye out. Take a peek.
Yeah, no one's coming. Hurry up.
Allie tried to look at some evidence in front of Judge Gull, and
It wasn't sealed. She just was
Wasn't
blocking
shit.
people.
like it was like Allie wasn't the real press, so some
No.
shit bag wrapped.
Don't forget, I
ratted blood.
decided to go in as the public.
Oh yeah,
And
on
then
the
I asked
general
her.
public,
Yeah, when is the general public's turn?
which was a point well taken.
Right,
However, I would have liked to have seen you go in there as the media or the press.
right.
I mean, nobody covered that case more than we did. No
Mm-mm.
mainstream media.
No,
Get out of my face.
get out my
That
face.
bullshit.
The post-trial court made no distinction regarding the comments it referenced in its order and the remaining comments that are in the record. The post-trial court, in fact, found credible Juror Z's affidavit statement concerning pressure from other jurors. This same affidavit included Juror Z's recollection of Hill's comments not to be fooled by the evidence presented by Murdaugh's attorney and Hill's instructions to, quote, watch Murdaugh closely, quote, look at his actions, and, quote, look at his movements. The state offers no rationale for finding part of the affidavit credible while rejecting portions that are damaging to the state's case. Juror Z's recollection of Hill's comments were consistent with Juror 785's affidavit, egg juror, egg lady, testimony that Hill told the jurors not to be fooled by the evidence Murdaugh's defense presented. Juror Z's recollection also consistent with the alternate jurors' testimony concerning Hill's comments. Quote, they're going to say things that will try to confuse you. Don't let them confuse you or convince you or throw you off. Close quote. And footnote 11 says the post-trial court did not make a finding on the alternate jurors' credibility. Returning to the body. These comments were also strikingly similar to the comments Hill made to McElveen and other staff members and the media when away from the jury. Furthermore, Hill's attempt to insert herself into the jurors' deliberation through these comments was in line with her stated desire for a guilty verdict to sell more copies of the book she planned to write. Her meddling in events around Juror 785's dismissal and her self-aggrandizing conduct throughout and after the trial, from granting favors to media members, such as allowing them to view sealed exhibits and sitting a writer with court staff in the courtroom, to granting interviews. As the post-trial court found, quote, Hill was attracted to the siren call of celebrity.
Siren call of celebrity. Buy
And-
it. Not
Oh,
to-
bye. Sorry. And, quote, allowed her desire for the public attention of the moment to overcome her duty to her oath of office.
I'm
We have
Becky
no-
Hill. I'm Becky Hill.
I bet you she always says her first and last name. She's that gal.
But
Yeah.
I'm Becky Hill. Nobody's gonna fuck with Becky Hill. I'm Becky Hill.
Can you
That's
see?
that's how you walk around. I'm Robert Mata.
I'm Bob Model. I'm Becky Hill. I'm Becky Hill.
Fucking- she cost the taxpayers of that county millions of
So
dollars.
much money.
Ugh.
I mean, somebody should bring a taxpayer suit, but then it's like you sue the county repays the taxpayers with the taxpayers' money. So
Oh yeah, it's a real vicious cycle.
I don't know how this helps. All right. We have no reason to find Hill did not make all of the statements the jurors reported. Therefore, we hold Murdaugh established Hill made comments that the day Murdaugh testifies he was epic or important and urged the jurors not to be, quote, fooled, quote, confused, quote, thrown off, or, quote, convinced by Murdaugh and to watch Murdaugh's body language closely. So they go way over and above what the trial court found. They find that all those statements are there, made them all. That's it. That part established. So next, we must decide whether these comments were more than innocuous interventions. Spoiler alert, they were.
Oh, yeah.
We could probably just skip down because, like it's short. And I know how you hate when I do that.
Oh, she's trying to skip, kids.
Uh-huh. People start complaining. Why is Allie trying to skip shit?
Hey, this section sucks. Redundant.
And of such a character as to reasonably draw into question the integrity of the verdict. Hill's statements were more comparable to those of the bailiff in Parker than those of the bailiff in Green. Now, those are those two cases we discussed before. First, that one bailiff said a bunch of crazy shit. I don't remember the quotes, but they were pretty damn bad. And the other one just said something about the Allen charge. So this court's saying, no. This is much closer to the bullshit the bailiff said in Parker. And the court goes on to say, like the bailiff's statements in Parker, Hill's comment attacked the defendant's character and credibility, which certainly were matters before the juror. And then they do quote to Parker, reporting a bailiff told jurors, quote, "Oh, that wicked fellow. He is guilty."
See, it was way better when
Way better. I was just thinking the
way
same
fucking
thing.
better. Like everybody's like, oh,
so-
Bob's losing his mind.
Okay, wait.
Everybody
See,
needs
so they
space.
cite to Parker and they say the reporting bailiff told jurors,
Oh, that wicked fellow. He is guilty.
and State v. Reyes, where there they said, stating, quote, "The credibility of a witness is exclusively for the jury to decide." Hill became a character witness on behalf of the state, encouraging the jurors to question Murdaugh's credibility, citing a 2020 South Carolina case, holding a plaintiff in a medical malpractice case was prejudiced when a juror who worked with the defendant doctor vouched that he was a good, reliable doctor, and explaining the doctor, quote, received the benefit of having a character witness on the jury who could attest to his skill without being subjected to cross-examination. So I'd love to go look at that case. The juror clearly had to lie. You know anybody, any of the parties here?
Oh, I don't know anybody.
I don't know.
Dr. Who?
Okay.
Hey, listen, that doctor's kick ass, man. He's awesome.
Best.
He's the best. He's thorough.
Right. Thorough.
He's a good
And-
man and thorough.
Thorough. In fact, I thought you were going to say name that movie.
I mean, people drop the ball on
Yeah.
9 times, so I don't know, like I don't have any faith.
In fact, by urging the jurors not to be fooled or convinced by Murdaugh's defense, Hill essentially implored the jurors to find him guilty, the ultimate issue in the case. Even Hill's seemingly innocuous comment that the day Murdaugh testifies was an epic or, quote, important day became nefarious when considered with her other comments insinuating that there was something unusual and suspicious about his decision to testify. In contrast, the bailiff's statement in Green, quote, though improper, did not touch the merits, but dealt only with the procedural question of how the judge might handle a jury impasse that apparently never materialized. And that's the one I said where it was the Allen charge. Therefore, we hold Murdaugh met the, quote, minimum standard of showing that, quote, the extrajudicial communications or conduct were more than innocuous, and the post-trial court erred as a matter of law in refusing to impose the Remmer presumption. Now, I'm not gonna really, talk
Stop
about.
and discuss.
No, I'm just gonna lay a little bit of a a real quick thing for the rebuttal. So the next part that we're getting to is whether the state can rebut that presumption. And that is honestly the most important law in the whole opinion. The post-trial court, Justice Toll, had found that the state did rebut it, or alternatively, and that's what I thought, that it was more saying that Murdaugh never proved prejudice in the first place. And the Supreme Court is about to take that apart on two fronts.
Is you high, bitch?
Exactly. That's what the judge is going to say. So front one is the burden problem. About Toll analyzed this by putting the burden of proving it onto Murdaugh, and that's backwards. And then this is external influence, so it's outside the reachings of the case, that Aldrich case that they are going to rely, that the trial court relied on. And on the second front, it's that this is the one to really understand. It's Rule 606B. So the rule against impeaching a jury verdict with juror testimony, and its core is after a trial, a juror is allowed to testify about whether an outside influence happened. The juror can say, yes, the clerk said these words to me. What a juror cannot do is testify about the effect, whether the comment changed their vote. The jury room has to stay sacred. So that's what this next section of part one is getting into. I'll just say that. You want to take over? Or you want me to continue?
Yeah, I'm starting to get stir crazy. I got to do some reading now. It'll keep me off the ledge.
Okay.
Keep me off the ledge of crazy.
Maybe I'm gonna run and get a snack.
Oh, I bet you are. I bet you that's exactly what you're going to do. So our following consideration is whether the state met its heavy burden of proving, quote, there is no reasonable possibility that the verdict was affected by Hill's comments. That comes from Cheek. So as stated above, the post-trial court analyzed the evidence before it by erroneously imposing the burden of proof of prejudice on Murdaugh. I remember that happening. When she did that. And I remember knowing that it was wrong because I think Allie had pulled the law before we watched that hearing. So I knew she was misapplying it. It was weird. It was blatant. Like I knew it was dead in the water in terms of the state's case and that verdict sticking when Creighton basically argued the law in opposite of what it is. So furthermore, as Murdaugh argues, the post-trial court erred in considering testimony from the jurors about whether Hill's comments affected their verdict because this testimony violated Rule 606B of the South Carolina Rules of Evidence. Rule 606B of the South Carolina Rules of Evidence limits the testimony a juror may give on the issue of prejudice. This rule provides, upon an inquiry into the validity of a verdict or indictment, a juror may not testify as to any matter or statement occurring during the course of the jury's deliberations, or to the effect of anything upon that or any other juror's mind or emotions as influencing the juror to assent to or dissent from the verdict or indictment, or concerning the juror's mental processes in connection therewith, except that a juror may testify on the question whether extraneous prejudicial information was improperly brought to the jury's attention, or whether any outside influence is improperly brought to bear upon any juror. Nor may a juror's affidavit or evidence of any statement by the juror concerning a matter about which the juror would be precluded from testifying be received for these purposes. So interpreting court rules, this court applies the same rule of construction to interpret statutes, Ex parte Wilson, 2005. Thus, quote, if a rule's language is plain, unambiguous, and conveys a clear meaning, interpretation is unnecessary, and the stated meaning should be enforced. We must consider not only the particular clause in which a word may be used, but the word and its meaning in conjunction with the purpose of the whole rule and the policy of the rule. I get to say id. In addition, when a South Carolina rule is substantially the same as its federal counterpart, we may consider federal cases in interpreting the rule. And so that's exactly what they do, considering federal cases when interpreting a state rule. All right, well, then we go boom, 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 boom. All right, so the U.S. Supreme Court explained Federal Rule of Evidence 606B. Our Rule 606B's federal counterpart, quote, is grounded in the common law rule against admission of jury testimony to impeach a verdict and the exception for juror testimony relating to extraneous influences, Tanner v. U.S., 1987. In Tanner, the Supreme Court examined the legislative history of Federal Rule 606B, setting forth the rationale for the rule. So I'm sure a vast majority of you guys understand how laws are made in this country. If it's federal law, you know, the legislature drafts bills or the House drafts a bill and it's got to get through the Senate. And once it gets through those two parties, you know, ultimately it can be signed into law by the president. But something that's really helpful for lawyers is when a new law is drafted, it's important to know why the legislator felt it was important to create the law. What was the intent behind it? So that's what they're talking about. And the legislative notes and the history of the law coming to be a law is usually very helpful in figuring out what the intent of the drafter of the law was. You hear about that all the time with the Supreme Court in terms of how they are interpreting the Constitution, which if you have what they call a strict constructionalist, like Judge Scalia, who's now deceased, he was a strict constructionalist judge, wherein he tried to go back in time into the mind of what the framers of the Constitution, the guys who sat in the room and wrote the Constitution, were thinking at the time and what their intent was. He didn't care so much about the fact that it was hundreds of years ago and that society had changed completely. And there were things that were going on in this world that the framers couldn't have contemplated. So he just always wanted to go back and strictly construe what it meant at that time that it was drafted. So legislative intent can be very, very helpful in terms of trying to get to what was the point of the bill being drafted initially. So public policy requires a finality to litigation. And common fairness requires that absolute privacy be preserved for jurors to engage in the full and free debate necessary to the attainment of just verdicts. Jurors will not be able to function effectively if their deliberations are to be scrutinized in post-trial litigation. In the interest of protecting the jury system and the citizens who make it work, Rule 606 should not permit any inquiry into the internal deliberations of the jury. And so that was reprinted in 1974. And again, that was going right to the intent from the legislature that they put in their notes. So the legislative intent, again, is important in terms of saying, okay, well, why did they draft this law? All right, so the Supreme Court noted in its, quote, holdings requiring an evidentiary hearing where extrinsic evidence or relationships have tainted the deliberations do not detract from, but rather harmonize with the weighty government interest in insulating the jury's deliberative process. That's Tanner. Let me get a drink. I'm getting dry mouth. So thus, while a probing factual inquiry, quote, is not only permissible, but necessary when a third party makes extrajudicial contact with a juror, the rule, quote, prohibits all inquiry into a juror's mental process in connection with the verdict, citing Cheek and quoting Haley. And then and then here they talk about Wright and Miller's Federal Practice and Procedure, which is a treatise, and it says most courts preclude jurors from testifying as to the effect on their verdict of extraneous information or outside influence. So the Fourth Circuit noted by, quote, by asking a juror whether he had listened to and considered all the evidence, the government was delving into the juror's mental processes about the sufficiency of the evidence in reaching his personal verdict. Such an inquiry exceeded the strict limits imposed by Rule 606B. again, citing Cheek. So it further held that the district court erred, quote, by relying on the jurors' mental processes in connection with the verdict when formulating its findings of fact. So holding that a juror's affidavit was inadmissible to the extent that it recounts how another juror's disclosures affected in, the thinking and voting of individual jurors or the deliberations of the jury as a whole, including the tally of votes, U.S. v. Blummeyer, the 1995 case. To the extent that the district court used testimony barred by Rule 606B to make its finding of fact, the court abused its discretion, which is what Judge Toll did. Like when Judge Toll took into consideration when the affidavit read one way and it was different than what the juror had testified to, specifically that, yes, Hill said these things to me, but it was the pressure I got from the other jurors that were deliberating that really put me over the edge to guilty when I was contemplating whether or not Murdaugh was guilty. So Toll was in error by doing that. She violated 606B. So we find that the plain language of Rule 606B of the South Carolina Rules of Evidence authorizes jurors to testify about improper extraneous comments by a third party, but not on the comments' effects on the juror's deliberative process. So while, as the Fourth Circuit recognized, quote, Rule 606B at times makes it more difficult to determine whether a new trial is warranted, sound policy supports the rule and outweighs any inconvenience or difficulty the rule imposes, citing Cheek again. So the state must meet its burden of rebutting the Remmer presumption without exceeding the limits of the rule. That's footnote 12. So we recognize that in Ethier, the court held the affidavits and testimony from the jurors describing whether another juror's premature deliberations affected their votes were admissible because premature deliberations may affect the fundamental fairness of the trial. We hereby overrule Ethier to the extent that this case condoned the use of testimonies about the jury's mental processes in reaching their verdict. So
See, another situation there where the court went off and said something different, and now they've got to reverse it.
yeah, I mean, because essentially, you know, what Toll did, like, I don't know if you were listening,
I
but
was.
I mean, essentially, and I don't know if you watched that with me. I feel like you did, maybe not. I streamed it for sure. And I'm talking about that hearing.
Right.
But Toll did what's verboten. She violated 606B in that, because that one particular juror who had testified about, she heard these comments, they did affect that particular juror. But then when Toll pressed her on it, she said, well, you know, back in deliberations, it was the heat, the pressure from the other jurors that what really swung me. So, and she wasn't allowed to do that.
Right.
She had to stick with what was in the affidavit about what Hill had done, and that was it. That's where the court's analysis was supposed to stop. All right, so holding the government rebutted the presumption of prejudice because the only juror who was exposed to the extrajudicial information was removed from the jury, and the jury began deliberations anew with the alternate juror. We therefore hold that the post-trial court erred in questioning the jurors about whether Hill's comments influenced their verdicts and in relying on the jurors' answers in its prejudice analysis. So the state contends that Murdaugh cannot complain about the post-trial court questioning juror Z regarding her affidavit because Murdaugh submitted the affidavit to the post-trial court with his motion for a new trial. See State v. Stanko. What a great name, Stanko.
Yeah.
So appellant cannot now complain of an error to which his own conduct induced, overruled on grounds by State v. Burdett. So we disagree. The purpose of Rule 606B is to preserve the sanctity of the jury room, protecting the jury system and the citizens who make it work. Tanner at 125, citation omitted. And then they cite the Texas Criminal Appeals Court, Cochran concurring. So, and this is, like Allie's right, I can't even see because I'm not looking at a huge blown up. So whenever there's a semicolon you're reading the citation, then what comes after it relates back to what they just cited. So, quote, we do not allow parties or the public to impeach that verdict with evidence of what occurred between the jurors in the sanctity of that jury deliberation room. So this right was not Murdaugh's to waive. Thus, the portion of Juror Z's affidavit in which she disclosed her mental process in reaching her verdict wasn't admissible. The post-trial court erred in questioning her about that portion of the affidavit, and the post-trial court should not have considered that portion in ruling on the new trial motion. So we also hold that the post-trial court erred in finding a lack of prejudice because Hill's comments were limited in subject and not overt as to opinion, were only heard by, at most, 3 jurors, and were made in a case with overwhelming and compelling evidence.
And again, that's I just wanted to make clear for people just listening and not watching. That's the Supreme Court restating what they disagree with about that's what the trial court has said.
Yeah, so we reiterate the burden is on the state to rebut the presumption of prejudice. First, the post-trial court erred in finding Hill's comments were, quote, limited in subject and not overt as to opinion, end quote. Hill clearly advised the jurors to find Murdaugh and the evidence he presented not credible, and essentially urged them to render a guilty verdict. Hill's position as the Colleton County Clerk of Court, an officer of the court who managed the trial and was the primary caretaker of the jury, amplified the impact Hill's comments had on the jury. That's gospel. That's gospel.
Sure.
It's like the jurors look at the judge as the ultimate being associated with that trial. They always give huge respect to the judge. The judge is rightfully respected by the jury more than anybody else in the courtroom. And a close second is going to be that shepherd, whoever that person is that's taking care of a jury, especially during a 6-week trial. Like that person that, again, feeds them, gets them water or drinks when they're thirsty, allows them to go to the bathroom, passes notes to the judge if need be, whatever they need. That shepherd, that bailiff, that clerk is their conduit to the outside world. So you can imagine that person and what they say would have huge sway with the jury, because frankly, the only person that's allowed to communicate with them. So in a juror's mind, they're going to be like, well, I mean, this chick is like kind of like running shit. Like she's got, we're hearing more from her than the judge. She's saying shit to me. It's got it. You know what I mean? It's like, there is no glossing over that. She is as huge influence on the jury. And obviously the Supreme Court of South Carolina realizes that. So here clearly advised the jurors to find Murdaugh and the evidence he presented not credible, and essentially urged them, an officer of the court who managed the trial and was the primary caretaker of the jury, amplified the impact of Hill's comments had on the jury. So C. Parker, U.S. 365, noting the official character of the bailiff as an officer of the court as well as the state, beyond question, carries great weight with the jury. And then McCormick says that the office of the clerk of the court is an elected one, created by Article 5, Section 24 of the South Carolina Constitution. Hill was elected by the very people who make up the Colleton County jury pool. So next, the limited number of jurors who acknowledged hearing Hill's improper comments did not reduce their prejudicial effect. As the Supreme Court explained, a criminal defendant is, quote, entitled to be tried by 12, not 9 or even 10, impartial and unprejudiced jurors, citing Parker. In addition, in the context of a jury tainted by external influences, the strength of the state's case does not necessarily warrant a finding that the state met its burden of proving lack of prejudice. The state certainly produced considerable evidence here, and arguably reasonable minds may debate whether the evidence here was overwhelming. in the situation before us, notwithstanding the strength of the prosecution's case, the state is unable to overcome the presumption of prejudice. The state's case rested largely on circumstantial evidence, and Murdaugh's credibility was a key component of his defense.
I just want to interrupt you right there.
I was right in the flow, girl.
But I think it's very telling that the Supreme Court does not say that the case, the state's case here, their evidence here was overwhelming. They say arguably reasonable minds may debate whether the evidence here was overwhelming. And I personally, I know you and I have a difference of opinion on this. I don't think the state presented a case that Murdaugh, and probably a lot of you out there are going to disagree with me, but that's, so be it. I don't think the case was proven against him.
Well, I mean, obviously, as to the financial shit, it was, but as to
well,
the
yeah, I'm not
murder,
talking about that.
Yeah, but that was 3 weeks of the trial. Like
Well, I know,
that
I'm just
concept
saying-
of them allowing Judge Newman allowing that much of the financial shit to come in for 3 weeks dirtied him up so badly. It didn't matter what they put on because it was all circumstantial. Like, I don't know what you think we disagree about. The only thing that I disagree about, you think that maybe he didn't do it at all. I just happen to think that he hired somebody because he couldn't pull the trigger on his wife and his kid. That's really the only difference. Like, I don't find that the evidence in that case was overwhelming as to the homicides. I mean, clearly he was there, but and like the defense, they put on some weird shit. The 5'2" gray people, there was some weird shit that they put on. They took some strange, like I can almost guarantee we're not going to be revisited by the 5'2" gray men, like in the second trial. They're going to come up with something different. Like I kept saying, why aren't they just saying that the guy's on his knee? One knee. Like Grin will tell you, if you're posted up, you're down on one knee and you're firing. Like that's the right level. You don't have to be like 5'2" little people. Like gray men.
I'd like you to get on one knee next to me. You're not.
I'm right
5'2".
here. I'm on one knee. Right
and
here.
I'm taller than you like that. So,
Yeah, but they're saying that it was 5'2" holding the gun down here. Same shit. Sorry, just is. You don't need to do that. Or sitting in the golf cart. Poop. Because that wasn't it. It wasn't like they were saying the 5'2" guys had the guns and the scopes up there. They were making it like, oh, there were 5'2" guys walking around like shooting from the hip.
well, their motive theory was just absurd to me.
The motive theory was the worst. It was so bad. And when you strip away some of the financials, which I think they're going to get to here in a minute, they're going to have to like, no one liked that motive. No one liked it because it didn't make any sense. It just wasn't like a real motive. Again, and I don't know where Alex's brain was. I imagine it was a lot like scrambled eggs. I mean, I don't know where the 50 grand was going per month. He clearly was not ingesting $50,000 worth of pills. He clearly, to me, had a side hustle. He was dealing. He was popping and dealing. He was getting high on his own supply, but he was also dealing. I think that his thought was like, I'm going to replenish the IOLTA that I've been bilking out of by doing this side hustle, making money, and then somehow figuring out a way to run it through this other bank to slide it back into my life. Whatever the guy was doing, he wasn't thinking rationally,
right?
But
his father getting sick put everything on pause. That if you're gonna, unalive somebody, why not the dying man?
Yeah.
Over your wife and son. I mean, if that's their ridiculous theory,
Yeah.
I forget what was Paul.
But I don't know why.
SC video. What was
It
that?
wasn't Paul's video that took you to beyond a reasonable doubt. It was the fact that he had lied about it is what took you to the beyond a reasonable doubt. And my contention had always been, and Ali will contest to this, he fucked up when he testified. It shouldn't have been the bullshit. Like, I didn't trust SLED in general. It should have been, I'm a lawyer. I've been handling criminal cases for a long time. My wife and my son were shot on my property. I was on the property. I'm not a moron. I
Right.
know that I'm going to be the suspect. I was not about to do anything, putting myself anywhere near those kennels, because at the time he makes that statement, he doesn't know that Paul had recorded that. Like, I would do the same thing, frankly. And it's a much more plausible explanation than I just didn't trust SLED because
Right.
of all the shit, you know, in our past dealing with SLED, whether it be in our cases or personal experiences. Like, that was crazy shit.
But
You
they
know,
also don't know the time of death. It's based on when the guy last used his cell phone and that
right.
he
It
let
was
his
the
cell.
only
Don't
first
if
time I've ever
if you're
seen that.
if you're no, I mean like his son. You're down
Both
by
of
the
them.
barn. How are you? You know, he never let his cell phone get below X battery percentage.
Yeah, like
Well,
6%,
he's
some
down
shit.
at the barn. You know, he was out like trouncing around looking for shit on the property. I thought. I don't know. Like,
Yeah, but
oh,
there's
his
no
phone got
evidence
below
that
6%.
there
Oh,
was no one else there. Yeah, I mean, like,
what do you need evidence that there was someone else there? Were the murderers leaving evidence that he was
for
there?
folks like Music to My Soul, apparently they need evidence that there was anyone else there. I'm not saying it. Music to
Oh,
My
well,
Soul.
music. I
So
mean,
this is what we're
killers
dealing with.
creep in and creep out without being seen. It was like so Bob and I we get this email from the school, our daughter's middle school. Well, we've determined the threat email and call to the school. It's nothing. It's nothing to worry about. Law enforcement has looked into it because the phone number is a spoof and the email's not coming back to a real person. And I say to Bob, what in the fuck? Do they think that killers use their real phone numbers and send an email from their like real email and say,
Stupid
hey,
ones too.
I know, but in general, to say, well, it's clearly bullshit because it was a spoof email. Wait a minute. To me, that makes it more likely that this is real. Because why are they using a spoof email? I don't
Yeah.
know. But
I
I don't know,
mean,
music to my soul, it's like, what did you what is the killer going to do? I mean, killers usually creep in and out unnoticed.
yeah, right. I mean, that's kind of the whole thing.
It's like part of
See,
their
but that
job.
was why I was of the mindset that Alec had hired them, and he called them in. He had them use his guns because he wanted to make sure that he was disposing of the evidence. He didn't want two crackheads running around out in these streets with guns. He's like, I'm going to handle it. You're going to come in. I'm going to give you the call. I'm going to tell you when I'm at the house, they're down at the kennels. I'm going to put the call in. You're going to come in. You're going to do the job. You're going to leave the guns. I'm going to scoop the guns. And I'm going to drive to my mom's and I'm going to get rid of the fucking guns. And I never want to hear from you pimps again. Here's your 10 grand a piece. Like, to me, that was always the more likely scenario. Because whatever you want to say about Murdaugh in terms of him being an absolute shitbag, which he clearly is, I just don't know if that guy was actually capable of killing his wife and son, no matter how fucked up he was in the head from the drugs. Like, there is no question. Like, you do not come from a family like that. You do not love your people like that and just get to a point where you're like, come up with some half-baked motive like the state was putting forward, and you're ending their lives violently. Like, his son's head was blown off. Like, that's a very hard bridge for me to cross, to think that Alex was the one who pulled the trigger. What I think, and he's just as guilty if he hired somebody.
Yeah,
Eh,
that's not the case
Tracy,
they
you
put
don't
on.
know him like Sharon. Tracy, you don't know him from a hole in the ground, girl. You don't know, and you don't know him like you just don't know him. We'll see. Like, the second trial is going to be interesting because, again, when you have 3 weeks of the financials showing what a scumbag he is, it taints you towards thinking that he's capable of everything. And I just don't know if he is.
Yeah, so Julia is saying that he wasn't involved at all, and somebody put a hit on him to get
Oh,
him
yeah.
to shut up.
So Julia's with me. Like, I mean, that's just where
No,
I'm
but
at.
he's saying that Murdaugh didn't hire the people. It was a hit.
Oh, dude, if he's pushing pills and he doesn't have to be
I
a
don't think he
drug,
was. I don't think there's enough evidence.
where
Showing
the
he was
fuck is
involved.
the 50 grand worth of shit per month at? He's definitely
I don't
pushing
know.
pills. He's not working. He's to the
Maybe he
point where,
was pushing pills, but I you
He
know,
is 100. Like he had
I'll have to
no-
reconsider the evidence when it's
He had
presented
no
again at
money coming
trial.
in. He was having to bilk from his clients his trust account. His own employees were like, he'd float in like once a week, like at 4:15. Oh, you know, like the dude was not working. And he was spending 50 grand a month procuring pills. I guarantee you, he was selling a portion of those pills. How much? I don't know. I don't know what the street value is per pill, but $50,000, you know, in terms of you're typically making 3 times what you paid.
Trace
know?
Bob just means because Tracy posted a comment that he was at work that day, like that in general, the man wasn't working like he should have been. He was showing up.
Yeah, Tracy, come on. He was barely showing up to work. Like at the end of it, he just wasn't going in. He wasn't going in. Like who gives a shit if he was in work that day? That's like that's nothing. Like he wasn't grinding.
And he used 2 guns. He's like got the wherewithal to shoot his like wife and then switch guns to shoot the son. Come on.
Yeah, I just like for me, like Allie's more of like maybe he didn't even do it. I'm more like
I'm just saying it wasn't proved beyond a reasonable doubt to me, not to me.
right, you know, and I get it. I get it. Like I never thought he wasn't going to get convicted because of the whole financial shit. Like he was going down. Like you can't get that stink off of you. You know,
What Music to My Soul says here is a almost a better motive. That if Paul's case went to trial, they were going to be looking into his financials, and you know
they were already looking into his shit.
I know. I'm
Like
just saying.
that wasn't their theory. Their theory was that in his warped mind,
Right, it would get him.
this horrible tragedy was going to be like the squirrel effect, that everybody's going to stop worrying about Alex and all the missing money. And now all of a sudden they're going to be concerned about who killed Paul and Maggie. And that's where all their attention's going to be drawn.
Right, I'm just noting that Music to My Soul's possible motive is much better than the one the state put out.
All I can tell you is this could be a lot of fun over here watching it. Like I'll challenge you. And I love the counter arguments. Like
People aren't going to want to watch because because they're going to be like, that crazy lady thinks the evidence doesn't prove he did it.
who? Wait, what?
Yeah,
Who?
People.
What crazy lady?
me. I'm the crazy lady.
Then they're not used to our channel. Like that's where you go to like Court TV and like, you know, whoever, like, you know, people that just scream guilty. I'll say, if you want to like challenge yourself and like intellectually like watch a trial and like have fun debates, it's the best.
All right,
That's
so
the whole
resume
point.
us here at the state's case rested because I love
Okay.
that sentence. I love
All
that
right. So the
sentence.
state's case rested largely on circumstantial evidence, and Murdaugh's credibility was a key component of his defense. Hill's repeated comments challenging Murdaugh's credibility directly undermined the defense. Hill's egregious, improper jury interference went to the heart of the case and unquestionably was intended to push the jury to a guilty verdict. See Barnes v. Thomas. So we are not convinced that the strength of the state's case against Barnes precludes us from holding that Barnes has shown actual prejudice. The focus of the harmless error inquiry is not on the sufficiency of the evidence absent the error, but rather on the impact of the error on the jury's verdict. So the breathtaking and disgraceful effort of Hill to undermine the jury process is unprecedented in South Carolina. Like, so we obviously aren't covering the Alex Murdaugh versus Becky Hill 1983 lawsuit that was just filed. This kind of language from the Supreme Court of South Carolina all but guarantees victory in that case. The question is, does Becky Hill have a pot to piss in? Because they're seeking $600,000. Like that's what they had to pull out of Alex 401k for attorney's fees. So it's basically restitution for what he had to pull out for that first trial from the 401k to make the 401k whole again. You know, because ultimately I remember he was ordered to pay all kinds of restitution, like after it as part of the
I was saying, I mean, that money should be going to his victims.
Well, he's never going to see a dime of it. he's never going to. The question is whether his defense lawyers are going to position themselves to get their hands on it. So, all right.
Who's going to try him this time?
Creighton will try him again.
For
No
free?
way. Oh, you mean who's going to defend him again?
I meant defend him. Sorry.
Yeah, no. Like it's Jim and Poot. They've said it.
Oh, they have?
Oh yeah. They're definitely defending him. Like there's no question. Like Jim Griffin is like Andy Baldwin as to Alec didn't do this shit as to his wife and son. Like he believes him wholeheartedly. Like he cries and shit. You know, he's like Alex could be like he's a massive piece of shit. He does the most dishonorable thing a lawyer could do. He's stealing his client's money, but that doesn't make him a killer. And he didn't do this. He's not capable of doing that to his wife and his son. Like he believes it. He believes it. I mean, I've heard him say it. Like he absolutely is unequivocal. Nah, it's a great, like Mav, it's an awesome comparison. It's spot on. Spot on. Back to the body. All right. So finally, we hold that the state has not met its burden of providing or proving the trial court's instruction of the jury cured any prejudice arising from Hill's comments. Generally, an instruction to disregard incompetent evidence is deemed to have cured the error. Moreover, jurors are presumed to follow the law as instructed to them, holding that any prejudice caused by the alternate jurors' presence in the jury room as deliberations began was cured by the trial court's instructions to disregard anything that the alternate jurors said, and thorough inquiry of the jurors to confirm that they could put the alternate jurors' words aside. Here, the trial court gave the standard instructions and admonishments to the jury, none of which provided guidance on what to do when the Colleton County Clerk of Court, an officer of the court, made comments disparaging Murdaugh's credibility and urging the jury to reject the defense. The trial court never had the opportunity to even attempt to cure the prejudicial effect of Hill's comments because they did not come to light until months after the trial. If we were to accept the proposition that standard charges could cure prejudice, then no defendant would be entitled to relief when improper extrajudicial information reaches the jury's ears, regardless of its content or context. Our federal and state constitution simply cannot countenance such an assault on the right to a fair trial and impartial jury. In summation, Murdaugh met his initial burden of establishing Hill's comments to the jury were more than innocuous interventions, triggering the Remmer presumption of prejudice and shifting the burden to the state. The state simply was unable to meet this heavy burden of proving that there exists no reasonable possibility that the jury's verdict was influenced by these highly improper comments. To implement the heavy obligation of the party who seeks to rebut the presumption of prejudice, we have prescribed that the proof must establish that there was no reasonable possibility that the verdict was affected by the contact. Accordingly, we hold Murdaugh's right to a fair trial by an impartial jury was violated, and the post-trial erred in denying his motion for a new trial. So stop and discuss.
Right. And I don't think that we necessarily need to. My question is, do we summarize this financial crimes, which isn't part of the order, remanding, or do we read it outright? It might be actually the most interesting part. I don't know.
I mean, it was interesting. You didn't think that was interesting?
No, I did think that was interesting. I'm just saying the financial crimes doesn't really go to the whole, that's kind of where it ends with we're reversing remanding for those reasons.
Amazing. Yeah, Mavhawk, until you've tried a case and worked with the defendant and the thing about Rick Allen, obviously we believe he's factually innocent in terms of you're thinking of it from the defendant's perspective and how you feel about whether or not the person did the thing or didn't. That's not what we're talking about. When I'm talking about what Jim Griffin believes as his lawyer and based on what he knows and what his client has told him, that I'm sure would never come out at trial, and all the evidence that he knows of that probably did not come in at trial. You know, it's like, that's what you have to kind of look at when I look at it from the inside or from the outside looking in. And I'm like, it was like when Andy and Brad, especially Andy, when Andy was like, my guy is factually innocent. I was like, all right, that's weighty for me, because it's a big move for a trial lawyer, a defense lawyer, to come out and say something which ethically we're not allowed to say. You know, that my guy is factually innocent. We're ethically not supposed to say that because it taints the jury pool. But what did it for me in that case was when Gull's two handpicked guys from her own county and a guy that was the head of the public defender's division in her courtroom and it was known to me by people that work with him that like it was like an errand boy for her. Like it was an inside joke in the public defender's office in Allen County that if he got a text message and he was running out the door, it was like, oh, Gull needs something. So like when those two guys turned around, and especially Labredo, when he turned around and said the same shit, it's like, that's all we have to go by. They have way more knowledge in terms of what the defendant has told them and what the evidence is that may not ever be admissible, may have no way to get it in. And they come to this conclusion that their person is factually innocent, and they feel so strongly about it that they go ahead and put themselves out on the line, potentially looking at a complaint to the disciplinary committee because they've gone too far afield. You know, so that's really what it is. It's not a reflection on the defendant or whether or not you think they did it or they didn't do it. It's when I look at a defense attorney and they make that kind of a move, to me, that carries a lot of weight. It just does. And you know, that might affect me. That might affect me in a way that, you know, because we're defense attorneys, I give it more weight than I should. I mean, that's certainly possible. But, you know, I've just seen Griffin enough to like, that dude really believes that Alec didn't kill his wife and his son. Like honestly, to his fiber, every fiber of his being, you know?
Right.
But I don't know.
So do you want me to start reading part B, or do you want to just do the discussion of it?
I mean, we could just do the discussion of it, or we could do it on a different live. I mean, we are at like 5 hours.
No, we're not going to start over just to read the last 7 pages. We just power. I don't want to do a whole live on just I don't know, unless you think that's, we'll never get to it. Let's just either do it now or do the discussion. Like just discuss it or read it.
Well, how long is the discussion going to take? Because reading it is probably another hour.
The discussion will take, 5 minutes.
I vote discussion.
All right. So the next part here is part 2B. And the first thing to understand is it's status. The court has already reversed in part 2A. It did not even need to reach the questions at all, but it chose to give the trial court guidance on remand. So this section is the court steering the retrial on purpose.
Okay, so I mean, the evidence at issue is obviously Murdaugh's financial crimes, and like I just want to be clear, and I want to throw Iceman's comment up. So Iceman had asked Bob and Allie, "Do you think that South Carolina would have reversed on the financial crimes if no Becky Hill?" It's an interesting argument. Like, what do you mean? Like they didn't appeal on the financial crime?
No, they did. They did. That's just what the court is saying. They did, babe.
No, he has pled to the financial crime.
No. He means on the financial crime issue.
Honey, I guarantee you.
What Iceman is asking
Okay.
is on the financial crime issue, on the issue of whether they introduced too much evidence of the financial crime at trial, is an issue that he did raise. We watched the arguments.
I know that.
Right. That's what Iceman's asking.
Are you talking about the fact that he pled guilty to the financial crimes without going to trial? Or are you talking about the issue that they allowed that much of the financial crimes to come in at the murder trial.
He's
I just need you to clarify it. Because the way I read that, it doesn't say issue. The
Like, that's
financial
what he's
crimes.
saying. They're limited in words anyway. It's clear to me that's what Iceman means.
But do you realize he pled out after the fact? Because I know you weren't even.
I'm not
looking at-
talking about the financial crimes case. I'm talking about the financial crimes evidence offered in the murder case, and that's what I think Iceman's saying. And we'll have to look in the regular.
Yeah,
comment.
let us know. So I mean,
Iceman says bringing all that stuff in is what I meant.
I
So-
don't think. Yeah, I don't think so.
And I do, because now we're just going to have to read it, because it specifically, they found unanimously that there was too much, that they went too far and too deep.
Yeah,
So-
but to the extent that it made it impossible for the jury to find him anything other than guilty based on the fact that they dirtied him up so much with that shit. Is that what they're saying?
I mean, maybe not all that, but I think that they went out of their way to focus on this. They went out of their way to focus on it at the.
But they only did that because they knew that they were having to give him a new trial, and they were trying to give them guidance for the next trial.
Right. I think they wanted to be like, we hint, we might have just reversed your ass, even though we're saying we wouldn't have. That's my opinion. You know, it would have been a hard one. Maybe their hands would have been tied, you know, but.
I mean, it is an interesting
All right.
conversation.
So
All right, so
let's
after the murder trial, he pled guilty to a sweeping set of financial crimes, and he's serving 27 years in state prison and 40 years federal, concurrent for both. So the state's theory at the murder trial was motive, that the financial crimes were about to be exposed in the days right before the murders. 3 rules are in play: 401, 402, relevance, and 404B, the rule against using other crimes to show propensity, and rule 403, probative value against unfair prejudice.
So maybe we do just read it, or you want to just.
I mean, at this point, no. Like
Okay.
we'll just summarize it. I'm going to read it because I haven't read this part of the opinion yet. Like personally, not on a live,
Right.
because I want to see what they're saying.
All right. So the court splits this into layers. Layer 1, relevance. And the court says the financial crimes evidence was relevant to motive easily. It uses a line that was great. The evidence carrying the weight of a feather is enough to tip a balanced scale. So then you've got layer 2, which was the 404B, the propensity rule. And here the court is candid. It says not every justice would have made the same call as the trial judge, but, and this goes to Iceman's question, on appeal, the standard on appeal is not what they would have done. It is whether the trial judge abused its discretion, and the court holds he did not, admitting some financial crimes evidence for motive, some was within the trial court's discretion. But then on layer 3, rule 403, and this is the unanimous, no hedging part. The court says the trial court let the state go far too long and far too deep. The state spent 12 and a half hours of testimony over 10 days on the financial crimes in a murder trial. And if you watched the arguments, the arguments live, and we had them on, and I think other people did. And babe, while I'm going over this, just quickly review this part of the order to see if there's anything else you think like stands out to you that we should read.
Well, this stands out to me. We agree with the state that the evidence of Murdaugh's financial crimes made the state's theory of the motive more probable. Like I wanted them saying like that motive sucked balls.
I know, but yeah, that's why I guess I should have cleared that up when I was saying they found it relevant easily, and that it would have been allowed in, which I just think is stupid. But so the court gives a concrete example of this whole far too long and far too deep, and it was the Tony Stafferfield testimony, where the state elicited that Stafferfield's brother is a vulnerable adult with a disability. Again, it was one of the questions that the court talked about during the live argument. The court says that it had zero probative value for the murder motive. It does not make the motive theory stronger what it does is paint Murdaugh as a man who preys on vulnerable people. That is unfair prejudice. So, you know, and here is the part, like, people will get wrong, like other non-lawyer commentators on this. So let's be precise. The court did not order this evidence admitted on retrial, and it did not order it excluded. It said the facts on retrial may be different. The trial court has to do the 403 and 404B analysis fresh. The only firm command is if the evidence comes in, the state has to do it efficiently without the lengthy parade of inflammatory detail. So they make clear that this is guidance. It's not a binding holding on the evidence for the retrial, but it's guidance with the target on it. And
See,
for
that comment by them is what made me think that it wasn't the type of issue that they would have reversed and remanded on.
and as I was, even thinking about it as I was saying it, I'm like, yeah, that might speak to Iceman's comment, and that they wouldn't have reversed.
See,
just
and
on
the
this.
reason well, first of all, the reason that I took Iceman's comment the way that I did, because number one, words matter. You gotta write things succinctly. And number two, I had gotten into this exact conversation over on Tony's Live, which we did on Murdaugh today, because it's interesting. It's interesting if Newman hadn't allowed all of that financial crime shit in. Number one, does Murdaugh testify? I think he does because of his ego and his narcissism. And
Right, but you could have argued that he wouldn't have. You and I
right.
kinda discussed that.
The weight and the volume of the financial shit created a situation wherein he had to testify, which in turn, because he's under oath and admitting to doing these things, he had no option other than to plead out after the thing. I mean, Creighton Waters killed two birds with one stone in terms of being able to put that volume of evidence on, which was so much that it forced Murdaugh to testify under oath and make absolute admissions that I did this. Yes, I stole my client's money. It was done. It was fait accompli in terms of that was never going to have to go to trial because he admitted it under oath. So if those financial crimes wouldn't have been admitted, would he have even testified? And if he doesn't testify, then there's still, and look, they had him like he was dead to rights on the
rights
shit, So, I mean, it wasn't like he was ever going to be able to fight it, but yeah.
And I mean, you got to think about it here. He's already in prison 40 years. How old is he?
Who? I mean, he's got to be in his 50s, maybe early 60s.
Right. I mean, he's not getting out anyway. I almost wouldn't even waste the taxpayers' money to do it again, except you serve 85% in federal, and there might come a time where they're like, hey, these federal inmates are getting too heavy. We got to start letting people out. Let's start with financial crimes.
This guy says he's 57. What's up, Sleuth?
So I was just going to say that
I didn't know. I'm sorry to interrupt you, babe. Did you know that they filed for change of venue?
In Murdaugh?
Yeah, which is interesting because it was their mindset that because of the Murdaughs and their legacy in that town, because I was like, when that shit came through, and I'm like, it was like every case, I'm like, why are these fucking people trying this in this county where everyone knows about the case?
And his entire family.
Right, and his entire family. So,
and he robbed the community.
And right, and they realized that was a terrible blunder the first time. So now they're moving it, and I'm sure it's going to be granted. So it's definitely going to be tried somewhere else. No brainer. It was like I felt the same way about Delphi. And obviously they did, but they still held it in that courthouse in that town, and they just imported Gull and the jury from Allen County. There, I would have liked to have seen it just moved completely out of there.
Well, it's the same difference. It's just where everybody's sitting their butts.
Yeah, I mean, every case that they keep trying cases that are high profile in the county that the thing happened.
Right.
And it's like you make that weird distinction it's like it's such a gamble. You're like, oh, well, Karen Reed, like all the people here in this county know how corrupt they are. Well, I mean, that's a huge gamble still, that you're assuming that you're going to get 12 people on a jury that are just that knowledgeable about how corrupt shit is there, that you're not worried about trying a case and the death of a cop in the county it happened in, where everybody in that town knows about it,
Right.
So, but it's like,
Luckily, it
yeah,
worked out there. But yeah,
crazy.
you're right. I mean, it's a
It's
risk.
crazy.
But this ruling is still, nonetheless, even though it's just guidance, it's a gift to the defense.
Oh yeah.
So Murdaugh's retrial team now has the state Supreme Court on record saying the first trial went too far. I mean, this is a ready-made motion, a motion in limine before the retrial even starts.
Yeah, I mean, it was a gift in multiple ways. It was a gift for what you just said, and it was also a gift in terms of the 1983 claim. Like, they're going to be, I promise you, and I have not read the complaint, but I guarantee you they plucked language directly out of this opinion and put it right in that complaint.
Somehow they didn't. They sure as shit should have waited.
I'm sure they did.
Tweaked the complaint. I don't know when it got filed in relation to when
I
this
think it
order.
got filed today or yesterday, like
Okay.
after this dropped. But I
Right,
mean,
so
I'm
they
sure
would've-
that they were, drafting it ahead of time.
Right, and then they had to plug some of this in. I would.
They're
If
like,
they didn't, if they didn't plug any of this in, then the lawyer needs to have his head examined.
Oh, we got to put the thing with Becky Hill's thumb on the scales in there. So we got to put that in.
So like that shit's crazy. But like to Allie look, this is a great example of an absolute piece of shit that's getting a new trial because he didn't get a fair trial. And it's that simple. It doesn't matter how horrible the person is. That's why we try to get it right the first time, because we don't want to have to do it again. And, I mean, this guy, like, how it's going to play out, I don't know. Like, I really don't know how it'll play out. I don't know. Does it go to trial? Does the state think better of it? Or they're like, oh, well, like, they're going to want him to pay. They're going to try him again. There's no way they're going to say, well, he's probably going to die, because they're running concurrent, not consecutive. I mean, he could creep out like as a 97-year-old man, walk out if they don't try him on this. It's like, I don't know, but they're going to have to look at the strength of their case in light of the guidance given to the trial court and the lawyers by the Supreme Court of South Carolina. So they're going to have to trim the fat off the financial shit, and they're going to have to decide, is our evidence strong enough? Because like everybody has the advantage of seeing how it played out the first time at trial, and they're going to make tweaks. I mean, Karen Reed tried a completely different case. The defense lawyers did. They got rid of all the House defendant shit.
Right.
Allen threatened it in openings, and they never touched it. They did what I was hoping and praying and yelling for them to do, just focus on the science. It's exactly what they did. So I don't know.
So,
It's crazy.
Just jump into page 23, and you could put it up. Talks about how Murdaugh is challenging it under the rules that we mentioned. And the court notes that, it may, however, be admissible to show motive. And I don't know if you already, oh yeah, you read that part. Okay.
Yeah.
And then they just say that it's seemingly inexplicable conduct when standing alone. It wasn't, the state argued that it was important to offer this evidence of why he did it, and that Murdaugh himself placed the issue of motive in front and center by his own words and actions, by suggesting the officers who arrived, like Bob said, at Moselle on June 7th, that the killer's motive stemmed from the boat wreck. Bob already read how the court, found that it made their theory more likely. So they find that, again, that it was evidence. Now, I don't know that they're really saying here that they find it more likely. That's the test for relevance. So in order for evidence to be relevant, it has to make an issue of fact either more or less likely. So they're saying, okay, yes, we agree these financial crimes makes the state's theory of motive more probable. But I don't know if they're necessarily saying, oh, we agree. That makes it more probable. That right there.
Well, they
they're just-
should have, like, I wanted them to say that motive was a big pile of goo because it sucked. Like, it
No,
just
I-
did suck. It still sucks. The boat wreck part of it sucks. It's like the concept that he's pushing shit off for a few weeks while they deal with the deaths doesn't make anything go away.
Well, and that might come into the balance of probative, the level of probative nature. So maybe let's pop down to there, because they say here the more difficult question is whether the trial court should have excluded all or some of the financial crime evidence pursuant to 404B or 403. And that's the one I was just talking about, whether it's more prejudicial than it is probative. So they're going to get into here what parts of it were why it was so damn probative in the first place. So we'll read this portion of it. We address the question as two distinct categories of issues. The first of these categories, whether the trial court should have excluded all the financial crimes evidence, is a point on which not all members of the court would have ruled the same way as the trial court. We each agree, that each being of the justices, on the panel. However, this was a decision within the discretion of the trial court under the facts and circumstances that existed. So then they go on to say that we unanimously hold the trial court allowed the state to go too far and too deep into aspects of Murdaugh's financial crimes that were not probative of the state's theory of motive, and which gave rise to considerable danger of unfair prejudice and therefore should have been excluded. As to whether the court should have excluded all the Murdaugh's financial crimes under 403 or 404B, we have discussed the principles applicable when the trial court is asked to exclude evidence of other crimes in numerous cases, and no further elaboration of those principles is necessary here. And they cite those principles anyway. So they go on to say, as to Rule 404B, the difficulty lies in the application of these principles to the facts and circumstances of any individual case. Here, the trial court correctly understood the applicable principles of law and thoughtfully applied those principles to the facts and circumstances before it. The trial court explained its view of the logical connection between the financial crimes and the Murdaugh's motive. The state's argument that it presented a valid theory of motive and Murdaugh's response that the fabricated motive theory is illogical, implausible, and not supported by the evidence was not a dispute for the trial court to resolve by making this evidentiary ruling. That was for the jury. The trial court's job was to determine in its discretion whether the state's theory of motive was reasonably plausible, and if so, whether the evidence the state presented could support the theory. And the court said, we agree with the state that under the facts and circumstances in existence in Murdaugh's first trial, the trial court acted within its discretion in deciding not to exclude the evidence under 404B. Now, as to 404.3, the trial court balanced the probative value of the evidence against its potential for unfair prejudice and concluded the probative value was not substantially outweighed by the unfair prejudice. The trial court specifically found Murdaugh's commission of the financial crimes, quote, does not suggest to the jury that the defendant has a tendency to commit murder. As we will discuss below, we find considerable unfair prejudice in allowing the state to go too far deep into the detail as it did. However, we hold the trial court acted within its discretion by admitting some of the evidence.
Yeah, they really don't answer whether or not which way they would have come down if the Becky Hill shit doesn't exist. I mean, like,
Right.
they might have, they
might not have. And they might not have.
I mean, they clearly knew it was within the judge's discretion. It all becomes a balancing test. Did he allow too much in, and it was too much that it just didn't create the ability for them to get a fair trial.
And the more I think about it, babe, like Iceman's question I'm talking about, now if that was the question before the court, whether this evidence was should not have been admitted, or too much of it was admitted. Now you do have your typical harmless error test where they are balancing the evidence against the defendant and say, but the evidence was so. Now again, they said that like reasonable minds might actually, what was the word? Debate, might not agree, whatever the word was, on whether it was so overwhelming or not. But it's still possible that they could have found it to be overwhelming, but that also might be a hint that they wouldn't have found it so overwhelming, given it was such a highly, circumstantial case, enough to tip the scales in a harmless error test. So, it really could go,
Wait,
either.
Julie is saying no. They said earlier, Bob, that they would have decided with discretion. Well, we know that they found it was within the judge's discretion to allow it in. That's a different question than whether or not he allowed too much in.
Whether it became more prejudicial than probative. Now, for
Right.
example, they clearly found this one section
Oh,
that they
such a
emphasized
big cough.
and that we talked about in our little discussion points, that this one piece about Statterfield was, it says this particular testimony had zero probative value. Although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. So, and then they go on to say much of the additional details the state presented as to Murdaugh's financial crime had little or no probative value for the purpose of establishing Murdaugh's motive. The state's theory of motive centers on the point that his financial crimes were about to be exposed and he needed time. The fact that he committed some of those crimes against a vulnerable adult adds nothing to the theory. To the extent many similar details may have had minimal probative value, the value is substantially outweighed by the unfair, prejudicial sympathy the jury was likely to feel towards the victim. By our calculation, the state spent a total of 12.5 hours on the testimony. We are convinced the state could have effectively presented evidence to support its motive theory in a fraction of that time.
Fraction.
Right. By holding the trial court in this case acted within its discretion in admitting some. They keep doing that, and they keep highlighting it literally by putting it in italics, that when a court does that, it's like, I'm not just saying it, I'm really saying it.
Yeah.
Lawyers may use it more than courts use it. When a court uses it, in their opinion, they're screaming. It's like texting in all caps. Would you agree?
Yes,
Okay.
definitely.
So
It's
again,
yeah.
going back to Julia's comment, and I appreciate your comment, and you're right, but they keep clarifying it. They keep putting a little contingency on this whole within discretion, some of the evidence. And by saying that, they're literally saying that they was an abuse of discretion in letting it all in.
I mean, we draft it as lawyers, and we use italics. We put in parentheticals, emphasis added to Allie's point. It's the same thing. The judges are like, oh, well, we don't have to write that bullshit, emphasis added. You should know.
And
if
when
we're
it's
italicizing some shit, we mean it.
Well, no, when we say emphasis added.
You may be making a different point, but what I made is a yes as well.
Yes, your point is a yes. When we're quoting another case and there was no emphasis, but now we've bolded it or underlined it or italicized it, we say emphasis added, meaning this wasn't what the original court had. To that same point, when it's already bolded, italicized, or whatever, we write emphasis in the original so that the reading court knows the original court actually literally emphasized that specific line or word itself, because it does matter. And when it's us doing it, the courts don't really care. When it's the court doing it,
they might. We're like, hey, this is important.
They're definitely going to note it as something we think is important, and they're going to see it, but it's not going to be like, oh, they emphasize.
What's so fascinating about this case is as we all know, you never have to prove motive. But in this case, you really kind of do. Like, Waters had to feel going into this trial, like, okay, we don't have to prove motive. It's not an element of the crime. However, we have to give the jury some kind of reason as to why Alex Murdaugh would have done this. And it's like they're sitting there thinking, like, what could have driven him to do this? And it's like all this is some shit that Creighton Waters and the rest of the prosecutors that got together talking about this case came up with in terms of a theory.
Yeah.
They have no proof of it.
No.
None.
That's what it always is.
Like
they're just their story, their narrative.
Roadside shooting thing. Like, if Murdaugh didn't intend on having whoever that was, I can't remember if it was a cousin or some fuck, whoever that guy was who shot him and didn't hit him, just skimmed his skull. Like, why isn't that guy testifying? I can't remember. Did he testify that Alex specifically told me to make sure you don't accidentally kill me? You just got to graze my skull. Yeah, his cousin.
I don't remember the testimony at all.
Cousin Eddie.
I remember the name, but did he testify?
I think Cousin Eddie testified, right? Yeah, he testified.
All right, so I just want to
My point is like, I think Murdaugh had every intention on Cousin Eddie killing him. Like otherwise Cousin Eddie would have said, Alec told me, make sure you don't. Oh, he didn't testify. Damn.
See, that's what I was saying. I didn't think he testified.
Fucking A. Well, he's going to testify now.
I mean, is he? I don't know.
I don't know why. Like, why wouldn't he?
But I just want to also point out to all the people that when the court takes up an issue, it doesn't need to. After it's already reversed a case, that is a huge flag being waved, red giant flag to the trial court. Don't do this shit again. We take issue with it. But they don't want to put in too much language because, when judges talk, it becomes law. And this is all what's called dicta. So it wouldn't be as compelling, like, to rely on for lawyers to quote in other circumstances. But I guarantee you, lawyers are going to quote it, and the court knows someone's going to come around trying to quote it, and then someone's going to argue, well, that's in dicta, But in any event, when they take up an issue like that and they say, I'm giving you guidance, that's a big deal. It's a big deal. And although they highlighted that one about the vulnerable, victim, they specifically say here, that by holding that the trial court acted within its discretion in admitting some, like we read, we certainly do not intend to require the evidence be admitted on retrial. As is often the case, situations change. Thus, the trial court on remand may do as the trial court did here, carefully and thoughtfully apply correct principles of law to the facts and circumstances before it. We do intend to require, however, that if the trial court decides to admit evidence of Murdaugh's financial crimes on retrial, so if you even decide to admit it on retrial, the state must complete its introduction of that evidence efficiently without the lengthy presentation of inflammatory details with little or no probative value that was permitted in the first trial. So it's not just that one little piece. They're saying, and they said it when they first cited to that one specific instance that they flagged. They said that there was much of the additional details the state presented as to Murdaugh financial crime had little or no probative value. So it's a pretty big. It
is. I mean, it's simply put, they had absolutely no obligation to mention word one about it. The fact that they did speaks volumes. It's that simple.
Yeah, you know what? You took it down, but let's just read footnote.
No, just
15.
read it without putting it up.
No, that's what I'm saying. You don't have to put it up. Oh. Footnote 15 here for like what I said in the beginning about how the court, like,
right,
even if
you want me to read it,
I'm reading it right now, or you could read it. Even if the court is like giving a little smack to the trial court, they still like go out of their way to be like, you were amazing and you're still great. And footnote 15, it's after the conclusion, it's at the very end, and it says, we commend the post-trial court, which inherited Murdaugh's motion for a new trial and was placed in the unenviable position of evaluating unprecedented jury interference by a clerk of court within the context of a murky area of law. Like, like I'm going to slap you with one hand and then give you an excuse and praise in the other. It's annoying.
No, it's like I'm going to slap you in the face, but I'm going to be patting you on the head at the same time.
Yeah, that's even better.
Yeah. It's ridiculous. Like, she's a shitbag. She's a shitbag. She created the situation. It's not murky. It was absolutely
not murky.
There was no murk.
The murk is minimal.
Unmurked.
But I can guarantee you, in my mind, the fact that all that other evidence came in on a highly, as they called it, highly circumstantial case. Okay. There was no chance in hell that they weren't figuring out. They had to reverse a case. They had to clarify 2 cases. They had to reshape their, hey, we got to change the law around a little bit to make this happen the way it needs to happen. It's a thing. It's a thing.
Yeah.
Did we do, oh yeah, that was the pirate thing. Did we do Julia's comment about see you at the green door?
Oh, no. That's good to know. Yeah. Just a little reminder, Ian coming in town. I think he's getting in the 27th. He's staying with us out at the Mata Crib. I'm going to drive him down for what he needs to do in the city. And I'm sure those of you that follow Ian and his adventures, I'm sure you know what's leading him into the great city of Chicago. So I'm going to go hang with him. I'm going to take him for some pizza. I'm either going to take him to Pequod's or I'm going to take him to Uno's, depending if he wants.
I was gonna say, what the hell is Pequod's?
Pequod's is fucking delicious.
I don't recall you ever taking me to a place called Pequod's.
It's because I wanted to take you to Uno's. It depends on what he wants, whether he wants true thick, thick
Is
crust.
Pequod's the place that does the salads and the bowls and the subs? No. But what's strange is in 28, wait.
It's not strange.
In
Uno's is my
28
favorite.
years, you've never taken me to this other place.
I haven't been there in 28 years.
So
I haven't been there since before you. And Uno's is my favorite. But again, I'm going to say it again. There are different styles of pizza. It depends on if Ian's I don't want a piece of pizza that's got 3 inches of fucking mozzarella on it, and I hate tomatoes on top of my pizza instead of underneath the cheese, then Uno's isn't for him.
Right.
And Pequod's is the place. And I told him I'm bringing him to Johnny's Beef. He's about to fuck with the Johnny's Beef. He's going to go back up to Canada, and he's going to be like, oh, man.
I'm going to start a beef.
But at any rate, on the 30th, Green Door Tavern, 6 p.m. We're having a meetup. A bunch of Ian's people, hopefully a bunch of our people will come. Allie will not be here. It'll be our niece's graduation from college in New Jersey. The only reason, what?
No, that's a different weekend altogether.
Will
That's
you be
where
here?
I'm gonna be helping the kids with the baby's birthday party, which is the 31st.
Which is the next day.
Yeah.
My granddaughter's birthday.
But I do want to say before people start to drop off, after
they only had 230.
I know, but because there's so many few here, I need to say this. After our Austin Drummond live, I think a lot of you did what I asked him was look, I'm spit talking. Unliked and reliked after the stream was over, and then hyped it, and we got 28,000 views on an Austin Drummond live, which is amazing because we don't usually get that much for Austin Drummond, and it's a way to get his story out there. Now, I don't even know right now with the limited people we had on this live if the hype will be available until more people start to watch it. But if y'all could just keep an eye out and think about it and give it a try, it would make a huge difference. It was the biggest thing that we were like, what? Woke up in the morning, we're like, well, what?
It was definitely not the biggest thing that we've ever done, but it was.
No, I didn't say the biggest thing we've ever done. The biggest, way that they have impacted our streams. Had the biggest impact on the visibility of a stream is what I meant. we were like, what happened? And I was like, you know what? People must have done the unthumbs up and 3 thumbs up and hyped it. So
Yeah, like people were crushing the hype like that. There's a way to check the hype, like where your shit's at in the hype charts. I cannot
I don't know.
figure out for the life. Well, I want to know.
Well, let's
I can
figure it
ask
out.
Mel, like Mel and Rebecca.
I was gonna say not Melanie Little because she
No,
doesn't get
no,
into all
no,
that
no,
stuff.
Mel ain't no little. She's all right. She's in our world, tech wizardry wise.
Right.
all
But
right,
Julia,
cool.
thank you for your continued support.
So we did a lot of them, right?
No, we're here.
Lucy Part 2, I got that. We're getting that. Grin, I sound amazing. We did all that. We got all the Grin stuff in. So are you in the right place?
I think you're higher up. We were at Grin for Me saying, "Is you high, Bish?"
I played it.
I
for
know.
them.
And then he said, "Allie, you don't need to get a snack. You are one."
Oh,
Got you, babe. Bob. Sorry.
Got you, Bob.
Got you, Bob.
thanks, Boo.
Oh, and then we did do Iceman's. And then Sky Goddess, thanks for your 1 year. Happy anniversary.
Aw, a year of family hugs.
I'm like, I was echoing back through your computer somehow. And she says, so happy to be a part of DD family. Well, we are so happy to have you.
Yes, we are.
And then, yeah, I guess we are almost done because then the last one is Music to My Soul. I was emotionally exhausted by the first trial. I can't believe we're going to do this all over again. Thanks for nothing, Becky. We appreciate your support. And I think that gets us everyone, hopefully.
In our daily angel, Kim,
Ah,
always floated another beautiful $25 to us via Venmo.
I don't know. Did
What
you
an
think?
angel. What an angel.
Yes, very thankful. We're very thankful for you, our angel. Did you give Brenda's? Unless that's
dare you.
Brenda's. That might just be Brenda's.
Aw, family hug. I was like, what? How dare you speak to Brenda like that?
I think there was some more. So we had Grin for Me again, super
Oh.
generous this evening.
Oh, wait.
Someone, what?
Sky got us.
Oh,
She threw us a 20 over on the Cash App. Thank you for the double feature. $20 solid.
thank you.
Oh, you're the sweetest guy. Thank you so much. I think there may have been a PayPal too.
You look while I go over all Grin
I'm gonna
for
go
Me.
check it while you do that other thing
Yeah.
you talk about.
So
doing.
Grin for Me keeps coming back, super generous this evening. Someone pulled Juror Z's financial. Confirmed, Juror Z took the egg bribe.
Ooh.
Eee, boy.
Oh
Oh, gosh.
yeah. Oh,
Abby Xing.
the
I think.
beautiful Mary Weeks sent us $10 on PayPal.
Were
You're
you
so
supposed to
sweet.
give her first and last name like
I
that?
think Mary's whole full name is in here. If I'm incorrect, I'm sorry, but I feel
Hey.
99% certain I see Mary's full name in the chats.
All right. So Abby, thanks for your generosity. And she says, we were live earlier and you're still live. Love y'all. Should
Yeah,
we
so much
do-
for short video ideas. Wow.
Should we do a beer for every accent? Absolutely.
Julia,
you're
no on Lou Malnati's. Like, have you ever been to Uno's? I'm not talking about the shitty chain. I'm talking about the original. The original Uno's and Due's down in the city is so much better than Lou's. It's better than Giordano's.
Not
been
the
up in
chain
here.
Unos, though. Not the chain Unos. It's like you got to go to the original one.
It is indeed. No, yeah. So funny story about Uno's. Allie and I, when she invited me to come out live in Pennsylvania, and I had taken like Uno's, which is down kind of in it's really in the loop, the north portion of the loop, and they've been around forever. And so when Allie was in law school here, we went there. We went and delighted in the wonder that is Uno's Pizzeria. And it's like you got to put your shit in. You're ordering a hour ahead of time. It's always packed to the gills. It comes in this just like giant like pan, and it's like it's delicious. It's the best pizza by far. Like I love their sauce, which is stewed tomato. It's so good. So at any rate, like we move out to Pennsylvania and we're driving. I'm like, holy shit! I'm like, there's a Uno's. I'm like, can it possibly be? I mean, what are the odds? It's got the same kind of font. So we go in there and I proceed to have the shittiest fucking pizza. It was like worse than Pizza Hut. I go up to the guy and I'm like, I'm from Chicago. And I'm trying to are you like affiliated
Are
with
you
the Unos?
authorized? Are
Right,
you bona fide?
affiliated with Unos and Dues in the city? He's like, oh, yeah, they own the chain. I'm like, well, this pizza's ass. I'm like, why doesn't it taste anything like the pizza? He's like, no. He's like, we could never do it. He's like, we have quick turnover. We changed the whole. So like, yeah, that's like a chain shit. It's nothing like the pizza that you get at Unos or Dues. It's just not.
Right.
But there is a chain, and it's not representative. I think it diluted their brand by putting that shit out there. Like if I was eating that shit out there and I came to the city, I'm like, is it the same ass pizza that I'm getting like out where I live? I'm not going to eat there. I'm going to fucking Lou Malnati's.
I mean, I think people that walk by are going to be like, "Wait, why is there a long line at this Uno's?" And maybe they'll, I don't know, but I think you've got to be right. So Grin for me, coming back again, says $20, says Jersey, got blue hair and uses the words, I'm uncomfortable at least 4 times in any adult conversation.
That tracks.
I mean, Jersey stood up and spoke her truth or his truth. How do you say this? AG
Curly?
gifted 5 defense diary.
Wait, did you go back up to the top?
Yeah, I realized we missed some. And look at those.
I mean, I
adorable
definitely
children.
put them up, but we didn't shout them out.
Right. Look at those adorable children.
No, those are cutie pies.
And then Brenda says she stole county funds. She involved her son in eavesdropping on city officials. She manipulated and interfered. This was not her first rodeo.
True story.
You got to make your noise. I'm Becky. Do the thing.
I'm Becky Hill. I'm Becky Hill. Fuck y'all. I'm Becky Hill. I'm gonna sell me some books.
Oh boy, Mittens, 1970, became a YouTube member. And what does Mittens and the adorable kitten get?
Aw, family hug. That's what they get.
So Grin for Me says, because I told him, hey, I'll keep an eye out, and then I didn't, I guess, for your free chat, so you don't keep having to spend all this money. And he says, I do this because I have the funds and I am financially able. Also because you deserve it, not just to be seen, literally. Hashtag feeding Bob.
Oh man, I love you so much.
For those of you who don't know, Bob can become Hangry Bob.
Oh yeah.
So Grin for Me, started the hashtag. Gotta feed Bob.
Grin fucking knows, man.
Yeah.
Like, this ain't no joke.
Hey.
Gotta feed the beast.
It's
Ariel.
Hey,
Remember, for
Ariel.
26 months.
Oh my, I was gonna say
Listen.
where's her necklace, but then I remembered I only see it, and I saw it when I was in the car.
Yeah.
Grin for Me posted about like who needs pizza. I was like, I see the necklace. So hopefully you have your necklace. Please, sir, may I have some more Garcia episodes?
Yes, Brooklyn. You were not here for
Yes, Heavy, it's Israel is his answer. She asked,
you were
please, sir, may I have some more Garcia episodes?
Yeah. No, I mean, I just dropped one. Like at
Well,
the beginning of the week.
It's next week.
Oh well. You want me to go back to every 3 months?
No.
Calm
No
down.
one wants that.
Relax.
But we appreciate that you love the Garcia.
We do. I'm working hard to finish it. We're obviously a trial. I've gotten much better. I'm not going to apologize for it anymore. Like once every 2 weeks is pretty good because I got a lot of other shit going on. So, but Brooklyn, to belabor your point, I do want to remind you guys at the midway point, I told you guys we really need to give love to the mods. Buy them a slice. It means so much to Allie and I. And in Brooklyn, I don't think you were in here yet, but I want to restate what I said in the middle. Give them some love. They deserve it. They are the backbone. They make our
thingy for them.
They will.
Quick.
They will. Throw the link up there again, y'all.
So, but I think she might be talking about what's gonna be it's gonna be a long night, like our 12-hour live.
Oh, yeah, maybe.
So also
that's gonna be hellish.
That'll be the only thing that we push other than the
we got the best the best mods in the game.
Yeah.
There's no question.
We have the best chat too.
We do. We have the best chat in the land.
I mean, I know. I think all like creators try to say that about their chat, but
dude,
really is the best.
I've been in chats,
and those other chats are definitely not the best.
They are not this.
Not the best.
Like, and I'm talking about I'll hang in like other law tubers shit and not like really say anything, just kind of sitting there. And it depends on what law tuber it is and kind of like what they cover and shit like that. But man, we just got the best. Like we got the funniest and smartest. And there's there's overlapping, obviously. But like as a whole, as a conglomerate, as a full community, we're the fucking best.
We're the
Oh,
best.
there it is. All right. So give the love. Yes, tonight, every day, and especially on Saturday, because that's going to be a long one. That's going to be a long one.
Yes. And classic overthinker, because we were having all that baby talk earlier, says, I'm here for the baby talk.
Oh, yeah. The baby talks. I love it.
And then I think I just want to make sure.
That's really my breakthrough with my granddaughter, because apparently I'm not doing the dancing, because she's not calling asking for fun pa. She's calling asking for mum, which I wouldn't have it any other way.
I mean, it makes me really happy.
It makes her very happy.
Ash and Sugar member for 3 months. You might have read this one already. Better late than never. I guess I'm on the replay crew. I think now we have read them all.
All right, mods, we love you. We love all of you for hanging with us for 540. Make sure you like, share, subscribe. If you're a replay crew, leave a comment. If you can, hype it. Let's go. Let's get it out to the peoples. Let's get it out to the peoples. I'll probably be doing Studi Part 2 at some point this week. Allie and I will decide whether or not we want to do the Becky Hill Murdaugh thing. They are intertwined. And I'm anxious to see how much they quoted this particular opinion we just read today.
I'm going to say based on we'll see how this video does, but based on the number of people that showed up for it.
Well, I mean, to be frank, God, that death hack of yours, quit vaping. Like, I'm done with it being the basement. It's like, it's that vape that you keep vaping.
It's the basement. It's
the fucking vape, bro. You've been doing it for too long. Like I sent you that video.
I didn't watch it.
Well, you should. It's like crystallizing your shit.
Well, Hedgehogs in Space says, dude, that lawsuit is bonkers.
Bonkers.
So.
Oh, and Tracy sent us some shit. I saw this. Some douchebag creator got sued and just got nipped with 17.5 million. I remember that case. It's the Ryan Church, some creator who apparently is a racist, was like in the Keely Rodini case. And she was a girl that had gone to a party. I can't remember if it was after their graduation or some shit. And she kind of like vanished off the face of the earth. And apparently this fucking guy, like on this YouTuber was like absolutely like blaming the family, like saying that they had done it and they were like fucking like, it was some horrible shit.
I wonder if that's one of the ones Cam told me about. I don't know. Our 19-year-old. And Tracy says, babe.
Yo.
Because I was complaining about the numbers.
Yeah.
See what she wrote?
No. Half left because the time kid. Yeah. I mean, nice job.
Well, so that was my fault.
That was definitely your fucking fault.
Yes, I'm saying that it did. Hello. I literally just said that.
Okay. That was definitely your fault.
So
she changed it like 5 times.
I can't
because I'm like, well, I mean, you're sitting there still working and it's 3 minutes to live. You're gonna have to move it again.
And then all the stupid stop and discuss. It was sometimes I just get on a little thing like that. I think this is gonna be great. And then I'm like, yeah, just skip the skippage. So I was trying to make it like a structure. I don't know.
I mean, you can say anything you want. You just might get your dick suit off. You know, the difference between like that and like say, for instance, us discussing the possibility that the House defendants did something to John O'Keefe is completely different because that was a public filing in an active case. That's a different thing than going on to a live and just blaming the family and accusing them of murdering their daughter to make a profit. That's a whole different beast. And I'm sure that the antis that are always creeping around and they love to post these things. Oh, see, they're coming for you. Yeah, sure.
So I thought, Miss Mrs. Olga Z says, send a link for membership for iPad, please. And I know we've had this issue come up, and I think you know the solution, right? Of how
I do
you
not. What does
Oh.
that mean?
Like, she doesn't know. She's not seeing how to become a member on her iPad.
Mods? Anybody?
Yeah, mods, you guys have the answer. See, you got everybody worked up
See,
with
Apple
your.
sometimes doesn't play nice. Wait, what did I get people worked up?
With your get your suit off. Now everyone's making
What?
penis comments.
Wait, eggplants?
No, just like, you know, you just got you got the chat worked up.
Oh, I got them all worked up.
You know, I've been known to do that.
He's been known to do that.
Known to do that. It says, oh, wait, Tracy gave some shit. She's right. That's the easiest way. Go to youtube.com. And then
Even on your iPad, yeah.
yeah,
Set it through the app.
it's just like trying to do it through the Apple app is just, it's hit or miss. It's hit or miss. So the best thing to go is to www.youtube.com/Defense Diaries podcast. And
Trial
it'll bring you to the chat. It'll bring you to the channel.
and Trial World TV says this guy did the Alex Jones calling it a hoax.
Who? Which guy?
I'm assuming the 17 million, or is that something different? He might have been commenting on something different. Is
I
that
don't know. Well, that's the guy that's repping the House defendants.
Oh, maybe that's yeah, okay.
I mean, I don't know. Like, but the Alex Jones thing, a trained fucking monkey could have, I mean, Alex Jones, like, literally was saying that they were paying actors and that the shooting, a school shooting, didn't take. It was the stupidest.
Oh yeah, that
fucking
was
thing.
the one that Cameron told me about. and
That
you
was
told
the
me about.
stupidest fucking thing I've ever heard. I'm like, huh? I'm like talking about a fucking tinfoil psychopathic bullshit thing. I agree. We should always go back to talking about my balls. All right, we got to go. It's been long enough. I'm punch drunk. I'm talking out of both sides of my mouth, and I love you guys because without you, I'd just be an old man.
Sitting around talking to his wife.
Boop. We love you, mods.